Attention, commissioners. Do we have most commissioners here? Everybody here? Except those who will attend virtually. There seems to be too many empty spaces that side. Okay, no, I think it's, yeah, they're filling up. Good morning, everybody. Good morning, commissioners.
Good morning, Chief Justice.
Thank you. We are going to start. We are about 8 minutes, we're running late by 8 minutes, but we should be fine. I know that our media spokespersons will at some stage today talk to the media, but I do think that it would be appropriate for me to say something at the beginning. So I will have a few remarks to make as we begin. So I thought I would just mention that. Otherwise, are we ready? Let me check. Commissioners who are attending virtually, are you there?
Good morning, Chief Justice. Yes, we are.
Good morning. Good morning, Commissioner Breitenbach.
Morning, Chief Justice.
Good morning, Commissioner Malema.
Good morning, Chief Justice.
Good morning, Commissioner Barnard. Thank you.
Good morning, Chief Justice.
Yes, good morning. Thank you for being able to join us today. Thank you.
Thank you, CJ.
Thank you. Unless there is somebody who wishes to raise anything before we call the first candidate, I think from my side I'm ready that we may call the first candidate. I don't think anybody has anything that they wish to raise before. So I think, Secretariat, you can bring in the first candidate. Good morning, Mr. Dodson.
Good morning, Chief Justice.
How are you this morning?
I'm well, thank you, and how are you?
Thank you very much. I'm well, and I think the commissioners are also well.
Thank you.
Welcome to this session of interviews, but I just want to take this opportunity to thank you for once again availing yourself for consideration for appointment to the Constitutional Court.
You're welcome, Chief Justice.
At least I know of 2 previous occasions when you have made yourself available. I don't know if there may be more, but I know of 2.
Just one more in 1995 when I was appointed to the Land Claims Court.
Yes, okay, all right. Good, thank you. Before we start, I just want to make a few remarks for the benefit of the public. The media spokespersons of the Commission will speak to the media at some stage today, I believe. But I do want to say the Commission had very fruitful and constructive discussion yesterday on its mandate and on various matters connected with its mandate. The spirit was very good, it was very constructive. I certainly benefited immensely from the discussions that we all had. And part of what we discussed was the selection criteria that had been decided by this commission in 2010, and we reaffirmed that they continue to apply. And there was also complete acceptance by everybody without exception that we appreciate it when practitioners and judges make themselves available when there are vacancies that should be filled in our various courts. There was complete acceptance by all commissioners without exception that at all times we intend treating all candidates with respect and courtesy and with due regard to their human dignity, and that we seek to simply try and establish what we need to establish in order to perform our functions in terms of advising the president as to who to appoint in those cases where we are required to advise the president. And that's what we do. There was acceptance that, of course, that we treat all candidates with respect and courtesy. Doesn't mean that there will not be robust discussions and questioning. It doesn't mean that candidates will not be asked difficult questions. They will be asked, but everybody must understand that all that is being done is just to try and make sure that we do our job properly. But the spirit of the discussion was very good, and I thought that it is important that the country should hear that. Thank you very much. Mr. Dodson, speaking for myself, I do not intend to ask you too many questions because I was part of this commission when you appeared before this commission in October. I will ask certain questions just to refresh everyone's memory. It may well be that there are other commissioners who might adopt the same attitude and only ask certain questions. So if you find that maybe you are not asked too many questions or by too many commissioners, that might be the reason. But also it may be that commissioners will feel that they want to ask you a lot of questions. So, but I thought that I must just mention that because we do have all the papers that have got information about you, your performance as a lawyer, as a judge, and we do have even the transcript of your interview in October. So all of that is before us. So I thought I would just mention that.
Thank you. I've noted that, Chief Justice.
Yes. Now, you have a BCom degree from the University of KwaZulu-Natal, which you got in 1982, is that right?
Correct, Chief Justice.
And you have an LLB degree, which you obtained cum laude in 1984 from the same university. Correct,
Chief Justice.
And you subsequently obtained an LLM degree from the University of Cambridge in 1988. Is that right?
Correct, Chief Justice.
And in 1992, you obtained a postgraduate diploma in tax law from the University of Cape Town.
That's correct.
You were admitted as an attorney in 1987, and you were appointed as a judge of the Land Claims Court when that court was started. Is that correct?
Correct, in 1995, Chief Justice.
Yes. And that was a term of 5 years. Is that correct?
Indeed, a fixed term of 5 years.
Yes, which you completed.
Yes.
And thereafter, you went back to practice and you got admitted as an advocate.
Yes, it coincided with the time I was also appointed by the United Nations to chair the Housing and Property Claims Commission to deal with property claims in Kosovo.
Yes.
And when I wasn't working in Kosovo, I was busy with my practice back in South Africa.
Yes. And then from 2001, you practiced as an advocate, and 10 years later, 2011, you obtained silk. Is that right?
That's correct, Chief Justice.
Yes. And you have practiced all these years, and that makes it about, what, 21, 22 years?
Somewhere around there.
Yeah. Okay.
As
all right.
advocate.
And during the time when you were a judge in the Land Claims Court, you gave many judgments which have been reported, and we dealt with that in October. They are all here, is that correct?
That's correct, Chief Justice.
Yes. And they are,
There is a list of the reported ones.
yes, yeah, there is a list of reported ones. You have also got a list of reported judgments where you appeared as counsel, is that correct?
Indeed.
Yes.
And as an acting judge in other courts.
As well as an acting judge in other courts. And the reported judgments in which you have appeared include judgments where you appeared in the Constitutional Court. Is that right?
Indeed. Where I appeared, yes.
Yes, yes, yes. You have a practice that involves constitutional law, administrative law, land matters, and you have got other branches of law. Do you want to tell us about those as well?
Yes, thank you. I am also involved to some degree in labor law from time to time.
Yes.
I have a limited commercial practice, but I do commercial matters on an ongoing basis.
Yes.
I am very substantially involved in the field of medical negligence claims, where I have been trying to develop the common law in a way that will assist I mostly act for the Eastern Cape Department of Health, will assist them in dealing with some of the financial crises that they've been facing by pushing for and seeking the courts to develop the common law in order to change the once and for all rule and develop a new approach to the law of damages.
Well, what I didn't mention earlier on, I must just mention, is something that I did mention in October when you appeared before us, that you have done some work for the commission that I chair at my request.
Indeed, Chief Justice.
Yes. Okay. Of course, last time it did emerge that you have not had a chance to act in the Constitutional Court, but everybody accepts that that's not a bar to appointment.
Yes, Chief Justice.
Yes. Okay, all right. Thank you. You have got no questions? Okay. Thank you. Judge President Lekhodi will put some questions to you. I just emphasize to you that by and large, when commissioners ask questions, they will be having due regard to the selection criteria that I talked about earlier on, which were approved by this commission in 2010, to see how you fit in within those criteria. Thank you.
Thank you, Chief Justice. Now I'm familiar with the criteria.
Yes, okay.
Good morning, sir.
Good morning, Judge President.
Let us go straight to one of those criteria. And it is put as follows. Is the candidate experienced in regard to the values and needs of the community? Are you that kind of a candidate? And before you respond to what I'm saying, I'm coming from a place in a village called Ramaja Mutungwabobe. And my experience in regard to the needs of the community may not be necessarily the same as yours. Now, if you are that kind of a candidate, what kind of the needs of the community are you talking about?
Well, my understanding of the criterion would be to ascertain whether the candidate is a person who has a history of involvement in understanding perhaps all the communities that make up the South African population, but I think it also brings with it a focus on disadvantaged communities and an awareness of how the law can and also very often cannot work for such communities. And I think, as I understand your question, what you would require from me is to indicate where I might fit into that analysis.
Yes.
And in response, I would say that throughout my career, from the moment in fact, before I even got into legal practice, I was very much involved in the legal aid clinic at university. I have focused on trying to make the law an instrument that isn't just there to regulate society, but is also there to come to the assistance where appropriate of particularly rural communities, but also urban poor communities. And I think that was manifested by the human rights work that I did as an attorney. There was quite a strong focus at that time on responding to the brutality of the apartheid regime. We were involved, I was an attorney in Cape Town, involved extensively in resisting forced removal of communities, poor communities, and particularly African communities in the Western Cape. I was involved extensively in representing clients from Crossroads, Nyanga, Langa, who were the victims of severe police brutality, particularly during the second half of the 1980s. And it was in fact that resulted in my being nominated as a candidate for the Land Claims Court. My work in the Land Claims Court was very much focused on addressing the pain inflicted on rural communities in particular, but also urban communities by the phenomenon of forced removals.
I think it's enough for now. Other members of the commission, if they want to they will make follow-up questions. It's not necessary to give that because we are constrained with time. Thanks, Chair.
Thank you, Judge President. Let me just mention for the benefit of the public and the media that the selection criteria that I referred to earlier on are on the website of the Commission already, for those who might wish to consult them. Thank you. Minister.
Yeah, thank you very much, CJ and Advocate. In the last interview, I engaged you on the Mwela's judgment, so I won't go there. I want to hear your view on this one, that you're involved in the land access movement of South Africa and others versus the chairperson of the National Council of Provinces. Why do you think it's important that before we could, or before we can have an act of parliament that can amend, or an amendment to the Land Restitution Act, to reopen the land claims, to first finalize the existing claims.
The motivation there was that there have been terrible delays in dealing with those people who lodged claims by the 31st of December 1998. The impact of the Amendment Act was to create serious problems for the adjudication of those claims and in effect to bring them to a complete halt. In respect of every land claim, you have to check whether there is a competing claim in respect of the same land. So the progress in administering and processing all of those pre-1998 claims suddenly had to stop in order to try and find out whether there were now new claims being lodged. In fact, there might even have been arguments to say that one had to wait for the full period of the new claims lodging before you could deal with those claims. So it created a problem of very, very serious further delay on top of delays of already up to 20 years in the processing of land claims. Also bear in mind that land claimants are mostly elderly people because of the timing of forced removals, and a lot of them were passing away before they ever saw justice. It remains a serious problem. That problem was going to be very seriously aggravated, and hence the need to seek a remedy, which we secured from the Constitutional Court, to say, hit the pause button as far as the new claims are concerned, and let's process those old claims so that they aren't seriously affected. Once those are complete, the new claims are then addressed. And it was left open to Parliament, notwithstanding the declaration of the law as unconstitutional, to continue the reopening of the process. But even those claims lodged under the Act that was struck down are recognized by the Constitutional Court order, so there is no prejudice to them.
No, thank you, CJ.
Thank you, Minister. Commissioner Mapisangakula.
Thank you very much, CJ. Good morning.
Good morning, Commissioner.
Morning. There is a matter which concerns me when I read your CV and when I read some of the objections which have been raised. And I just want you to help us just clarify this matter, where one of the groups says they've criticized your judgments and philosophy because they feel they are not according with the values and principles of our Constitution. Now, this is just a bold statement which has been made, but no examples have been given to us as to how. Could you perhaps just provide clarity why anyone would make that kind of statement?
The statement is a mystery to me, and I think it's very, very unfair. No information was given. I have never, ever heard of any criticism of that sort ever having been directed at any of my judgments. Unfortunately, I only focused on it this last weekend. I immediately addressed an email to the Commission. I said to them, please give me information about what is behind this criticism. And the Commission said they weren't in a position to take the matter. The Secretariat of the Commission said they weren't in a position to take the matter up with NADEL. What's also strange is that it comes right at the end of a generally positive description of the work that I've done. I simply know of no such criticism, and with respect, it's very unfair. It's very unfair to put a comment like that without any substantiation whatsoever, and I can offer no explanation. I do not know of any such criticism. It's taken me completely by surprise.
Thank you very much. Thank you. Thank you, Judge President.
Thank you, Commissioner. Commissioner Makwanisha.
Thank you very much, CJ. Good morning, Advocate Dodson.
Good morning, Commissioner.
I only have one question. Is there anything that you would want to bring to our attention which could favorably advance your cause, which has happened between the last time we interviewed you and today?
I think that Perhaps the only significant thing I could mention is that it didn't happen during that time, but I didn't update my curriculum vitae, and I did act in the High Court during August. So it preceded the previous interview, but I didn't update my CV, so it isn't known there. But in the interim, I've continued my practice as an advocate as I did before, and in the manner that I did before.
Thank you, Advocate Dodson. Thank you, CJ.
Thank you, Commissioner. Commissioner Moimang.
Thank you, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Just one question also from my side. Does the Constitution stand in the way of radical land reform, in particular the legally insecure forms of tenure for millions of people living in communal land in the former Bantu stance to address rural prosperity? Thank you, Chief Justice.
With respect, the opposite. Section 25 specifically addresses the problem of insecure tenure, specifically brought about by apartheid, and calls upon effectively the state to address that and to pass legislation to address that. Legislation specifically in relation to security of tenure has passed. In relation to the so-called former homelands, there was the Communal Land Rights Act. Unfortunately, that act was very poorly conceived. It wasn't correctly passed through Parliament. It tended to favor traditional leaders at the expense of rural communities, and it was the subject matter of an application that I was involved in bringing on behalf of communities to have that law set aside. Where there is a serious gap is that no act has been brought to replace the act that was declared to be constitutionally invalid. And there's a desperate need for that, because if there can be greater security of tenure, if there can be greater clarification and registration of people's land rights in the former homelands, it creates all sorts of potential for advancing development and prosperity. So there's an urgent need there, and I worry about the fact that I'm not reading anything about that happening. So the shortfall is in the statutory regime. It isn't a shortfall in the Constitution, in my view.
Thank you, Advocate Dodson. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, CJ. Morning, Advocate Dodson.
Morning, Commissioner.
It's linked to the question raised by Honorable Makwanish, but it's asked differently. Of course, you have had some time to reflect about the last interview, as CJ has indicated that you have been interviewed twice. Probably something that you'll look back that was said then when you were being interviewed that you think you might not have done justice in clarifying the commission, that you might want to do a reflection and make us to seriously consider that particular specific issue?
I believe I had a fair hearing at the previous interview. I was asked some tough questions, but I didn't mind being asked the tough questions, and I answered the tough questions. Perhaps the only thing that I could add is in relation to the provision in the Constitution that requires demographic representation to be considered in, I think it's, I'm forgetting the number now, it's subsection 2 of the 171.2, I think it is. Just to make the obvious point that I don't think that my appointment at this point in time, given the demographic makeup of the Constitutional Court, would be a negative factor, because of the fact that frankly there are currently no white members serving on the Commission. So the question I was asked about being a white male, I don't think my appointment at this point in time, given the Constitution of the Court, would operate as a negative consideration against me. If anything, it could, I would respectfully suggest, operate as a positive one.
Thanks. My last question Section 167, subsection 2 of the Constitution, where it said a matter before the Constitutional Court must be heard by at least 8 judges. What's your view about this clause in the Constitution in relation to Constitutional Court?
Well, it's unfortunate that sometimes the court is made up of only 8 members. And in fact, I was in the Labour Appeal Court a few days ago, in which we were dealing with what's known as the hen door judgment, which the Chief Justice will be familiar with, where the court split 4-4. And when that happens, it creates real difficulty for those who are subsequently required, subsequently required to implement the legislation and apply it to other cases. And in fact, a problem has developed in labour law, which is particularly harsh on workers who achieve reinstatement after an unfair dismissal through legal proceedings, in that it's really difficult for them now to claim back pay. So if you have a case that drags on through the Labour Appeal Court and perhaps goes to the Constitutional Court, they get an order of reinstatement, and they then have to, several years down, enforce the order of reinstatement. There's a real difficulty with getting back pay beyond the date of the original award of a CCMA commissioner. And some guidance was provided by the Hendor decision, but it was complicated by the fact that you, as you point out, it was an 8-person bench with an equal split. So perhaps one day when the Constitution is being tinkered with in the future, they could look at changing the provision of 8. I think you've made a very good point there.
Thank you, Advocate Dotsinetsi. Thank you, CJ.
Thank you, Commissioner. Mr. Dodson, I may have missed something about the connection between that provision of the Constitution that allows the Constitutional Court to deal with a matter on the basis of a panel of 8. The connection between that and the Labour Court and reinstatement. I just want you to clarify that for me. I want to understand what you were saying.
So all I'm saying is that there's this difficult area of law that has developed in relation to how do you deal with the question of back pay. And the answer is to some extent provided by the Hendor judgment, but it's complicated by the fact that there were 2 judgments there and an even split. 4 of the judges supporting your judgment and 4 of the judges supporting, I think it was the judgment of Justice Matlanga. And it simply makes it a bit more difficult to understand the implications of the Hendor judgment in applying it to that particular difficult situation.
Okay. No, I think I get the idea that if there was a reinstatement order prior to the matter coming to the Constitutional Court, and then when the matter comes to the Constitutional Court, 8 judges sit in the matter, and they are split 4-4. That's where the problem arises in the context of a back pay. That's what you are saying.
Yes, it's simply a matter of the
because there is no judgment.
Well, in that particular case, it was concerned. Hendor was concerned more with the question of prescription and how prescription impacted.
Yes.
But the statements that were made there were also relevant to this vexed question of what do you do about the period between when a commissioner granted reinstatement and the matter is finally decided in their favour by the Constitutional Court. And there are all those years that have passed.
Oh, yes.
And what was said in relation to prescription in Hendor does impact on how you answer that question as to how you deal with the question of back pay. And it's become very difficult for workers. Effectively, they've got to bring fresh legal proceedings to be able to recover the back pay.
No, thank you. Commissioner Play.
Thank you, Chief Justice. Mr. Dodson, with the new expanded jurisdiction of the Constitutional Court.
Let me just say before you continue, Commissioner Play, Mr. Dodson, there are commissioners who were not there in October when we interviewed you, so they might feel that they need to know you more. So I just mentioned that.
Thank you, Chief
Thank
Justice.
you.
Mr. Dodson, with the new expanded jurisdiction of the Constitutional Court, where the court considers not only constitutional matters, but also matters which raise arguable points of law of general public importance, we do see a greater influx of commercial cases coming through to the Constitutional Court, and undoubtedly the court will be called upon more and more to consider commercial principles against the values.
I'm sorry, Commissioner Pillay, I wonder whether you might pull your mic closer to
I'm sorry,
you.
I'm sorry, Chief Justice.
Yes, or speak up a bit, yeah.
Can I pick up where I left off, or do you want me to?
No, you can pick up where you left off.
So the Constitutional Court will be called upon more and more, Mr. Dodson, to consider commercial principles against the usual kind of constitutional process of interpretation. Now, against that backdrop, looking at your application, I noticed that in relation to your 10 significant cases that you list, none of them are commercial cases. In fact, your application states candidly that you do limited commercial work. Now, if I can ask you, how do we assess that aspect of your application against other candidates who will be appearing before this body who do have considerably more commercial experience? What's your take on that?
Well, one must be, I think, careful how one describes commercial work. I think the question really, in a strict sense, relates to non-constitutional rather than commercial work. So in the work that I do, certainly poor people often have non-constitutional problems. Because of where I come from, I've acted most of my life for disadvantaged people and poor people, but they run into, for example, delictual claims. The work that I do for the Eastern Cape Department of Health is all about the law of delict and the development of the law of delict. One can consider that is certainly in the realm of non-constitutional work. But I do commercial matters. I was involved in a matter an appeal a couple of days ago in a full bench in Gauteng involving the question of ostensible authority and authority by estoppel. I've in fact done the analysis. I've worked through my judgments in the Land Claims Court, and I can make that available where non-constitutional issues have come up. In addition, if one looks, and I think the point is made by the Bar Council in their review, if one looks at all of my judgments as an acting judge, not just the reported judgments, I've dealt extensively with commercial matters as far as that is concerned. The other area where I've had very substantial and complex commercial experience is that for a period of about 20 years I've been involved initially as vice chair and for about 10 years until 2020 with the disciplinary committee of the Independent Regulatory Board for Auditors. That brought before me complex commercial matters, complex auditing matters. One of the biggest matters that I was involved there involved the auditors who were the auditors at the time of the African bank collapse. Bank auditing is known to be one of the most complex areas of commercial law that there is, and the reference to the decision that I wrote is in my curriculum vitae. There's a link to it, and that has given me very substantial exposure to commercial law. So I think I would certainly be in a position to deal with that. One must also remember that there's been a unification, particularly a result of the Natal Municipal Pension Fund judgment of Justice Wallace, around how one approaches interpretation in law, and a recognition that it's the same whether one's dealing with the Constitution, a statute, a regulation, a contract, a document in a case. And often litigation and adjudication comes back to how do you interpret the particular instrument that is in front of you, wherever it may come from.
Thank you, Chief Justice.
Thank you. Commissioner Lucas.
Thank you very much, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Welcome once again.
Thank you very much.
I think we are beginning to feel like family now.
Happy to be part of the family.
Thank you very much. I was just thinking when I read through all what was written about you or what you have written about yourself, do you believe that there is a room for activism in the judiciary? As a judicial officer, will you say that there can exist a term like judicial activism? That is my question.
certainly there can be a term, yes, but I think that the term has become, with respect, redundant as far as adjudication is concerned. It's well recognized that we have a transformative constitution that aims to achieve not formal but substantive equality in South Africa. It is a bold constitution as manifested by the specific provision in Section 9.2 for affirmative action measures, the specific provision in Section 9.4 for legislation that makes discrimination outlawed not just at the level of state but at the level of citizen and between citizens. Related to that, Sections 8.2 and 8.3, and then, of course, the provision for socioeconomic rights in the Constitution. So what I would rather say is that we have an activist constitution, and once you have an activist constitution, as long as the judge comes to the case with the recognition of the fact that it's a transformative constitution, and an open heart as far as that is concerned, I don't think you need to be a judicial activist in order to do justice. It's also important to remember that law is there both as an instrument for the consistent regulation of society, but also to achieve justice. The beauty of the Constitution is that it allows you to meet both of those ends. Sometimes it's a little bit difficult and one sees it wrestled with. An example was this very recent Diamond's decision that came out of the Constitutional Court, where you had the minority judge clearly seeing a particular outcome as being appropriate for a disabled person who'd been injured at work. The majority, however, saw it as a case where the law was clear and it didn't allow the grant of the remedy that that particular worker was striving for. So, short answer, we have an activist constitution. You don't need to be an activist judge.
Let me not ask the follow-up, since we agreed on time issues.
Thank you. I'm going to go to the commissioners who are attending virtually before I proceed to the remaining commissioners who have indicated their wish to ask questions. Commissioners who are attending virtually, is there any one of you who wishes to put questions to the candidate?
Commissioner Malema.
Yes, Commissioner Malema, please go ahead.
Thank you very much, CJ, and good morning, SC.
Good morning, Commissioner.
I just have one question. I think you tried to explain it when the other commissioner asked you about the things that you could have done differently or said differently in the previous interview. So I think you tried to deal with it, but let me put it differently so that we are clear when you leave here. Do you think your appointment to the Constitutional Court advances any transformational agenda?
Yes, I do. And the reason I say that is that I accept and adopt and have always accepted and adopted the transformational ethos of the Constitution. And if you have a judge who accepts and adopts the ethos of a transformational approach to constitutionalism, it's going to be reflected in the judgments that they hand down.
I specifically ask about issues of gender and race. So if we appoint you to the Constitutional Court, which of those two are we achieving through your appointment?
Well, if one follows on from what I've already said, I come from a background from my earliest times as a lawyer of finding racial discrimination and gender discrimination an abomination. And the work that I do in the Constitutional Court, were I to be appointed, would reflect that and would contribute to addressing racial discrimination where it continues to exist and gender discrimination where it continues to exist. In terms of the numerical answer, and I don't think transformation is only about numbers, Of course, there's nothing about the fact that that I'm white and I'm male. I explained my position at the previous interview. I don't want to cover that ground again. I am an African.
Are you done, Commissioner Malema?
Thank you, CJ.
Thank you. Any other commissioner attending virtually who wishes to put questions to the candidate?
Please, Chief Justice, it's Glynis Breitenbach.
Yes, Commissioner Breitenbach, go ahead.
Thank you. Thank you, Chief Justice. Forgive me, I'll keep my camera off because it's raining here and worried about signal.
Okay, all
Good
right.
morning, Mr. Dodson.
Okay.
Morning, Mr. Dodson.
Good morning, Commissioner.
My question is a simple one. What, in your view, are the factors that a judge should consider when deciding whether or not he is conflicted? And what would be the factors you would consider in recusing yourself from a matter?
Well, the law has been laid down very clearly, and there's in fact a recent judgment, I think it's of Justice Kampepe, where she dealt with a recusal application in respect of Chief Justice Mogoeng, and it lays down the principles there very clearly. From a personal point of view, obviously I would have to recuse myself if I had a personal interest in a case, or could somehow be said to have a personal interest in a case. I would also have to consider recusing myself if I had made some sort of a statement that suggested that I had a particular view about a matter which favoured one of the sides to the dispute. And then there are more concrete examples. So, for example, if I were to be appointed to the Constitutional Court and one of my cases that I'd been an advocate in came before the court, obviously I'd have to recuse myself in that matter. The interesting thing and the important thing that comes out of Justice Kampepe's judgment, though, is that it's also wrong to recuse oneself too quickly. There is a presumption of judicial impartiality. We're trained as lawyers and as judges to be impartial. It's recognized that every human being has their own particular predilections, and one can't simply abandon those when one comes to the bench. But one uses one's discipline as a lawyer in order to put those to one side. It's only when they reach a particular level of interest or association with one of the parties that there's a need to recuse oneself.
Thank you very much. Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Barnard, do you have any questions or not?
Nothing from me, Chief Justice. Thank you.
Nothing from you. Commissioner Shabangu Mdawe, do you have any questions?
Nothing from me.
Thank you very much.
CJ, sorry.
Thank you, Commissioner Singh.
Thank you very much, Chief Justice, and good morning, Advocate Dodson.
Good morning, Commissioner.
I'm here to your right. I think you're looking at the screen now.
I thought you were also being beamed in from somewhere else.
No.
Good morning, Commissioner.
Thank you very much. I had two questions, but I'm going to make it one because my other colleagues have asked the question. During our previous interviews, some of the concerns we had, some of the commissioners had, was your limited acting experience. And in mitigation thereof, you cited your sitting at Kosovo, the United Nations, and your URBA disciplinary board. Now, for the new commissioners and also for myself, again, just to understand this, how do you align that kind of experience with the experience sitting in a court here in South Africa? Because you used it as experience that you had gained. Thank you.
Sorry, just to complete your list, obviously there's the 5 years on the Land Claims Court as a...
Yes.
But are you asking specifically, how does my time in Kosovo relate to sitting in a court here?
Yes, and the URBA board. Yeah. Thank you.
Well, I'll start with the URBA court. The URBA court and Commissioner Kane will bear me out on this because she sat as a deputy chair with me on that. It's effectively running a trial. Cases come to you in the form of trials. There are lawyers on his legal team generally on both sides, and they're run as a trial. Evidence is presented by the board and then by the defendant. It's run according to the rules of a trial. And the decisions that we wrote were effectively judgments, although they were called decisions. They reasoned fully in that way. And there's an example which I've attached to one of the decisions to my documentation. So that certainly, with respect, counts. And as I've said, some of those matters were really complex. In Kosovo, again, it was adjudication. It was taking facts. It was applying the law to the facts, and in that process, then coming up with a written decision. But it also gave me exposure to a different legal system. Comparative law, I think, and comparative experience, I think, enhances one's experience as a lawyer. It gives one other ideas that one can bring to bear in the adjudication. It exposed me to international law in operation. International law issues come before the Constitutional Court, and there's frequent reliance on international law. It's required effectively to have regard to it in the Constitution. And the Kosovo experience would give me experience in applying international law. The other component of it is that because I was the chair of that commission, I had to effectively be very much involved in setting up and administering that adjudicative body. So it gave me experience in the practical side of adjudication, in making a court work or making a tribunal work.
Thank you, Chief Justice. Thank you. Thank you.
Thank you, Commissioner Baloyi.
Thank you, Chief Justice. Good morning, Mr. Dodson.
Good morning, Commissioner.
If I may start by making disclosures, I am with you. You're a member of the same group of advocates as I am.
Indeed.
Yes. And a second disclosure, it is that I nominated you. It must have been the first appearance that you had here for the interviews.
Indeed, it was the first one, Commissioner.
Yes. Now, if I may then get to it, in your cases that you have listed, and the ones that you've identified as amongst the important cases, you've referred to the case of Chief Nchabeling and versus Chief Pasha. And this has to do with the requirements for an interim interdict. Now, you say about it that that case, and you sat there with BMJ, and you say that judgment, or rather what you did there, is to introduce I think you refer to it as a flexible approach to interim interdicts in the Land Claims Court. Now, there's two questions to it. Firstly, it is, what is the philosophy, to the extent that you say flexible, the flexibility in the requirements as it pertains to the Land Claims Court or matters before the Land Claims Court, what would be the philosophy behind flexibility in the Land Claims Court? That's the first question. Related question to that is, how is it that the two factors that you've identified and that you say you take from the Siamite case, the English case, the question of a triable issue, one, and the second one you say, I think it goes to balance of convenience, at least that's what I take of it. Why do those not fit into our common law requirements as they've been established in the normal course? One, which is prospects of success. I would have thought that the question of a tribal issue would fall ordinarily under for consideration under prospects of success. And then the second question, which in this case you determined, was that the applicant would not suffer any prejudice if you granted the respondent wouldn't suffer any prejudice. Why that doesn't fall easily within balance of convenience?
So on the flexibility issue, what it does, and in a sense it also answers the second question, is that it creates, I think, less of a burden on a party who's coming to court for interim relief to have to demonstrate a prima facie right. And it switches the focus more to trying to regulate what the status quo is. So, as I recall in that particular case, I think there was a problem with one chief settling people on land that was claimed by another community, and it was going to really complicate the land claim by having people newly settled on land that was meant to be subject to adjudication by the Land Claims Court. But the claimant had a relatively weak case. But it was certainly a case that was arguable, and viewed from the perspective of what was best for having a fair hearing ultimately on the issue, it was better that that process of invading the land effectively was stopped so that there could be fair consideration when the matter came before court. So that's why I talk about flexibility. It's a bit less of a focus on the prima facie right and more focus on trying to look at preserving the status quo to ensure a fair adjudication at the later stage. As I understand your question, your second question, it relates to, well, where does that not fit into the current common law? I think that's a very fair question. There are some judgments which are almost indistinguishable from that analysis, and I think I acknowledge it in the judgment. And in particular, it's two judgments of Judge Holmes, later Chief Justice Holmes. The one is Ericsson Motors, and the other is Olympic Passengers. And I, in fact, use those cases to argue that you could apply a similar flexibility. And effectively, what he says is it's a spectrum issue. You weigh, if a person has strong prospects of success, then balance of convenience means less or will have less significance, or the other way around. If you've got weak prospects of success, does the balance of convenience particularly favor a person? And I think your observation is fair. At the end of the day, there's not that much difference between the two.
CJ, I do have a second but unrelated question. I don't know if I should ask it now or give other commissioners.
Okay, you can ask it.
Yes. The last time when you appeared, and I see this from the transcript, one of the issues that were raised is the fact that you seek to be appointed from the bar to the Constitutional Court, and that was debated with you. And in the way that you answered, and I raise this so that I can understand your answer, in the way that you responded, it's capable of being understood, and I don't know if that's what you intended, to be, your answer to be, well, I served on the Land Claims Court, which is a court of similar standing as the High Court. It would be a step back. In fact, you use those words. It would be to take steps back to go to the High Court. And I think if one speaks without too much care, it sounds like you were saying it would be a demotion. Now,
sorry, I didn't hear that word. It would be
a demotion if you went. I mean, and I'm saying, if one speaks without too much care in choice of words, that it sounds like you would be suggesting that it would have been a demotion. Now, the question is, you obviously have the requirements of a judge. That's why you served in the Land Claims Court, right? And that's why you've put yourself up to be appointed to be considered for the Constitutional Court. The question is, well, isn't it a loss to the lower courts, being the high courts, that you do not avail yourself to serve at that level of court, which is, in my view, and you can tell me if you differ, this is the coalface of litigation, the high courts, and one sees that by the number of matters that end up on appeal. In fact, by far the majority of cases do not go on appeal for whatever reason, so they get finally decided in the high courts. Isn't that a factor that you should take into account in your decision not to avail yourself, if you're not nominated or not appointed to the Constitutional Court? Would that not be a factor that you should consider perhaps to avail yourself for the High Court anyway?
Just to clarify on the demotion, I wouldn't see it as a demotion, but I did say it would be a bit like starting again where I started off in 1995. I accepted that I would be able to perform a valuable service in the High Court. I accept that you might term that a loss if I weren't to go to the High Court, but I have served my time, as it were, for a period of 5 years in the Land Claims Court. I've served my time doing other adjudicative work, and I'm turning 62 shortly, and I have, let's say, about 13 years of working life left. And one looks at that time and one thinks, how best can I use that time? I enjoy my practice. I have a practice as an advocate where I believe I make a very significant contribution towards society, and that's the choice that I've made as far as the remaining 13 years of my life are concerned. I would very much like to serve on the Constitutional Court. I think I can bring my own particular perspective and skills and experience to bear there. This commission and the president must decide whether that is or isn't to be. If it isn't to be, I believe I can make perhaps as strong a contribution as an advocate as I do as a High Court judge. And obviously, as an advocate, I will act on a regular basis in the High Court. I will have no hesitation. And because I'm no longer working for the commission, I've resigned from the Independent Regulatory Board for Auditors, I would happily act on a regular basis, not only in the High Court, but also in the Land Claims Court and the Labour Court, were I not to be appointed to the Constitutional Court.
Thank you, Mr. Dodson. Thank you, CJ.
Thank you, Commissioner. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Advocate Dodson.
Good morning, Commissioner.
Chief Justice, the first question I has been asked by Mr. Singh alongside with the question of Advocate Baloyi. So just a follow-up on the issue that that Mr. Singh raised about the issue that you answered to and your experience either sitting at IRBA or in Kosovo and your time at the Land Claims Court. Could you just add to the issue of experience on appeals? If you could do that for me, Mr. Dodson, I just wanted to ask you, given that as a Constitutional Court judge, a lot of the matters that come there are matters of appeal, what sort of experience do you have dealing with appeals? And then I'll deal with my next question. Thanks.
My experience as an appellate judge has been in those cases where I've sat as a full bench while acting in the High Court. In relation to my experience in Kosovo, we had an adjudicative function in addition to the adjudication of the claims, which was reconsideration requests. And there were several thousand reconsideration requests that were submitted, and those were effectively in the nature of an appeal. And that was my experience as far as that was concerned.
Thank you, Advocate Dodson. The question I wanted to raise with you, you touched on it a bit in the last interview, but I want to ask it from a different perspective, and it comes also from the interviews we had during the Chief Justice process, and which is there are issues of delays in finalizing matters in the Constitutional Court. In your response, you said you do not, to Commissioner Malema, in fact, last time, you said you didn't want to enter into a blame game. What I want to ask you is, what do you think should be done where, as a judge, as a candidate for the position of a Constitutional Court judge, to deal with effective finalization of matters? Because in our view as a commission, effective finalization of matters also help the public to have confidence in the judiciary. So I just wanted to hear your views about what should be happening at the Constitutional Court to ensure that matters are finalized quickly and judgment provided timelessly. Thank you, Advocate Dodson.
I think it's a question of management to avoid those delays. I read an article about the about the targets that were set by the different courts and achievement of them before this interview, not the previous one. And I did notice that the High Court and the Supreme Court of Appeal seemed to be the top achievers. They were achieving above their target percentages. And I also saw there that the Constitutional Court was below its target. They had a target of 70% completion. They were on 61%. And that was to some extent ameliorated by the fact that there'd been an increase in the caseload. But addressing it as a question of management and discussion and report back. And I think it's when I say management, it's a leadership, with respect, it's a leadership issue. And I think the leader of the court has to find a mechanism where people are required to report on a regular basis on their outstanding judgments, where they have reserved judgment, and to provide progress. And if that is done in a manner where there's level of scrutiny from colleagues, I think it can create the necessary incentive to ensure that you don't have unacceptable delays. And I accept that there have been some unacceptable delays.
Chief Justice.
Thank you, Commissioner. Commissioner Nochesi.
Thank you, Chief.
Let me just say before we proceed, I think we have taken about an hour with the candidate. I'm just alerting everybody so we are aware of the time. Thank you. Please go ahead.
Obviously, Chief Justice, my question is only one.
Yeah.
Advocate, it's only one question. It's just a follow-up to Commissioner Breitenbach. What would you regard a situation where a judge sit in the SCA, say over a leave to appeal, dismiss that leave to appeal there, and then goes to the Constitutional Court on the same matter, sit on a leave to appeal in the panel, dismiss that appeal on the same matter? How would you, does that matter? Does that matter fall in the category of recusals?
Yes.
Thank you very much.
Thank you, Commissioner. Nochesi, Commissioner Matolo Sepu.
Thank you, Chief Justice. Good morning, Advocate Dobson.
Good morning, Commissioner.
I just want to hear you on the Council of the General Council of the Bar mentioned in their comments one of your publications.
One of my
publications, maybe it's a contribution to a publication on post-conflict property redistribution, the approach in Kosovo and lessons learned for the future international practice. I just wanted to find out, looking back, I mean, this was done in 2009, and in South Africa it's 2022. What lessons could we have learned from that input that you made in 2009? Or have you learned anything in South Africa so that we fast track our property and housing issues?
Thank you for that question. I certainly did learn a lot from Kosovo about how it might have been possible to do things differently in South Africa. And in my very first interview, I went through some of those. But just to give a couple of headlines, because I know time is short, I think that there's insufficient collaboration between the Commission and the court. I think that there is inappropriate skill sets that are appointed in the Commission. It's a legal, intense process. Should have been a lot more lawyers appointed to the Commission. I think that there's been a failure to try to find mechanisms of grouping claims so that several claims are heard together. What we did in Kosovo is we would factually group claims that had very, very similar similar facts, and we would decide them effectively in one decision. It requires a very efficient underlying body. The equivalent of the commission there was the directorate, and they would collect all of these cases actively, put them all together, present them to the court so you could decide it in one go. And the result was we were able to get through 29,000 odd claims in a period of 7 years and complete the process. So yes, those would be some of the things that one would have done differently. There are some complexities of South Africa that are different, including the fact that it's substantially rural-based. Kosovo was substantially urban-based, and the rural component of it makes it more difficult. Also, the fact that it was spread over a much longer period of time. This was a war that took place over 3 months. Yes, at a maximum, a decade if one took into account the discrimination cases. South Africa, we're talking about discrimination between 1913 and 1994. So there must be some fairness to the Commission. And the Commission is getting there. The last statistic I saw was completion of 72,000 out of 80,000 claims.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Traba, is your hand up? Yes. Okay.
Thank you very much. And
okay.
Good morning.
Good morning, Commissioner.
Thank you very much. I just want to follow up on the question on the comment on your judicial philosophy. You have acted as a judge. So you were a judge of the Land Claims Court and acted in the as a judge in the High
Just
Court.
1 second, Commissioner Klaver. Can I just get an idea that, generally speaking, everybody hears when everybody speaks? Sometimes I've wondered whether everybody can hear. Generally, everybody hears. Okay. Thank you. Go ahead.
Thanks, CJ. You were a judge in the Land Claims Court, and you acted in the High Court on several occasions. I just want to know if there was any of your judgments overturned on appeal. Was any of your judgments overturned on appeal?
There's a record in the Bar Council's comment of that. There was a judgment where I sat as an assessor in a Labour Appeal Court matter, where I was a majority in the Labour Appeal Court with Judge Farlam, and that was overturned by the Supreme Court of Appeal. I think that's the only one that I'm aware of where I have been overturned. But a judgment of mine, an aspect of a judgment of mine, aspects of 2 judgments of mine I think have been criticized. An aspect of the Slumdien judgment was rejected by the Constitutional Court in the Richtersveld case. In the Slumdien, and aspects of the Slumdien judgment were also accepted in the Richtersveld case, and most of it has been accepted. But the one aspect that wasn't accepted from the Slumdien case is where I said that the intention of the Restitution Act was to deal with spatial apartheid, and that aspect was rejected by the Constitutional Court, and they said it went more widely than that. And it was necessary because in that particular case they looked at the way that claims in respect of the mining of diamonds had been dealt with. And it went beyond spatial apartheid. So that's the one aspect that was criticized. And then I understand that my judgment in Khomo versus Standard Bank in relation to the National Credit Act was criticized in a full bench decision of the Gauteng High Court. But subsequently, my decision has in fact been followed by another judge of the Gauteng High Court based on that judge's understanding of the relevant Constitutional Court judgments. So it's only one that I'm aware of where I've actually been overturned, and I was an assessor rather than the judge there.
No, thank you so much, CJ.
Thank you, Commissioner. I think we...
Yes.
Commissioner Dodovu?
Yes, thank you very much, CJ. Just one question. On the question of the land, I thought one commissioner would ask that question. Parliament has not passed the amendment to Section 25 of the Constitution. In your view, as matters stand, is Section 25 of the Constitution unlawful as it relates to expropriation of land without compensation.
CJ, I wonder who's that commissioner who should have asked that question.
Commissioner Malema is Commissioner Totov, but he's asking the candidate. Yes, Mr. Dodson.
But perhaps it might well be that Commissioner Malema is seeking to say either that question is unfair or it makes no sense or something else. And I think if that is what he intended to do,
I can assure you, Commissioner Malema will not keep quiet. Please, you may respond, Mr. Dodson.
As I understand your question, you're effectively asking, does Section 25, as it currently stands, permit expropriation without compensation? Or have I misunderstood it?
Yes, that's the question. Because there's been a lot of polemics and discussions whether, as it stands, it's unlawful in respect of that point or not.
So the short answer is it is possible to have expropriation, lawfully to have expropriation without compensation under Section 25 of the Constitution. And there are two ways in which that can happen. The first is if one applied those criteria in Section 25.3 that govern the determination of just and equitable compensation. If one applied those factors and an application of those factors led to an answer of 0, it would be lawful to give expropriation without compensation. So just by way of example, if it could be demonstrated by the state that that particular landowner had been subsidized by the state both by way of interest and by way of capital improvement to an extent that equaled, for example, market value, the person could then be expropriated without compensation. But the other legal route to it is that you also, at the end of the day, even if you couldn't justify expropriation without compensation with reference to the Section 25.3 factors, at the end of the day, one must always come back to the limitations clause in Section 36 of the Constitution. And if on a proper application of the limitations clause in Section 36 of the Constitution, you found that notwithstanding that perhaps some compensation was payable under Section 25.3, that was a justifiable limitation, you could also end up at a figure of 0. The practical answer to your question is that the expropriation bill is still there. Yes, the amendment of Section 25 has fallen, the constitutional amendment of Section 25 has fallen away, but the expropriation bill is still there. It's got, I think, a non-complete list, I think, of 5 different circumstances in which there can be expropriation without compensation. And look, I think the first of those, the one about land being held on a speculative basis, might come under debate, but they look okay to me. The provisions in the bill look as though they may well withstand scrutiny under the existing version of Section 25. So I hope that answers your question.
Oh, thank you, CJ.
Thank you, Commissioner Dodovo. I don't know why Commissioner Malema asked the question that he asked, but it is possible that he was thinking the Constitution being the supreme law, it can't be unlawful. So it's other laws that can be unconstitutional. So maybe that's why he was asking. I think we have come to the end of this interview. Mr. Dodson, we have come to the end of this interview. I don't know whether before I release you, there are only 2 or 3 matters you consider important to emphasize to the commissioners before you leave for purposes of your candidature?
Chief Justice, I think it's been covered well. I think that it was, with the greatest of respect, a good idea to put up the transcript of the previous interview. And if I look at the previous interview and the current interview, I've been given a very fair and full hearing. I don't think there's anything that springs to mind that I need to revisit. Just to thank all of the commissioners for the hearing that they gave me. I have responded to the one negative comment from Nardel. I don't think I can say anything more, not knowing what the basis of it was. So thank you very much, everybody, for hearing me. Thank you, Chief Justice.
Okay, thank you very much. You are now excused.
Thank you.
Good morning, Judge Catherine Setlwane.
Good morning, Chief Justice.
How are you this morning?
Very well, thank you. Very well,
Thank you. Thank you once again for making yourself available. I know that at least this is the third time you are making yourself available for appointment to the Constitutional Court. We appreciate the fact that you continue to make yourself available and come to the interviews. I was there when you were interviewed in October, as were many of the commissioners who are here. Other commissioners were there when you were interviewed in April last year as well. We do have before us the transcript of your interview in October, and we have obviously your CV and the questionnaire, so we have all that information. I, for one, will not be asking you many questions because through that interview I got to know what I wanted to know as much as possible. And it may be that other commissioners will take the same view, but there are commissioners who were not there in October, and they may want to ask you much more than maybe some of us. But obviously, every commissioner who wishes to put questions to you will be allowed to do so. So I'm going to ask you a few questions just to refresh our memory about some of the basic information about you, and after that I will then allow commissioners to put questions to you.
Thank you, Chief Justice.
Yes. In terms of your academic qualifications, you obtained a BA degree from the University of Natal in 1988. Is that correct?
Yes.
Oh, I just realized now that, so you must have been a student at the University of Natal, at least for part of the time when I was a student there.
Yes, probably. We probably were there at the same time.
Yeah.
I may have been doing my undergrad when you were doing your
Yeah,
postgraduate.
well, I finished my LLB in 1986, but so you must have been doing your first year or second year.
Yes.
Yes. And then you did your LLB in 1991 you got it from that university in 1991.
Yes.
And in 1993, you obtained your LLM from Georgetown University. Is that right?
Yes, that's correct.
And you practiced subsequently as an advocate for, was it about 14 years?
Yes.
Yes. And then you also clerked at the Constitutional Court, is that right?
Yes, in the inception of the at the inception of the
Yes.
Constitutional Court.
Yes. And you have been a judge in the High Court now for how long?
Approximately 12 years, I think.
About?
12 years?
Yeah, about 12 years. And you have acted in the Labor Appeal Court and Labor Court, as well as Competition Appeal Court. Is that right?
Yes, and the Supreme Court of Appeal.
And actually, you have been appointed to the Competition Appeal Court or not?
No. There were not any vacancies at the time, and a vacancy in the Competition Appeal Court came about at the same time that this vacancy was advertised.
Yes.
And the previous vacancies were advertised.
Yes.
So I couldn't apply for both, and I had to choose which to apply for.
But you have acted a number of times, both in the Competition Appeal Court and the Labor Appeal Court?
Yes, I've been acting in the Labor Appeal Court since, I think, 2014, and in the Competition Appeal Court since 2017 or 2018, yes.
And you acted in the Constitutional Court for about, was it 6 months
Yes.
or about a year?
For 6 months in 2017.
Which you enjoyed very much, is that right?
Yes, absolutely. It was really one of the highlights of my career.
Yes.
Acting in that court.
Yes.
It was an honor indeed.
Yes.
And I acted in the Supreme Court of Appeal in 2016.
Yes. Okay. And you have written, well, when you were in practice, you appeared in a number of matters which subsequently produced reported judgments. Is that correct?
Yes.
And you have listed them in the questionnaire.
Yes.
And you have also written a number of judgments that have been reported, both when you were sitting in the High Court and when you were sitting in the Labor Appeal Court and the Competition Appeal Court and the Constitutional Court. Is that correct?
Yes, Chief Justice.
Yes. Yes, I will now allow commissioners who wish to ask you questions to do so. As they do so, they will be seeking to satisfy themselves how you meet the criteria which this commission uses. And I just mentioned the criteria. There is criteria as stated in the Constitution, and the question there is the particular applicant an appropriately qualified person? 2, is he or she a fit and proper person? And 3, would his or her appointment help to reflect the racial and gender composition of South Africa? And then there are supplementary criteria. Is the proposed appointee a person of integrity? Is the proposed appointee a person with the necessary energy and motivation? Is the proposed appointee a competent person, technically competent? That is A. B, capacity to give expression to the values of the Constitution. 4, is the proposed appointee an experienced person? A, technically. B, experienced in regard to values and needs of the community. 5, does the proposed appointee possess appropriate potential? 6, symbolism, what message would be given to the community at large by the appointment of a particular candidate. So commissioners will ask you questions, but largely they'll be seeking to get information from you that will help them see how your appointment would meet those criteria. Thank you.
Thank you, Chief Justice.
Do you have any questions? Minister?
Thank you, CJ. And good morning, Judge.
Good morning, Minister Lamola.
Thank you. My question relates to the decision you participated in on the Spark Group Limited versus Absa Bank Limited, on the discretion that the bank must use to inform the beneficiaries or the payees on EFT payments. Do you think this is also important in a society like ours, which is also unequal and lots of poverty? Do you think that banks also have a role to play to protect the most vulnerable on their day-to-day execution of their transactions?
Yes, indeed, Justice Lamola. One's belongings and one's savings and one's salary that goes into a bank, particularly those of the disadvantaged groupings in our society, is very important to them. And it's important for their existence and livelihood. And it's important for the bank to safeguard those possessions of vulnerable people. So before a bank takes steps to, that may cause, or to reverse any payments for that matter, there's a legal duty on them to take steps to ensure that they don't cause economic loss. It's particularly important in the case of individuals that depend on the banks to safeguard their possessions and safeguard their interests. Yes.
Thank you, CJ.
Thank you, Minister. Commissioner Nyambi.
Thank you, CJ. Morning, Judge Kadisitulwan.
Good morning, Commissioner Nyambi.
It's only one question.
Okay.
As the CJ has indicated, you presented yourself from the same position twice last year. How different are you today from the judge that presented herself previously? Something that you think can stand out that we have to seriously consider?
Yes, I think I'm more tempered. I think I'm a calmer individual. I think it helped me grow in strength. It helped me develop as a judge. It helped to point out what is needed from a judge in terms of one's strength, in terms of one's character, in terms of one's humility, in terms of one's patience as a judge, in terms of one's ability to be fair and objective, and in terms of one's ability to be unbiased. I think this room brings a lot of wisdom to any candidate that appears before it.
Thank you, Judge. Thank you, CJ.
Thank you. Commissioner Lucas.
Thank you very much, Chief Justice. Good morning, Judge Sitilwane.
Good morning, Commissioner Lucas.
Yes, good to see you again.
Lovely to see you too. Thank you.
Yeah, I was saying to the previous candidate that we are feeling like a family already.
Yes.
The way we have been in short time seeing each other. But it's not my issue. I see you've made quite a contribution on issues like gay and lesbian marriages, and also I read your article, or part of your article, that you have critiqued on CEDAW and so on because of the role that I've been allocated to in Parliament. there is one thing that I don't know whether I've asked it before, maybe I didn't get the chance, but now I'm getting the chance. There is still the issue of Customary Marriage Act and how women are not just, particularly the women that are under customary law, not just getting a just dispensation. What is your view around that one? Thank you.
Yes, I think the intention of the Act is good, to regularize customary marriages and to ensure that women married under customary law, because they choose that, it's a choice of law that they choose, and they choose to be married under it, that they're treated equally as individuals that are married under the civil law system. I do think that the Act has good intentions. I think the Act needs to be properly implemented. I know the default position is that the marriage is a common law marriage and not one, is a marriage in community of property and not one out of community of property. I do think that, customary law must also be consistent with the Constitution and the values espoused in the Constitution. So to the extent that customary law is not, it will have to step up and the courts would have to intervene to make it consistent with the Constitution. I know in terms of customary law, particularly women in rural areas are not aware of what their rights are under customary law, and they can often be subject to abuse. So it's important for lots of education to occur around the meaning of the Act, the consequences of the Act, and what the consequences of customary law marriage is. The point is that the Act basically aligns customary law marriages with the values of our Constitution and the Bill of Rights. And I think there needs to be a lot more education around the protections that the Act offer to a woman who chooses to be married under that regime.
Thank you very much, CJ. I never got such a perfect response because it's exactly what the women feel.
Okay.
That is the issue. Thank you.
Thank you.
Commissioner Moiman.
Thank you, Chief Justice. Good morning, Judge Setulane.
Good morning, sir.
Just one question from my side, prompted by what caught my attention on your profile, page 23 of Book 1 of Book 2. In paying tribute to the former Deputy Chief Justice, Justice Museneke, you reviewed an article titled "A Warrior for Justice," Essays in the Honor of the Museneke. I'm interested in what are your key salient features that you are bringing forth to your readers in response to key critical questions around the structural limitation of our economy that were canvassed by the Deputy Chief Justice in his book. Thank you, Chief Justice.
Yeah. Yes, sir. The article basically recounts and celebrates Justice Muneke's unique understanding and vision of the transformative project of the Constitution. It considers his views on the political and economic challenges facing South Africa in achieving economic justice and the role of and the challenges facing the judiciary and the framework of constitutional transformative constitutionalism. He raises issues of, we have an ideal constitution that basically provides for for socio-economic rights, and there's an indivisibility between socio-economic rights and civil and political rights. You know, your civil and political rights are really meaningless unless you have the means to achieve your social and economic livelihood. And he talks about how it's a joint project between government and civil society. And he touches on issues of corruption and how that has affected the lack of political will, how that has affected the pure economic justice and the enhancement and the entrenchment of, in fact, the realization of socioeconomic rights of ordinary citizens, in particularly the disadvantaged groups. And he says that, he talks about, to the extent that you can't only view this as government's task. He accepts that sometimes the will is not there, sometimes there are issues of corruption and other structural issues that affect economic justice and the achievement of meeting all of these socioeconomic rights. But he also says individuals have basically their own agency, and they as well, working together with government in their private capacities, can help build, you know, the means to attain economic justice. And the article basically recounts, you know, to what extent, you know, we have this wonderful constitution that provides all of these rights and entrenches these rights. And what is the difficulty that is, you know, what are the challenges that are faced? I mean, I do think that it's quite important now. We've been so involved with political cases. The Constitutional Court, the High Courts have, in the recent years, been so involved with political cases that have come to them that there's a need now for NGOs, for communities to basically bring matters to the court that basically will give content to the socioeconomic rights in the Constitution. You know, the right to housing, the right to education. We've had cases coming to the court, but in the first, I'd say 10, 15 years, but in the last 10 to 15 years, there's been a decrease in those cases coming to the court. And it's really important, given the challenges faced by government in terms of its resources, in achieving fully the socioeconomic rights of its citizens, and particularly the vulnerable groupings. I think there's a need for civil society to basically constantly test the Constitution through the courts in relation to the achievement of socioeconomic rights.
Thank you, Justice Situlani. Thank you, Chief Justice.
Thank you very much, Judge President Lekhodi.
Good morning, colleague.
Good morning, Judge Lekhodi.
You and the CJ, you make me feel very bad about my age, because you start talking about the 80s, and I ask myself where I was in the 80s. And I'm start asking myself as to whether I'm not the most senior person in this room. Because I'll be turning 68 this year, and I'm asking myself how young you were at that time. Okay. Two of the criteria, as part of the, I want to ask you questions on two of the criteria mentioned by the CJ. The first one is the candidate having the capacity to give expression to the values of the Constitution? And this is where I am. Are you that kind of a candidate? And if so, do you have one judgment that perhaps if you have to pat yourself back, you will do so? you can mention that.
Yes,
And
I mean, I think
the second criteria that I would want you to respond to as well is, what message would be given to the community at large by the appointment of a particular candidate? And I want you to respond to this question in the context of the current composition of the Constitutional Court judges. You may proceed.
Yes. Yes, I think I've dealt with a number of constitutional matters that deal with, various provisions of the Bill of Rights. In the SPA group matter, I developed the common law. In the Residence of Industry House, the application concerned the constitutional validity of Section 13(7) of the South African Police Act, which was a post-constitutional enactment. It gave extended powers and intrusive search and seizure powers to restore public order and ensure the safety of the public in a particular area. And it permitted warrantless searches. And those warrantless searches basically constitute an infringement of the rights of the individuals who were subject to these searches. I mean, they were treated, not only were their privacy rights infringed, but their dignity rights were infringed. In the middle of the night, their homes were raided. The police entered without a warrant. And I mean, these were people that were eking out a living in downtown buildings, the city of Johannesburg. There could have been a different way for the city to basically ensure that there was control in those buildings. But the police, in fact, stepped in to protect the owners of the buildings, and they used these warrantless searches as a means to evict these communities from these buildings. So I think that's an important judgment. It was a full court decision. It dealt, with a frontal challenge to the privacy rights, to the Police Act, which implicated the privacy rights of individuals. And the Constitutional Court then upheld their judgment, and they confirmed the order that was granted in the judgment and the unconstitutionality of the section in the terms in which we had granted the order. So that decision makes me proud. There's the decision of the Contingency Fees Act, in terms of which attorneys were basically taking advantage of RAF litigants because they were entering into common law agreements with RAF litigants, contingency fee agreements, in terms of which they charged, 3 or 4 times what the Act allowed. And I think that's an important matter because we stepped in to put a stop to that practice.
Which judgment is that one?
The Bobroff matter.
Okay.
The Bobroff matter. Yes, Judge Lahori, I'm committed to the transformative project of our Constitution. I'm committed to social justice. The rule of law is an important component of our democracy, I believe that to a large extent, we need to take a kind of victim-centered approach to the manner in which we protect rights of the vulnerable groups. There are a number of constitutional judgments that have been involved in.
Yeah, I think insofar as the first one, I'm happy with the explanation that we gave.
Yes.
But the second issue is, what message would be given to the community at large if you were to be appointed, and take into account the current complement of the Constitutional Court?
Yes. The Constitution currently comprises of 5 male judges and I think 3 female judges. In the last round of the interviews, the president, and that's entirely his prerogative, appointed 2 male judges to the Constitutional Court, which brought the complement basically to 5 male judges. The Constitution makes it quite clear that the judiciary needs to be transformed. It makes it quite clear that there's a need for the courts to reflect the gender composition and the race composition. And I think I'm a woman judge. I think that's important for the court to be equipped with more women judges. I will, as a woman judge, add to the representativity of that court and the diversity of the court. I think it's very important not to just pay lip service to the issue of gender, but to actually make appointments of strong, competent women. You don't only appoint women because they are women and for the sake of being women, but you appoint women that are competent, that are skilled in a particular area of law, and that are committed to the objectives of the Constitution.
Thank you. Thanks, Chair.
Thank you, JP. At this stage, I would like to go to the commissioners who are attending virtually. Commissioners attending virtually, is there anyone who has a question?
Is Commissioner Malema here? Morning, Judge.
Yes, Commissioner Malema, go ahead.
I'm on virtual, Judge.
Yes, Commissioner Malema is attending virtually, just said Luana. But go ahead, Commissioner Malema, and ask your question.
No, mine is not a question per se, Judge. It's just to wish you well because we keep on trying. We don't know what's going wrong, but we hope we'll succeed one day.
Thank you. Thank you, Commissioner Malema. It's lovely to have a vote of confidence from you. Thank you very much.
Thank you, Commissioner Malema. Is there any commissioner attending virtually who wants to either put a question or put a wish?
It's Glynis Breitenbach, Chief Justice. I have no questions. Thank you.
Thank you, Commissioner Breitenbach. Commissioner
No question.
No question.
Thank you.
Thank you very much.
No questions, CJ. Just to wish her a good luck.
Thank you very much. You've
Thank
got
you very
another
much.
good luck.
Thank you very much.
Commissioner Singh.
Very briefly, thank you, Chief Justice. And also wish good luck. Good morning, Justice Atwana.
Good morning, Mr. Singh.
Your response to JP Lakoti, when you mentioned the criteria in the end, I just want to ask you, firstly, do you feel you ticked all the boxes?
Yes, Commissioner, I do believe I've ticked all the boxes.
Thank you. Right. My question then relates to a follow-up on Commissioner Lucas about customary law and customary marriages. I think you're familiar with the one-year judgment that was taken to the Concourt on live-in partners and their rights in terms of maintenance and inheritance. It's now referred to Parliament, and I think the Minister is dealing with that. We've been given 18 months to deal with the legislation because the Concourt didn't want to interfere in the affairs of Parliament. What do you think about that particular judgment? I know it's law, it's a judgment that's come out of the Concourt, but there were some very strong opposing views within the Concourt bench at that time.
Yes, Mr. Singh, I'm sorry, I didn't read the judgment, but I'm aware of it. But I didn't get an opportunity to read that judgment, yes. But in terms of the rights of live-in partners, and certainly when a live-in partner is part of a relationship for an extended period, then I think there must be recognition of that extended period that a living partner spent in that relationship. And it should be accorded with the rights that are accorded to persons in civil unions and in marriages, provided they can show that there was this permanent relationship and certain obligations, and there was a community in that partnership.
I'll leave it at that, Chief Justice. Thank you. Thank you.
Thank you, Commissioner Singh. Commissioner Mapisa-Nqakula.
Thank you very much, and good morning, Judge Situluane.
Good morning.
I also want to wish you well.
Thank you very much, ma'am.
CJ, I have no question, but I want to comment about two key judgments you have made. No, one. The one is the groundbreaking judgment which you made as far back as 2004-06, when you instructed the executive to allow for same-sex marriages to be recognized, and with the result that we now have a Civil Union Act. I'm the minister who directed to do that. And I can assure you it was one of the most traumatic at the time experiences to have to effect that. Reason being that at the time you took that kind of decision when it was not fashionable for South Africans to even mention or even talk about the LGBTQI community. And I think for that, it's something which South Africans should commend you for. But the other comment I would like to make is, I see that part of your programs have been to place women who are in the bar from poor communities. You've placed them to work in disadvantaged backgrounds with large corporate firms. And I just think that that's a very good program, particularly in the context of South Africa. Now, I would then want to make a plea with you, because we have been discussing, even at the last interviews, one of the things which was pointed out, particularly by advocates, Matole Lepo, is the fact that government and corporate firms, amongst others, do not give work, assign work to young black women. And I see here your focus has been to women from disadvantaged backgrounds, and you've done that by placing them in large firms. And therefore, I would expect that when you go into the Constitutional Court, part of your responsibility still would be to continue to advocate for this amongst your colleagues who are equally judges in the Constitutional Court, because there are very few of you who are advocating for women, black women in particular, to receive these kinds of assignments so that tomorrow they too are eligible to sit there and be appointed as judges. So thank you very much. I also wish you the best.
Thank you, Commissioner. Thank you very much.
Thank you, Commissioner Mapisa-Nqakula. It does look like, Commissioner Matolo Lepu.
Thank you, Chief Justice. Good morning, Judge.
Good morning.
I know that I echo the sentiments of Commissioner Mapisa-Nqakula. And one of you, I know that you are very passionate about training women. But now my angle is you are very passionate also on the socio-economic rights to be brought, matters to be brought to the Constitutional Court. One of my concerns is that we tend not to uplift our customary law and make it a South African common law. We tend to be focusing on Roman Dutch law and other. How do you see us uplifting our South African law to be our common law, especially taking into consideration the customary law?
Yes. That's very, very important, Commissioner. We know that there are three graces of the law. There's the civil law, there's customary law, and there's the common law. And customary law is always treated as the step-sister. So, it's important for the courts to take on the challenge in developing customary law or developing the common law to basically take into account customary law. I mean, customary law stands as an independent, pluralistic choice of law, but it also given its flexibility, given its, the important role it plays in dispute resolution, etc., I believe that it can play an important role in the development of the common law. And I think that's a challenge that the courts need to take up in basically looking at ways of infusing the common law with customary law, rather than developing the customary law to be consistent within the common law. You need to basically have these two systems infused into each other, and perhaps in that way we will give importance and essence to customary law, and in the hierarchy of the laws in the country. Yeah. So it's very important for courts to take on that challenge. And I know recently in the Bidika judgment dealing with the enforcement of contracts, Justice Saron made it quite clear that Ubuntu plays a major role in determining whether or not a contract, should be rendered unenforceable or not. So I believe there's room for the courts to basically look at customary law and how it can enhance its value in line with the value system of our Constitution. The Constitution makes it quite clear that the common law must be developed in line with the spirit, purport, and objects of the Constitution, and so must customary law. I can't see why these two systems can't be infused into each other, stand side by side with each other, and be given equal prominence in our jurisprudence.
Okay, thank you, Chief Justice.
Thank you, Commissioner. Commissioner Baloyi.
Thank you, CJ. Good morning, Judge.
Good morning.
Yes, Baloyi. In the previous interview, and it's not just you, but other candidates as well, the issue of the delays in the delivery of judgments by the Constitutional Court became a recurring theme. And answers differ, and I see what Mr. Madonsela put to you was issues about the length of the judgments, perhaps they could be kept simpler, and you agreed that might be one of the ways to avoid the long delays. But I wonder if that is the only way to look at it, or in fact a fair way to look at it. And I want to put this proposition to you, that when the first court, Constitutional Court, if I may call it that, was conceived, and the provisions in the Constitution, there's a prescription of sitting, at least 8 judges must sit. That is a completely different environment altogether. It didn't contemplate your 17th Amendment, for example, which expands the jurisdiction of that court, and therefore the load of work that comes to that court, that was not contemplated at the time. And isn't perhaps the conversation that we should be having that is that provision, that requirement that at least 8 must sit, still relevant to the environment in which that court is operating today? Should we not be looking? I mean, you've got the SCA, which is not, doesn't sit 8 people, because there's no such prescript, and maybe there isn't enough judges to do that. Is the rationale still sound? We have now an established jurisprudence, constitutional jurisprudence. We're completely different landscape when you look at our jurisprudence from what it was at the time that that provision was conceived. And isn't that where we should be addressing the problem about the delays in delivery of judgments, 1, and then 2, shouldn't the Constitutional Court itself, of course through the right office of the Chief Justice, be agitating, because you have the lived experience in that court, be agitating for changes?
Yes. Yes, I agree with you, Commissioner. I don't, the workload has increased, I don't know, 5-fold from the early days of the Constitutional Court. And you're quite right. The foundations of the jurisprudence are there. And it's an application now of those, the foundations that were basically put in place in the first, I'd say, 10 years of that court. Most of the rights content has been given to it. It may be helpful that given this increased given the increased jurisdiction of the court, because all matters are now infused with constitutional law, so every matter that goes there, there's the contention that this is a constitutional matter. If it's not a constitutional matter, it's a matter that has an arguable point of law, that is of sufficient public importance, and it needs to be dealt with. So everybody, all litigants are taking their matters from the Supreme Court of Appeal, from the High Courts, even where the Supreme Court of Appeal has refused leave to appeal. It still goes to the Constitutional Court for another bite at the cherry. And the numbers have just increased. And it's very difficult for the judges to manage that. I've been told by some of the judges in that court, they've now put in a different system to deal with application for leave to appeal, where in the past you had 2 judges on duty every week. Now you have 1 judge on duty, and the judge is allocated a set number of cases. In the past, the practice was you could get 30 cases in 1 week, and the next group of judges sitting in the second week would get no cases. So there was this disproportionate load in some judges, and that impacts on the judgment writing of the court. But perhaps the court, and the court needs to basically look at making representations, in relation to how it sits. Perhaps they can sit, they don't have to sit on bank all the time, with having a minimum of 8 judges, or 11 judges. They could sit in benches of 4. I think Judge Zondo may have been involved with that in past years, where it was envisaged that, in labor matters, you'd have kind of labor specialists within the Constitutional Court dealing with that. And you don't have to have all 11 judges, for instance, sitting there, all 8 judges. You could have a smaller group of judges. So all depending on, and also some of the application for leave to appeals, they take very, very long to finalize those applications, because you've got to go through 11 judges. Every single decision that is made, every single recommendation that you make, you have to make it to all 11 judges and all 8 judges that are involved in the matter. And it kind of lengthens the period of finalization of anything. So perhaps, the court needs to make representation on how it can streamline the work and how it can change the manner in which it sits, but still deal effectively with matters. But it would obviously need a legislative amendment. But certainly you can look at ways of bridging this difficulty that the court is experiencing, because it's incredibly difficult. You're dealing with judgments in current matters. You're dealing with judgments in past matters. You have judges presenting judgments. You go to two or 3 drafts at their judgment. You decide at some point in the process that you wish to dissent. Sometimes that's 3 or 4 months after the original, the scribe presents its judgment. That delays the judgment for a further 5 or 6 months before it can be handed down. There's the whole editorial process which the clerks are concerned with. It's an important part of judgment writing, that the judgments are properly edited, that the judgment is checked for consistency with previous judgments, that the judgment is checked, the citations are checked. So it's an incredibly long process. I understand how, as a single judge, that process takes so long for a single judge. But when you sit with 8 judges or 11 judges, that just increases and prolongs, the finalization and the delivery of the judgment. So I do think the point you make is valid. Perhaps the court needs to look at ways and how it can bridge these difficulties by making these representations to Parliament.
Thank you. Thank you, CJ.
Thank you, Commissioner. Commissioner Pillay.
Thank you, Chief Justice. Good morning, Judge Catherine Sitlwani.
Good morning, Ms. Pillay.
Perhaps I should begin with a declaration that I was your pupil many years ago when I first joined the bar.
Yes.
Judge Sitlwani, just tagging on to a question raised by Judge President Lekhodi earlier about giving expression to the values in the Constitution. Now, you're known not only for being an ardent champion of women's rights, but you're known for your commitment to the enforcement of the rights of the LGBTQI plus community. Yet one of the issues not yet specifically dealt with by the Constitutional Court is the rights of trans and non-binary or gender-neutral persons. And my question really in relation to this is twofold. Firstly, whether you consider that the current constitutional and legislative framework is sufficient to protect the rights of trans, non-binary persons. And secondly, and just drilling down to court process and the experiences of both litigants and witnesses as they appear in courts, how it is that we ensure that judges adequately recognize and respect the rights of people to their chosen gender.
Yes, I think it's important. I think the court, I think the Parliament has put in protections for this community of people. They, however, face violence at the hands of heterosexual people, essentially, in the townships. They can't, it's difficult for them to exist in certain communities. And that goes to the broader question of violence, gender-based violence, because they become victims of gender-based violence. I think that, yes, the courts are going to be dealing with these issues more and more. You have transgender people appearing in courts as witnesses. I think we need to be, particularly in assault cases, in other gender-based violence cases, and one needs to be sensitive in the same way that you are sensitive to the needs of women who are victims of abuse. In the same way you are sensitive to gay and lesbian people, in particular women, who are subject to abuse and violence in their communities. I think the courts have to be sensitive. I think it's important also at the level of reporting these cases to the police, for the police to be sensitized on how to approach and how to deal with cases of a person who chooses, to chooses a particular identity over what their birthed identity would be. And I mean, there are now amendments to the Domestic Violence Act in terms of the different groups that are protected under this regime, and vulnerable groupings are now, people from vulnerable groupings are now given protection under the Domestic Violence Act. And I think, well, obviously, transgender people will fall, within the vulnerable groups. They've experienced terrible, terrible violence in their communities at the hands of heterosexual people, in particular heterosexual men. And the police need to make a concerted effort. I think Parliament has now put in these protections. Also how, the evidence can be taken and the sensitivity in which the courts need to deal with the evidence that they give in court, and to treat them like they would treat any other individual, any other litigant that is a witness in their courts, I suppose.
And just sorry, Judge Kathleen Setlowani, just to follow up on the second part of the question, and that's really around practitioners and litigants who appear in court and who choose a non-binary identity. How it is that you can get judges now to begin to firstly understand and respect that choice.
Yeah, I mean, I think to the extent that litigant or counsel chooses to take on a particular identity that is non-binary, that needs to be made clear to the court. Unless it's made clear to the court, you are not going to know. And if you wish not to be referred to as a he or a she, then that must also be made clear to the court. And perhaps that could be done in chambers before hearing by counsel or an attorney who wishes to be addressed in a particular way. And to the extent that the litigant itself chooses to take on a particular identity, but non-binary identity, then that must also be addressed with the judge, and the judge must be sensitized to this. So in open court, the judge doesn't make an error, and that could be embarrassing, and it could be offensive to the individual concerned, I think.
Thank you, Judge. Thank you, Judge, Chief Justice.
Thank you. I only have 2 names, and those would be the last ones unless something else happens. Commissioner Nochesi.
Thank you, Chief Justice. Judge, just one question. You acted in the Constitutional Court. Now, assuming a judge who act in the SCA, receive an application, therefore leave to appeal, dismiss it, and is appointed to act in the Constitutional Court, that matter can appear before that judge. What are his obligations? Is he allowed to sit, decide also on the very same matter that he has decided in the court, ACO?
Yeah, I think you would ask to be recused if a matter comes, leave was granted, or leave was not granted at the Supreme Court, and if a judge was involved there. I think there's an obligation on that judge to bring it to attention of the other judges that he or she was involved in the decision not to grant leave. And that particular judge can be excused from the panel. You don't have to have all 8 judges, a minimum of 8 judges in leave to appeals. You could, do that number, as long as I think there are 5 judges that can decide the issue, then that would be appropriate.
Thank you very much, Judge.
Thank you. Commissioner Tsepe.
Thank you, Chief Justice. Good morning, Justice.
Good morning.
Sitilwan. Justice Sitilwan, in your response to the question raised by Commissioner Baloyi, you were looking at various mechanisms on how some of the delays in the Constitutional Court could be dealt with. And a thought just came to mind, and I wanted to find out what your view is, because I think this is one of the mechanisms the Constitutional Court may be trying to deal with in order to have matters expeditiously dealt with. There has been a number of cases where the Constitutional Court is making decisions on some matters which are not leave to appeal without hearing parties. And I wanted to find out from you whether you think that is a good practice, and what kind of cases other than leave to appeal cases do you think that practice, what kind of cases would be best suited for that kind of a practice? And if we were to hear it in respect of all matters, what could be implications? I'm thinking on amici who may want to appear in those matters. I just wanted to hear your thoughts on that. Thank you.
Yes, I mean, I think, Commissioner Sepe, you get the matters that are kind of full-blown constitutional matters that are dealing with important aspects of the law that concern, the larger public interest, that will have a larger impact. I mean, I think all of those cases, the court is very clear that those sorts of cases need to be dealt with. These very high-profile cases that deal with the issues of separation of powers, that deal with the powers and functions of organs of state, that deal with the violation of fundamental rights in areas of the law where the court hasn't made decisions as yet. Those sorts of matters the court deals with in open court hearings. Then there are matters where there may be a violation of constitutional right, but the court has already developed the law in that respect, and some of those cases then get discussed in chambers, and judges allocated that particular judgment to right. It may be an issue of costs in the labor court regime and, what the constitutional obligation is in relation to cost in that court. That's something that could also be dealt with by an individual judge, with just having a chamber discussion with a conference discussion with judges, and you don't need. So there are lots of matters that actually get dealt with on that basis where, and that helps as well, because you don't have to, you don't have to, there doesn't have to be a thesis on the law. You're not developing the law. You're not making new law. You're really applying principles that the court has already developed. And the court is doing that to a large extent. And yes, so that helps also to kind of bridge that the difficulty and the challenge that the court experiences. Yes.
Justice, thank you.
Thank you, Commissioner. We have come to the end of this interview, but are there 3 or so points that you wish to emphasize to the commissioners that they must take into account in considering your candidature, or are you satisfied that you have mentioned either in writing or in your answers all the important points?
I think I've covered all the important points in my application.
Yes.
I think it's important to take into account that it's important to increase the capacity and to increase the composition of women judges on the court. So that's something that needs to be taken into account. I think you have 2 strong women judges that are appearing before this panel today, and that appeared before this panel in the past. And I think you need to look at our skills. You need to look at our judicial philosophy. You need to look at our contribution to the law. You have to look at what our contribution can be, should we be in the Constitutional Court. I think as a women judge, I have, in the 12 years, proved myself as a judge. I have shown my commitment to the transformation of the judiciary. I've shown my commitment to the transformation project of the Constitution, to the value system of the Constitution. I have ample experience. I'm an all-round judge. I went from being a public interest human rights lawyer to doing constitutional law, to doing competition law, to doing commercial law, to dealing with cases in labor, to dealing with broadcasting, complex telecommunication cases.
Thank you. You are now excused. Thank you very much for making yourself available.
Thank you very much, Chief Justice, and thank you very much to all the commissioners.
Commissioners, we are going to take the tea break at the moment. The time is about 28 minutes past 11. We are going to come back at 11:45. We adjourn. Have we got all commissioners back? Yes, the candidate can be brought in. Sometimes the candidate is already there, but I can't see the candidate because the gentleman with the camera is standing between us. Good morning, Judge Molimela.
Good morning, Chief Justice.
How are you this morning?
I'm fine, Chief Justice. How are you?
I'm all right, and the commissioners are all right too. I must once again thank you for availing yourself to be considered for a position in the Constitutional Court. We appreciate that at least it's the third time you are making yourself available. Maybe it's more than that, but I think I know 3. The third time now. Thank you for continuing to make yourself available. We appreciate it.
It's a pleasure, DCJ.
We...
Sorry, Chief Justice. I still need to get used to the new title.
No, it's fine. We do have before us the transcript of your interview in October. Yes. And obviously we have got your CV and the questionnaire that you have filled. So we have a lot of information about you and your candidature. Because I was part of the commission in October when you were interviewed, I will probably not have lots of questions to ask you. It may be that other commissioners might take the same approach who were there, but there are commissioners who were not there and who might want to know you more. But certainly we all have got the transcript and the other documents that I've mentioned, which we will have regard to. I will ask you just a few questions just to refresh everybody's memory about some basic information about you, whereafter I will allow commissioners who might wish to put questions to you to do so. You hold several degrees. The first one is BA which you obtained from the University of Fort Hare in 1986, is that correct?
That's correct, Chief Justice.
And then you have a BProc from the University of Fort Hare, which you obtained in 1992, is that correct?
Correct, Chief Justice.
The one is a 3-year degree, the other one is a 4-year degree, so you, for those two, you must have been at Fort Hare for quite some time. Is that correct?
I was at Fort Hare from 1982 to 1985 and then went back in 1992,
Yes.
Chief Justice.
Okay, no, that's all right. And then you have an LLB degree from the University of the Free State, which you obtained in 2000, is that right?
Correct, Chief Justice.
And you have an LLM degree from the University of Free State, which you obtained in 2002.
Correct, Chief Justice.
And then you have got quite a few diplomas and certificates in addition to that, is that correct?
Yes, Chief Justice.
Yes. One of which is, I don't know if it's a diploma, but you will tell us, or certificate, but it's advanced military law.
Yes, that's a certificate, Chief Justice.
And you even qualified as an estate agent.
Correct, Chief Justice.
Yes. And you served articles, and you were admitted as an attorney, and you practiced as an attorney. For how long did you practice as an attorney before you went to the bench?
93 to 2008. That's 15 years, I think. Chief
That's
Justice.
15 years.
Yes.
Yes. During your time in practice, just give the commissioners a picture of the branches of law in which you were involved.
I served articles of clerkship at a firm called E.G. Cooper & Sons. And at that stage, the area of the law where I cut my teeth was collections, doing collections.
And maybe you could pull the mic closer to you.
Okay. Yes. Am I audible now, Chief Justice?
Yeah.
Yes. Yeah, I was doing mainly collections as a candidate attorney, but also being the most junior, taking statements from clients, all clients that came to the office. So that in itself, Chief Justice, gave me a lot of exposure because I was not restricted to just one area of the law. The one aspect that many candidate attorneys used to lament was that they used to say that they were merely being used as glorified messengers. I was fortunate enough not to have been in that kind of a setup at any of the firms where I served articles. E.G. Cooper & Sons in particular is a firm where I gained a lot in terms of practice management because they really had state-of-the-art facilities for everything. And I then joined Mr. Pete when he opened his own practice. I followed him to his practice because we had struck quite a good relationship while he was a professional assistant at E.G. Cooper & Sons. And that firm, we proudly called ourselves general dealers because we did everything, all aspects of the law. And I was admitted in 1993 and stayed on in that firm for 2 more years before opening my own practice, which I opened in 1995. And soon thereafter, I was admitted as a conveyancer. And soon thereafter, I was admitted as wrote exams and admitted as a conveyancer, and later on wrote exams and was admitted as a notary. And that helped me a great deal because then I was able to be placed on panels of various banks because they insisted that they wanted what they called a one-stop shop. In other words, a firm that had practitioners that could deal with all areas of the law. At that time, I was in a partnership with a colleague of mine, who is now also a judge, Justice Kubushi, and we had two offices. She was in charge of the office in Qwaqwa, and I was in charge of the office in Bloemfontein. We had a fairly successful practice because of the fact that we were on the panels of many parastatals and so forth. And precisely because we were considered to be a one-stop shop, it meant that we really dealt with all areas of the law. And with, being conveyancers actually exposed me to commercial law, more commercial law, because when you are a conveyancer, contrary to what many people believe, that all you do is sit at an office and sign the deeds of transfers and the mortgage bonds, you are really in charge of what is behind the, let me call it, the putting together of all the instruments that are necessary to eventually get that property transferred. Meaning that there must be a causa, there must be a legal reason why the property is transferred from Mr. X to Mr. Y. If it is because a property, a house has been sold, then the causa would be a sale. If it's because there's a long lease, then the causa would be a lease and so on. And so that gave me exposure to the drafting of contracts. And as a matter of fact, it's one of the areas where you are tested. When you write a conveyancing examination, you have to show that you are proficient in the drafting of different contracts. So it would be sale contracts, lease agreements, and you also had to be conversant with all other areas of the law. For example, estates, where property is being transferred from one person to the other because it is an inheritance. So from then on, in order to get a quicker specialization in labor-related matters, I joined the CCMA as a commissioner. Thereafter joined another firm called Claude Reed and joined a firm in Johannesburg, which was at that stage called Smith Tabata Buchanan Boys. And by the time I joined the Judiciary in 2008, I had really acquired what I considered to be sufficient exposure in all the areas of the law.
Yes. No, thank you very much. I guess there would still have been some areas that you might not have had simply because generally black lawyers would not be exposed to because certain clients wouldn't give that work to them.
That's correct. That's correct.
Yes. And you were a judge of the High Court for how long before you were appointed to the Supreme Court of Appeal?
For 10 years, Chief Justice.
Yes.
I had acted, before my permanent appointment, I had acted for a cumulative period of a year.
Yes.
Yes.
Yes. And of those 10 years, you were judge president for how long? 3 years, 4 years?
I was a judge president for 3 years.
Yes.
Yes.
And how long have you been in the Supreme Court of Appeal now?
4 years.
Yes.
Excluding the acting period.
Sorry?
Excluding the acting period.
Yes.
Yes.
And you have acted in the Constitutional Court as well, is that correct?
I have, yes.
And that was for about 6 months?
For 2 terms, yes.
Yes. How did you find that experience?
Very, very enriching.
Yes.
Chief Justice. Yes, it was the best experience of my life.
Yes.
I think, yes.
And in terms of judgments that you have written both in the High Court and the Supreme Court of Appeal, do they cover a wide range of branches of law?
They do cover a wide range of branches of law, Chief Justice. And because, you know, at the Supreme Court of Appeal, we sit mainly in fact, we sit all the time as panels. It's either a panel of 3 or a panel of 5. And so even where I did not write a judgment, I was on the panel. And as I was chatting to another colleague this morning, I actually came to the conclusion that I've been on a panel in all the fields. I've
Yes.
served on the panels in all the fields.
Yeah.
The fields of law, to be specific.
Okay, no, that's fine. I will now allow members of the commission who wish to put questions to you to do so. And largely, when they put questions to you, they will be seeking to see how your appointment would satisfy the criteria which the commission adopted some time back. And without reading all of them out, some of those relate to whether you are a person of integrity and whether you have the necessary energy and motivation, and whether you are a competent person, technically competent, or whether you have capacity to give expression to the values of the Constitution, and what message your appointment would give to the community at large if you were to be appointed. There are other criteria. So largely, commissioners will be asking you questions aimed at establishing how your appointment would meet those criteria. Thank you. Minister?
Thank you very much, CJ, and good morning, Judge Melemela.
Good morning, Minister.
I thought when the CJ said that you were also an estate agent, he was going to ask you, how many houses did you sell? My question relates to the judgment that you contributed in on the Opelt versus the health department, the head of the health department, provincial administration of the Western Cape.
Yes.
Why do you think, learning from this judgment, the importance of the state's duty to ensure that it does deliver the health services, particularly in the public service and the most vulnerable, to save public life and also to prevent these medical negligence cases that are piling up in our hospitals?
Yes, thanks for the question, Minister. It is a matter of grave concern that we see so many medical negligence cases against the hospitals, with the government having to pay such a huge bill in respect of damages. But I always believe that there are always lessons to be learned. And there have been many of those cases, but as regards the case of Opelt itself, I think the most important lesson coming from that case is that you cannot put up protocols and then ignore them, because if you do that, then you will be found to have acted negligently, and because of that, you'll be held liable to pay damages. And that's exactly what happened there. There was a hospital, Conradi Hospital, which had been earmarked as a specialist hospital in relation to back injuries. But this particular patient, a young boy who was playing rugby and sustained an injury during the game, was transported to a different hospital, Groote Schuur, and kept at that hospital for quite some time before being transferred to Conradi Hospital. And Conradi Hospital was a hospital that had successfully done a number of operations which used the reduction method. And that kind of method had been proven to be successful in relation to injuries that had been caused, that are usually called low velocity injuries. High velocity injuries would be, for example, an accident that you sustain, an injury that you sustained in a motor vehicle accident. But a low velocity injury would be an injury like that one that was suffered by the young boy in question. Low velocity simply because he was in a game running and so forth. And that there had been a degree of success where such injuries had been successfully treated at Conradi. And we really could not find a satisfactory explanation why, number one, the patient was taken to Groote Schuur instead of Conradi, a specialist hospital. And two, why, when he was transported to Groote Schuur, why did they then not transfer him as soon as possible to Conradi? So I would say that amongst all those cases, the big lesson to be learned from there is that you must honor your own, as hospitals must honor their own, the protocols that they have put in place.
Thank you, CJ. Thank you, Minister. Justice Betzer.
Thank you, Chief Justice. Good morning, Justice Molemela.
Good morning, Deputy President.
I've got one question for you. In the bundle of documentation that we have before us, I'm looking at the case of Morudi and others, where you wrote a dissenting judgment in the SCA, which was in fact upheld by the Constitutional Court on appeal to it. And what I want you to comment on, because as I understand your dissent, it reiterated a well-established principle of our law, affirmed many years ago in the Garden of Eden, that the presence of a litigant in court is not confined to physical presence, but includes, most importantly, the right of that litigant to be afforded the opportunity to defend himself or herself.
Yes.
Would you perhaps want to respond to what I've just put to you?
Yes, I'll agree with you that that particular, the dissent affirmed a long-standing rule of audi alteram partem, because in that case, the litigants were in court and their representative was not allowed to address the court on the basis that the matter had been settled, even though the settlement had not taken the interests of the other litigants into consideration. So my point of view there was that those litigants were respondents in the matter in their own right, and it did not mean that if one of the respondents decided to settle the matter, that the settlement should also be extended to them. Was still where they were loudly protesting the terms of the settlement. And the point that was taken, or the reasoning followed by the High Court, was that, well, they had no right to represent themselves in that matter. And yes, I wrote the dissent in which I said that those who had purported to represent them also represented them as directors, acted as directors. They were respondents as directors of the particular company, but also in their own personal capacities as shareholders, and that as shareholders, they should have been allowed the right to make representations to the court. And that was affirmed in the Constitutional Court.
Thank you, Justice Molimela. Thank you, Chief Justice. That was my only question.
Thank you very much. I apologize, Commissioner Makwanishe and Commissioner Nyambi. You were ahead of Justice Petse, but somehow I didn't look at my list. So, Commissioner Makwanishe, it's your turn.
No, thank you very much, Chief Justice. Good afternoon, Judge Mulemela.
Good afternoon, Commissioner.
I only have two quick questions. The first one, looking at your CV, you have studied widely. In addition to law degrees, you have also done a diploma in business management and a certificate in a state agency. What has been the impact of those courses or studying widely in addition to law qualification to you as a practitioner and to you as a judicial officer?
Thanks, Commissioner, for the question. I would like to comment particularly on the diploma in business management. I think that I benefited a lot from studying and obtaining that diploma, because then it helped me in terms of all the leadership positions that I held. Before becoming the judge president, I had been active in the boards of, in several boards of directors, and that assisted me a great deal, especially in relation also to management issues and things like that. And in particular, it helped me a great deal when I became the judge president. And I would think that I was successful as a judge president because of the benefit that I got from the fact that I had that diploma and I had the insight into leadership. And I think it's always helpful. I like to study a lot. So at that time when I studied that diploma, I never thought that I would actually end up as a judge president. But look how it benefited me. I always say when I motivate students and those that are worried that they have degrees but they don't have jobs as yet, I always say to them, you benefit from any kind of job that you do. It doesn't matter what you do. If you are, and so I say to them, always be prepared to do any job in the meantime. Don't wait so that your first job is to become a prosecutor or your first job is to be a candidate attorney, because jobs are scarce. If you are offered a job as a manager, for example, at Edgar's, take that job. If you are offered a job to be in charge of the storeroom somewhere, take that job, because it's going to benefit you. So my own experience has been everything that I have studied has turned me into this broad-minded person that I think I am today.
No, thank you very much, Judge Mulemela. My last question, since the last time we interviewed you, have there been any developments on your side which you think that we should consider when we consider your application today?
No, not that I can think of.
Thank you very much, Chief Justice.
Thank you, Commissioner. Commissioner Nyambi.
Thank you, CJ. Morning, Judge Molemela.
I think it's now afternoon.
Afternoon, Judge Molemela. Thank you.
Good afternoon, Commissioner.
I must also say, the last time you interviewed, as CJ has indicated twice last year, you interviewed well, and you were part of the 5 that were recommended even then. So I have just 2 questions. The first one, what will you consider as your most important contribution to administration of justice in our beloved country, South Africa? Something that stands out that you want to share, that you haven't shared with us?
I hope you won't think that I'm ducking your question, because I'm not. But I think everything that I have done so far is contributed to the administration of justice. I've been a lawyer, I've been a lecturer, I've been an arbitrator, I've been a judge, and in all those positions, I was contributing immensely to the administration of justice. So for me, they are equally important, but maybe I can just say that the one that I enjoyed the most was as a lecturer, interacting with students. You always have a fresh perspective of things. But in general, I think that every position that I have held has contributed to the administration of justice.
The second question, as the first female chancellor of the Central University of South Africa, what is the relationship between education and law, and how will you sum that experience sitting here today being interviewed for Concord?
I have always said to people that I think being a lawyer is quite a privilege. Being in the legal field is quite a privilege because it entitles you to know everything, in the sense that you know the law that relates to medicine, you know the law that relates to education, you know the law that relates to all the branches of the law. And as a judge, you are even in a more privileged position, because you listen to the evidence of people that are highly qualified in various fields. You listen to professors, you listen to specialists in the medical field, engineers, fields that you have not participated in, but where you, at the end of the day, are the one who has to make a judgment. So I think there's an interface. And in terms of the relationship with the university, I would think that it's mutually beneficial, in the sense that the university is benefiting from my expertise in the legal field, because even though I am not in the operations, because I'm just the titular head as a chancellor, but I do have interactions with the chancellor from time to time, where I, under certain circumstances, would be prepared to offer advice and so forth. And yeah, I think that's what I can say about it.
Thanks, Judge Molemela. Thank you, CJ.
Thank you, Commissioner. Commissioner Tolo Zepu.
Thank you, Chief Justice. I know you are very active in trial advocacy, especially with the Black Lawyers Association.
Yes.
And you haven't said much about it, because for me it's one of those training courses that you empower Black practitioners and young practitioners. Looking back, do you think that the program has achieved much, or do we have to accelerate? I mean, from where I'm standing, the child advocacy courses so that they link up with the universities, you know, so that, because there's this challenge where people are complaining about the LLB now and practice. So do you think we should accelerate child advocacy course with the university? And what's your take on that? And the second question for me, it will be, access to justice, it's still a wish for a lot of South Africans. And from where I'm sitting, the Constitutional Court is actually a court which will actually empower communities and make sure that communities bring their issues, constitutional issues, socio-economic issues. How do you think we can go about it? Because suddenly the Constitutional Court is flooded with political cases and commercial cases. How do you think we can go about it?
Maybe let me start with the last question. As a judge, there isn't much you can do because of our code of conduct, because it restricts us in terms of our involvement in extra curial matters or extrajudicial activities. So that is why after my appointment and after many judges' appointments, they actually withdraw from all the activities that they were involved in because the code of conduct does not permit. There was a stage when I was a board member of a non-governmental organization, Free State Rural Association, and I resigned as a board member from that organization when I relocated to Johannesburg because I could no longer attend their meetings. And because I was acutely aware of the problems that beset farm workers in particular, when I became the judge president, I invited the provincial chairperson of the South African Human Rights Commission to be part of our Provincial Efficiency Enhancement Committee, which is usually referred to as the PEEC. And in my engagement with the chairperson, I told the chairperson that I was particularly worried about the plight of farm workers, and I thought that the chairperson, being the chairperson of the Human Rights Commission, was best placed to see to it that the problems or the challenges that are faced by farm workers are in one way or another prioritized in terms of resolution thereof. So, but as a judiciary, we are reactive and we have to be that way, and that's in acknowledgement of the separation of powers. As a judge, you cannot go out there, be a member of an organization and invite people to bring cases to the courts, because when that happens, you might actually be asked to recuse yourself because people might have formed the impression that you have already shown where your sympathies are going to lie in a case of that nature. So, and most unfortunately, as judges, there isn't much we can do. We are reactive. We have to wait until cases are brought to us. I think that's why on a number of occasions you have heard the former DCJ Moseneke, lamenting the fact that only a limited number of cases pertaining to Section 25 were brought to the Constitutional Court. All you can do under those circumstances is to lament. I do also recall that on several occasions, the former Chief Justice at this forum in the JSC also lamented that and went on to ask why there's an inclination for people to join certain organizations, non-governmental organizations, and not others, especially those that are directed at the accomplishment of socio-economic rights. So I'm so sorry that I can't offer a solution in relation to your last question. I can only offer an advice that people, should club together, form organizations, and bring cases to courts, and we will gladly deal with them. As far as trial advocacy is concerned, it's my passion. Smack bang in the middle of COVID, I went to Cape Town to do training on trial advocacy, morning and evening. That's how passionate I am about it. I think it is very, very successful because after the training, the participants are given a questionnaire to indicate how they found the experience. And most of them actually ask for it to be extended, But all around, I think everybody is happy with the trial advocacy that is being offered at the moment. As I said when I started, there's always room for improvement. So if it is something that will be done in conjunction with the universities, maybe during the last year of LLB or whatever, I think that can also be explored. I think it can only be helpful.
Thank you, Chief Justice.
Thank you, Commissioner. Commissioner Schlemmer.
Thank you, Chief Justice. Good afternoon, ma'am.
Good afternoon, Commissioner.
I would just like to hear your view on what we have been seeing, the fact that since the jurisdiction of the Constitutional Court has been extended, that quite a number of the SCA judgments are now appealed to the Constitutional Court. What the view out there is either that because there's a second opportunity that people are using that's the one. The second one is that maybe the quality of the judgments of the SCA has deteriorated. And also we now find that from the Constitutional Court side there are delays because of the increased workload, but maybe also due to the fact that specialists aren't necessarily sitting in the court dealing with the different private law, commercial law type of matters. What is your view on that?
My view on that, and I'm not criticizing anybody for this, I'm just saying, before the Superior Courts Act, which gave the Constitutional Court additional jurisdiction, before it was promulgated, when it was still in the offing, there were consultations. And I think it was the Department of Justice that was visiting all the courts to hear the comments of the judges on the matter. And I think in most divisions, I'm speaking under correction because that was a long time ago, but I think in most divisions, the view was that the minute you give additional jurisdiction to the Constitutional Court, the danger is that there are going to be bottlenecks because I think it's just human nature. When people know that there's another court, they will try their best to get their cases to the final court. And so at that moment, I know that a number of judges were saying, don't grant the Constitutional Court additional jurisdiction because there will be now a lot of appeals from the Supreme Court of Appeal to the Constitutional Court, and that in itself will cause a delay in the finalization of matters. But then it happened. And when I was there at the Constitutional Court, I also did realize that the workload had increased significantly, and that was in 2015. So in 2015 already, they were getting a lot of applications for leave to appeal. And my take on it really is not because the judgments of the Supreme Court of Appeal are of a poor quality. I think my take on it is that everybody wants to have their cases heard by the last court, and so they will try to get audience in that court. And unfortunately for that to happen, it is that very court in itself that has to decide whether it's going to grant leave or not. And so that has added additional workload to it.
Thank you, CJ.
Thank you. You said it was the Superior Courts Act that gave the Constitutional Court additional jurisdiction. Was it not the 17th Constitutional Amendment?
Yes, the 17th Constitutional Amendment.
Okay, all right. It looks like there are, Commissioner Singh.
Thank you very much, Chief Justice, and good afternoon, Justice Molamela.
Good afternoon, Commissioner.
I did have my hand up, Chief Justice, but I realize it's a long way from there.
Yeah. And the light behind you also sometimes.
Yes.
Yeah, okay, all right, thank you.
No, thank you very much. Just two short questions. I think I've been fortunate to have been here from 2014 when Justice Molamela was recommended for JP, Free State, and then you went to the SCA, and then you acted in the Constitutional Court. And now you've applied for this position here to the Apex Court. Now, one of the criteria that we have to consider is the proposed appointee a person with the necessary energy and motivation. Energy over the years in your interviews, I've noted that you have. But can you give us an assurance that if you are appointed to this Apex Court, you are motivated enough to fulfill your term of office in that court, because you probably will have another 10 or 12 years to go in the Apex Court. Thank you.
Thank you. I'm more than happy to give you the assurance that I have both the energy and the motivation. In terms of the energy, I carry very good genes from my grandmother, who could still run in her 70s. And I have a lot of energy. My colleagues will tell you that. I'm always willing to, in terms of the motivation, I'm always willing to go an extra mile. I do additional reading. Well, you would not know this when you are not involved as a litigant in an appeal that I participated in, but there are many cases where in the judgments I write, I make reference to authorities that were not referred to by counsel. I always make sure that I compare ourselves, with other jurisdictions and what happens there. And if I find an interesting judgment, I will see whether it can be applied, and if it can, then I will refer to it. So I do my own additional research in addition to the heads of argument that we receive. So I have the motivation, and I'm more than ready to hit the ground running at the Constitutional Court.
Thank you. And your career path will evolve around the Constitutional Court in the next 10 years or so?
That is correct.
Correct.
And,
Thank you.
and maybe just in terms of the motivation, just to conclude by saying this is now my 35th year in the legal profession, and throughout these 35 years, I have been very, very energetic, very, very enthusiastic, and very, very motivated. I find the law fascinating, and I think that's how it's going to be until I retire.
Thank you very much. My second question relates to, I think it was in 2018 when you came before us to go to the Supreme Court of Appeal. You spoke about a very cold and unfriendly environment within the SCA at that time. Your experience since then, has that changed, and how would you try and manage that kind of environment if you are appointed to the Apex Court?
Well, okay, first of all, to give you the assurance that things have normalized at the Supreme Court of Appeal. We have a very happy working environment. Okay, I'm lucky enough to have had training as a mediator. So in terms of collegiality, I think I can contribute in any environment that I'm in. That's why even at the Supreme Court of Appeal, I did not hold back, even though I was acting. I mean, from the time I was acting, I was actively involved in normalizing things. And that's what I will also do if at all the situation like that arises at the Constitutional Court.
Chief Justice, she was fiery then and she's fiery now as well. Thank you very much, Justice Molemela. Thank you, Chief Justice.
Thank you, Commissioner Singh. Well, Judge Molemela, I don't know whether Commissioner Singh, when he asked you whether if you're appointed to the Constitutional Court, you will finish your term, I don't know whether he was thinking you might be attracted to go back to estate agency and leave the Concord. I'm going to go to the commissioners who are attending virtually at this stage. Commissioners who are attending virtually, is there anyone who wishes to ask some question to the candidate?
CJ Julius.
Yes, Commissioner Malema.
No, mine, Judge, is not a question. It's just to encourage you to continue appearing before us until the things happen. Because we've been trying and we don't know where things are going wrong, but some of us are convinced. Do not be discouraged. Thank you.
Thank you, Commissioner Malema. I think Commissioner Malema is really, he has good wishes for candidates today. Any other commissioner attending virtually who wishes to, who has a question or something?
Commissioner Shabangumdawe, CJ.
Thank you. It looks like the other commissioners don't have any questions attending virtually.
Commissioner, sorry, CJ Shabangumdawe.
Yes.
Thank you. Good afternoon, Justice Molemela.
Good afternoon, Commissioner.
How are you?
I'm fine. How are you?
Glad to see you again.
Thank you.
Commissioner, there's a question that keeps on coming. It was asked previously in previous interviews, and it also came up this morning. The issue of delay in handing down the judgments, particularly the agent application. What do you think can be done so that agent applications can remain agent even when coming to the delivery or the handing down of the court's decision?
Thank you, Commissioner. Let me start by saying that I did read about the interviews for the position of the Constitutional Court, and in the articles that I read, I think at least 2 judges who are already at that court, and I think that includes you too, Chief Justice. I think it was you and Justice Madlanga, who said that you have already made some changes in relation to how certain matters, applications are attended to. Unfortunately, because I'm not sitting in that court, I'm not privy to the extent of the amendments, so or the changes. So, Commissioner, all I can suggest would be something that is based on my own experience when I was there, that the applications take a lot of time, and they are the ones that contribute eventually to the delays in the delivery of the judgments. And perhaps what could be done, the panels could be made smaller in relation to the applications, and in that fashion I think the applications could be finalized more quicker. But I do appreciate the fact that that would obviously entail a legislative amendment. Yeah, but that's the one thing that I think could help to ease things a little bit at the Constitutional Court.
Thank you, thank you, Justice, and thank you, CJ.
Thank you. Maybe I must just take this opportunity to share with the commissioners that the system that I talked about, and maybe Justice Matlanga also talked about, that we as judges in the Constitutional Court introduced towards the end of last year, of dealing with applications, seems to be working very well in terms of easing up backlog and making sure that the applications can be dealt with reasonably quickly. It entails judges of the Concord receiving one application at a time, like in a cycle, whereas in the past you would be with a colleague and you'd be on duty for a whole week and you receive many applications that the two of you need to deal with. So now, each application, when an application comes in, it gets given to the next judge available. When the next one comes, it gets given to the next judge. So you have one application to do at a time. So it's making a big difference. So I thought I must just share that with you. We are still looking at the issue of some delays in relation to reserved judgments, and we are looking into that. We are discussing. I'm confident that soon we are going to find a solution to that as well. Thank you, commissioners. Commissioner Breitenbach, did you have any question for the...
Thank you, Chief Justice. I have no questions. Thank you, Chief Justice.
Thank you. Commissioner Barnett, do you have any question for the candidate?
Nothing from me, Chief Justice. Thank you.
Thank you very much. Judge President Lekhodi, you have a question.
Thank you. Khaitsedi ya me dumela.
Dumela Khaitsedi.
I'm just saying it deliberately so that other commissioners, if they feel jealous, they should do so. You are my sister. Initially, I thought I will ask you two questions on some of the guidelines for the interviews and appointment. I'm no longer going to do that because of some of the things which you said. And I just want to make a statement to say to you, I was greatly humbled and touched by some of the things which you said. And I'm sure you are not going to show me a middle finger when I say, next time when I go to Eastern Cape, where Honorable Moganisho is coming from, to go and address young people there, I'm going to insist that you should go with me. And now when I go to my village at Mudungobohove to address the students, and when I go to a village called Kanimo, where the minister is coming from in Bushbuck Ridge, I will ensure that he's not there so that the community should not get confused to think that we're part of the executive. I'll wait for him to get out of the country. But the point is this. You have said some of the things which I think every one of us needed to do. To hear you saying you encourage young graduates, young people who are unemployed to take any job which come their way, because that somewhere along the way is going to benefit them. It's very humbling, particularly when we all know that we have got young graduates out there who are unemployed, and you don't want them to lose direction. And the only way of doing it is continue to encourage them. for you to interact with the students and see it as refreshing, it's just humbling, especially if it is coming from a judge, because sometimes people think that we are loners and we are not part and parcel of the community, something which I think we should all of us recoil, because we are part and parcel of the community. And the other thing which you said is that it is a privilege to be a lawyer, and I'm sure you wanted to say it is a privilege to be a judge, but you remain to be part and parcel of the community. And when you are being given a privilege, it must not be an issue of status or titles. It must be an issue that you have been put there by those people who may not be in a position to reach where you are, but you can't reach there on your own. It is these ordinary members of the public which are making us to be where we are today. And for that, I want to say, if that is your spirit, continue with that spirit, because at the end of it, we'll just simply be a shining society. Thank you.
Thank you. Thank you, JP.
Thank you, Judge President. Commissioner Play. She is the last one on my list. Thank you.
Thank you, Chief Justice. Good afternoon, Justice Molamela.
Good afternoon, Commissioner.
Justice Molamela, part of the criteria that we have to test for is independence.
Yes.
Which includes the ability to make your mind up independently.
Yes.
It includes having courage and having integrity. Now, against that background, I would like to refer to three of the judgments that you referred to in your application. The first is the Morudi judgment, which the Deputy President has already referred you to. The second is the Harilal judgment, and the third is the Harvey judgment. Now, all these three judgments have three things in common. The first is that they're all judgments of the SCA. The second is, in all of them, you gave dissenting judgments, where 4 other judges formed the majority. And thirdly, in all of them, the decision of the majority which you differed with was set aside on appeal to the Constitutional Court. Now, against that background, Justice Molamela, perhaps I could ask you just to take us through how the process unfolds. Do you first seek to convince your colleagues that your way is the correct way, and at which point do you then reach the point of handing down a dissenting judgment?
All right. The first time you get to hear the views of other colleagues will be at our post-hearing conference. Okay, so after every appeal hearing, we have a post-hearing conference. But sometimes during the hearing itself, you can determine that it looks like we are not ad idem. It looks like there's going to be a split. But sometimes it's like that, and after our conference, we are all unanimous, you know, because we have managed to persuade one another. But sometimes you are not successful in persuading the others. So the process is that in the post-hearing conference, which we hold immediately after the hearing, which I think is a huge advantage because it's when all the arguments are still fresh in everybody's mind, we have that discussion, and every judge will then indicate the outcome that they think ought to be the one that carries the day. And every single one of us will give reasons why you think in a particular way. So whether you agree or disagree, you will give your reasons. If you agree, you will give your reasons for agreeing. Maybe those reasons are reasons that have not yet been mentioned by your other colleagues. And likewise, if you disagree, then you will give your reasons. And after you have indicated your view, your colleagues will, engage you just to find out where you are coming from in terms of your reasoning and so forth. And thereafter, then the conclusion will be that, all right, we'll wait for the designated scribe to go and write, because as a judge, you must always remain open to persuasion. So even though at the conference you felt that you held a particular view which differed from the other colleagues, you will wait until the first draft of the scribe has been circulated. And once that has happened, then you will know for sure whether you have been persuaded to follow the majority view or not. And if you are not persuaded, then you will write your judgment and hope that your judgment can still be persuasive. But you know, as you are writing your dissenting judgment, you are acutely aware that actually you might be the one that is wrong, you know. And but if you are of the view that this view that you hold of the matter needs to be put out there, needs to be expressed, you will express it nevertheless. In relation to the Harvey matter, it's something that pained me before the hearing. You know, I was thinking about it. During the hearing, I was thinking about it. And even after our conference, I was thinking about it. But what made me resolute in proceeding to write a dissenting judgment in that matter I was always saying to myself, but picture this situation where you as a parent have adopted a child, and this child does not know yet. I think in terms of the law, you only inform the child when or you are obliged to inform the child that the child is adopted at the age of 18. But now say this child is 16 and you have not yet informed the child that he or she is adopted, and the child is completely under the impression that he or she is your biological child, and none of your biological children know that this particular child has been adopted. And the next thing that happens is that your mother or your father leaves a will, and in that will, your mother or your father says, I leave all this property, I leave, okay, the mother has 5 cars, let's say, make that example, 5 cars, and there are 4 grandchildren. And the mother then says, I leave my 4 cars and 4 grandchildren. I leave my 4 cars to my grandchildren. And then the next thing that happens is that somebody decides, no, the adopted children are not included because they have not been expressly included in that will. How is that child going to feel, the one that is not going to get the car when the others get their cars? It's not the parent who has done this, it's the grandmother who has decided to do this. And for me, I just said to myself, there's no way this cannot be right. There's no way this can be right. So I read quite a lot about it, and in the end, I managed to find 2 cases that supported my view. And my view was bolstered, and then I resolved to write the dissenting judgment. But I must tell you also that there have been instances where after the conference, I thought, but I don't think I really agree with this particular view on this particular point. And when I get the judgment, the issue in question has been articulated so well and so clearly that I think, okay, no, I'm fine. I'm happy to go along with the majority judgment.
Thank you, Justice Malumila.
Thank you.
Thank you, Chief Justice.
Thank you, Commissioner. I think the last hand was Commissioner Nochesi. That would be the last one. Thank you.
Thank you, Chief Justice. In fact, Chief Justice, you can accept that all candidates, I will ask them this question.
Okay.
So you must just include me in your list.
Oh, okay.
Justice Manuel, it's just, I had no question for you mainly because I've read all the records, but there's only one question that has since come for one reason or the other. If you are, you sit at the SCA, leave to appeal is brought before you, you decide on that leave to appeal, is dismissed. Shortly thereafter, you are appointed to the CC. The same matter comes now as a leave to the Constitutional Court. Can you sit in that matter? And if you do sit, what are your obligations?
From my experience at the Constitutional Court is that you do not participate in that appeal. I don't know whether that has changed, but I know for sure that in 2015, the practice, let me call it practice, the practice was that if you were involved in the matter before, you will not participate.
Thomas, that concludes my question.
Thank you, Commissioner. We have come to the end of this interview. Have you got 3 or so points that you might wish to just emphasize to the commissioners before I release you? Or you are satisfied that all points have been dealt with properly?
There's one point that I want to talk about.
Yes,
Chief
thank you.
Justice. I think it would be remiss of me if I were to leave this room without touching on it. And I'm going to be very, very short. To say, if you have a look at section 174, subsection 2 of the Constitution, it says when judges are appointed, the need to reflect a judiciary, I'm paraphrasing, a judiciary that matches the demographics should be taken into account. And all that I want to emphasize at this point, Chief Justice, is that it's 28 years. I think this is the 28th year of our democracy. And the Constitutional Court, I think, is the court. No, I would be wrong. I was about to say it has the least number of judges in that there are only 11 judges. No, now I remember that there are less judges in the Northern Cape and in Northwest. But the point that I want to make, DCJ, is that I think it is lamentable that so long after the advent of democracy, when we have a section that expressly states that the need to ensure that the composition of the judiciary matches the demographics of the Republic, there is still no gender parity at the Constitutional Court. In short, my understanding of Section 174 is that the court, the Constitutional Court, I want to confine myself to the Constitutional Court. The Constitutional Court must match the rest of South Africa. If you look at the Constitutional Court, then it should be a reflection of our country, but at the moment, it is not, because there has never ever been a stage when that court had the same number of women or even more. And there was a stage, I think it was in 2014 or 2015, when the GDRU, Gender Democratic and Rights Unit attached to the University of Cape Town, lodged a complaint with the Commission for Gender Equality. And the complaint was related to the fact that there was no gender parity in the judiciary. The judge presidents were engaged, and I know, because it's in the public domain, there was also a letter from the JSC on the matter. And there was also a matter because the president of the country was also cited as one of the respondents. And in the end, on the 16th of May, 2016, a letter from the presidency was issued, in terms of which there was an acknowledgement that there was an urgent need to have gender parity in the judiciary. As to why that has still not happened up until now, I don't know. I will be quick to say I acknowledge that steps in the right direction have been taken, but I think that being 2022, we are at a stage where we should be there already, especially when you consider that you have among your candidates women that tick all the boxes. Experience, you name it, we tick all the boxes. We have experience, speaking for myself, I have experience at the Supreme Court of Appeal, which is an appellate court like the Constitutional Court, where I have been exposed to all the areas of the law. So I think back then, what was stated was that the pool was limited. But Chief Justice, I think you know too that the pool is not limited. The pool in relation to the appellate court is not limited because you draw from the High Court, where there are female judges already. You draw from the Supreme Court of Appeal, where there are female judges already. You draw from the Supreme Court of Appeal and you get a female justice who has been a judge for 15 years. So I'll just conclude by saying with all humility, Chief Justice, and all those who know me know that I'm a humble person. I'm saying this with all humility, that I think now is the time. Thank you, Chief Justice.
Just on that, before we conclude on it.
I'll let you say something. I think all of us as commissioners appreciate what you have just said, Judge, and we are aware of the situation. But two things maybe need to be said in connection with what you have raised. One is that, of course, the candidates who have made themselves available for these two vacancies, there are only two women who have made themselves available. In October, when you were interviewed, if I recall correctly, also it was only two women.
Yes, Chief Justice.
It might have been I think before that, in April, it was three women, I think. Judge Pillay was there as well. I don't know if it was more. So the point I'm making is I am concerned, and I'm sure it's a concern that all of us have, is why are women not making themselves available in bigger numbers than that. Maybe all of us as society need to investigate that and say, what is it that is not making it attractive to women to make themselves available for appointment to the Constitutional Court? But the other point I wanted to make is that the provision in the Constitution that you are referring to, of course, talks about gender and race as well. At the moment, the Constitutional Court does not have a single judge who is white, so who is appointed. I'm leaving out acting appointments. So I'm just mentioning that so that because it comes from the same provision in the Constitution.
Yes, of course, Chief Justice.
Yes, thank you. I think
if at least one woman, at least one woman can get the nod.
Are you thinking about the last time? I think Judge President Lekhodi wants to say something.
No, I wanted to say to the candidate that that is one question which I neglected to question you on, and I'm blaming it on you because you diverted my attention to social context sensitivity issues. So you have got yourself to blame that I did not raise it with you. That's all what I wanted to say.
But if I may ask, are you happy that I raised it?
I reserve my right to raise it.
Okay, no, thank you very much for availing yourself once again. We really appreciate it. You are now excused.
Thank you very much, Chief Justice and
Thank you.
Commissioners. Thank you.
We are at 8 minutes past 1. It seems to me that maybe this is when we should take lunch.
On the program there is lunch, but there is one more candidate.
Okay, let's take the lunch break. We are going to be back at 2:15. Thank you.
Oh, there we go.
I think we are all in. The next candidate can be brought in.
These might.
It's yours, it's best.
Good afternoon, Judge Rogers.
Good afternoon, Chief Justice.
How are you this afternoon?
I'm well.
Okay, I see you don't want to know how I am. You're not interested.
Then I'd have to ask everyone.
Well, I'll tell you anyway. I'm fine. Thank you very much for making yourself available for consideration for one of the vacant positions in the Constitutional Court. We really appreciate the fact that you made yourself available. I do want to make a disclosure that I encouraged you to make yourself available. I think you were not thinking of making yourself available. I did so because I think it is the responsibility of heads of court to try and encourage more candidates to make themselves available so that this body has a wide pool, a wide choice when they consider the filling of positions. Obviously, being encouraged to make yourself available doesn't carry with it any promise. But it is something that many years ago, Chief Justice Charles Carlson and heads, of course, took as the right thing to do to try and encourage more candidates to make themselves available. So I thought I must just make that disclosure. You, unlike the other candidates for the positions in the Constitutional Court who have been before this commission a few times already, you are coming before this commission in respect of the Concord for the first time, is that correct?
That's right.
Yes. With regard to the other candidates who have been to this commission in regard to positions in the Constitutional Court, we, or many of us, might not have had much to ask because we have interviewed them before. But with you, it's for the first time. I will ask you certain questions, and after I've finished, it will be an opportunity for the rest of the commissioners to ask you questions. Are you feeling comfortable? Are you comfortable?
Yes, as can be expected in the circumstances.
Okay, all right. I see that in terms of your academic qualifications, you obtained in 1982 a BA degree at the University of Cape Town, and you obtained it cum laude. Is that correct?
That is correct.
And that was 1982. And then you obtained in 1983 your BA honors from the same university. Is that right?
That is correct.
And then in 1985, you obtained your LLB magna cum laude. Is that correct?
That is also correct.
Yes. And you then served articles of clerkship at Sonnenberg, Hoffman, and Galombik from 1986 to 1987. Is that right?
Correct.
Yes. But after your articles, you didn't get admitted as an attorney, or you did get admitted before you went to do pupillage?
I did get admitted
Yes.
to preserve my right to practice as an attorney if I decided I didn't like the bar.
Yes. And then you started at the bar in 1988.
That is correct.
And you practiced as an advocate at the Cape Bar up to from 1988 to 2012. That's about how many years?
I think it was about 25 years.
Yes. But about 10 years into your practice as an advocate, 10 years or so, maybe 11 years, you obtained silk, is that right?
That is true.
Yes. So you obtained silk, I think, in 1999?
Correct.
And you practiced as a silk from 1999 up to 2012. And then you were appointed as a judge in the Cape High Court in 2013?
Correct.
Yes. And you remain a judge of that court to date, is that right?
That is so.
But in the meantime, you have acted in the Supreme Court of Appeal?
Yes, I think for 7 terms over a period of some years.
Yes. And you have also acted in the Constitutional Court?
I acted for the 3rd and 4th terms last year, yes.
Yes. How did you find that experience?
I'll be honest, I think I'm a hard-working person, and I've got a fair experience of High Court work, SCA work, and then I had 2 terms in the Constitutional Court. I found the work very interesting, but the pace of work was quite unrelenting. It's a grueling workload in comparison with the other courts. That was my experience, but at the same time, one is working with colleagues who were very collegial. I never felt when it came to legal issues that an acting justice's voice was less important than anyone else's. Debates were always courteous and friendly. And of course, the court is generally involved in constitutional or other legal issues of considerable importance. And that is intellectually satisfying in addition to being important for the administration of justice in the country.
Well, I'm going to say this, that when I approached you to invite you to come and act in the Constitutional Court, you seemed surprised. Is that correct?
I was surprised.
And your first response was you thought you didn't know constitutional law enough.
I'm not sure I would have put it quite as bluntly as that, but that I had conceived
You were very humble about, about your knowledge of constitutional law.
I did think that my experience was more generalist, plus I had some specialized knowledge in fields which weren't overtly constitutional, like tax and pension fund law and company law.
Yes. Speaking for myself, I think that during the time that you have acted in the Constitutional Court, I have seen you making very important contributions. Whatever thought you may have had that maybe you were not so experienced in constitutional law, I can say I didn't see that.
Thank you.
Yes. How many judgments have you been able to write while you were at the Constitutional Court?
I have written 2 judgments where I was the nominated scribe. The one was mentioned in my questionnaire, the Shiva uranium case, which was a company law case in the field of business rescue. The other judgment, which was reserved at the time of my questionnaire, was a pension fund case. I think that's item 16.5 of the questionnaire. That was reserved on 30 November last year, and that was delivered on 14 March of this year. Both of those judgments were unanimous judgments. I wrote the majority judgment in the first of the Electoral Commission cases, which we heard in September. That was at the invitation of one of the senior members of the court who formed part of that point of view at the time.
Yes.
And then I've recently written a majority judgment in a case where judgment was delivered a week or 2 ago, MVM versus Tembisa Hospital, on a jurisdictional issue. And then I also wrote a unanimous judgment in a case where there was not a hearing concerning the rescission of judgments taken through the registrar by the South African Revenue Service. That's Barnard Labuschagne versus SARS. Those are all now on the SAFLI website under the Constitutional Court database.
You referred to yourself earlier on as a generalist. You said you thought you were a generalist. I take it that that doesn't necessarily mean that there are no specialist branches of law in which you got involved even while you were in private practice, because I know you did some labor law work, so you would have got involved in some specialist branches of law as well.
Yes, in my early days at the bar, I did quite a bit of labor work, and you will see from my questionnaire that I did act for a month in the labor court quite early on.
Yes.
I specialized when competition law assumed importance in South Africa in the early 2000s. I became involved in that sphere, and I am a judge of appeal of the Competition Appeal Court. Income tax, or tax generally, was a significant part of my practice. And then pension fund law, I not only did pension fund cases, but sat as the chairperson of tribunals dealing with the apportionment of pension fund surplus, and then also company law more generally. And it so happens that the 2 judgments which I was asked to write in the second, third and fourth terms respectively happened to involve company law on the one hand and pension fund law on the other.
Yes. Now, in terms of your practice before you went onto the bench, would you describe your practice as also having been of a generalist nature? Or
Yes,
not really?
It was weighted towards those fields that I have now mentioned, but I did a certain amount of administrative law and other public law work. I did some delictual and insurance work. I didn't do criminal work, although as a judge I have done quite a lot of criminal work.
Yes. And then as a judge, in all the courts in which you have been, the High Court as a permanent judge, and also acting in the Supreme Court of Appeal, your judgments have covered, what kind of branches of law have your judgments covered, generally speaking?
I think it is a very wide field. I have given judgments on constitutional and administrative law matters, a fair number of review judgments, but I have given reported judgments in the criminal sphere, in company law, contract law, delict. I think it covers a very broad sphere.
Yes. And we have got here, you gave us in your questionnaire a list of reported cases in which you appeared as counsel while you were in private practice. Is that correct?
I'm not sure I did give you that, no.
Oh, I thought I saw it. You didn't give us that. But I take it there would be quite a long list.
Yes, as counsel in the law reports,
as counsel, yes.
I would have given that information, I think, when I was applying for position in the Western Cape High Court.
Yes, okay. But also you have given us in the questionnaire quite a long list of reported judgments that you have written in the different courts. Is that correct?
Yes, that's Annexure A to my questionnaire.
Yes, yes. And you said in the SA you acted quite a few times, is that right?
I think seven terms in all.
Oh, is that so? So
they weren't sequential. I think I acted for 3 terms and then for 2 and for 2.
Yes. Well, 7 terms would be like, if you put them together, would it be like 2 years, 1 term?
That's correct.
Yeah, yeah. Or maybe just under two years.
Yes, sorry, just under 4
yeah.
terms would be a year.
Yeah, yeah. Okay. Of your judgments that you have written in any of the courts, which one do you say, would you say, has made the most important contribution to our jurisprudence, if you are able to say?
I would probably say the third of the cases I mentioned in 16 of the questionnaire, the Nkata case, Carter versus First Rand. I say so not necessarily because it was the most complex or difficult of the legal issues, but it highlighted an aspect of considerable practical importance in all matters arising under the National Credit Act about the circumstances in which credit agreements which have been terminated because of default can be reinstated. And I was reversed by the SCA, but then reinstated by the majority in the Constitutional Court. And I know from experience in the High Court that it is a decision which has had a lot of practical effect on the way judges grant orders. I know in my own court I had a special form of order in bond default cases which built on this and accommodated a sufficient time period to enable debtors to potentially reinstate their agreements and so not lose their property. So I would mention that case.
Your judgment in the Constitutional Court in the Tembisa Hospital matter, how would you say it contributes to resolving the issue of jurisdiction in the Constitutional Court?
Yes. For the information of the commissioners, the question there was whether the Constitutional Court had jurisdiction in respect of a case concerning causation in hospital negligence where a baby had tragically suffered from lifelong cerebral palsy as a result of negligence. And it was a difficult question as to whether the causation issue in some way implicated the Constitution or a legal question sufficiently closely to engage the court's jurisdiction. What I did, I'm not saying it hasn't been done before, but I went back to the language of Section 167 and sought to base the jurisdictional outcome on giving a certain interpretation to the words, what is a constitutional matter, because that's the phrase used in Section 167, a constitutional matter, and the other jurisdiction is, does the case raise a arguable point of law of general public importance? And I sought to give an interpretation to what is a constitutional matter and when can a case be said to raise an important question of law. And I certainly utilized and saw myself as giving effect to judgments which the Constitutional Court itself had given. And in that, I don't think it was necessarily groundbreaking, but I think it gave a particular interpretational coherence to a number of disparate judgments which the Constitutional Court had given on that subject.
Yes.
And I may say that I think it is, when I first came to the Constitutional Court, I was a little bit frustrated at not being able to grapple with the facts of cases. Having come from the High Court and with my SCA experience, when one felt that a court lower in the hierarchy had gone wrong on the facts, there's a natural tendency to want to intervene and do something about it. But I had to learn that an apex court sitting with 10 or 11 justices can't be involved in a second or third reappraisal of facts. And sometimes potentially bad factual decision-making just has to be left alone. No system of justice can always ensure that every decision will be factually right. I don't wish to suggest anything about the Tembisa case itself as to what the facts would have, what a factual analysis would have led to if we had had jurisdiction. But I'm just saying that I think it is important that what the apex court deals with should be subject to limits. And if the framers of the Constitution expressly imposed limits on the Constitutional Court's jurisdiction, one should not necessarily seek to circumvent that in difficult cases by dressing up as a constitutional issue something which is just a factual reappraisal.
Yes, while you were at the acting in the Constitutional Court, did you get an opportunity of writing a judgment which declared some legislation unconstitutional?
No, I don't think I've done that.
But you sat in matters where another colleague wrote a judgment declaring some legislation as unconstitutional?
I actually don't think such a case served before the court in the third or fourth terms last year. I might be wrong, but I don't think that is so.
Yes. While in the High Court, had you had a chance of dealing with such a matter?
Yes. One of the cases, I think I might have mentioned it in my questionnaire, not necessarily in the list of 10 significant cases, but in tracing the fate of some of my judgments on further appeal. One was concerned with the search provisions in the Customs and Excise Act. Gertner, that would be in paragraph 16.4, the third bullet, Gertner versus Minister of Finance. In that case, I declared certain provisions of the Customs and Excise Act unconstitutional. The Constitutional Court upheld the declaration of invalidity, but whereas I'd given a more extensive reading in as to what would be an interim position while Parliament looked at the matter, the Constitutional Court gave a much slimmer or shortened version of the reading in.
Are you familiar with the doctrine of subsidiarity?
Yes.
Yes. Do you want to say a few words about it?
The doctrine of subsidiarity entails that where the Constitution envisages that certain fundamental rights will be the subject of national legislation, and the national legislation comes into existence, then if one wishes to launch an attack, if one wishes, for example, to say that one has been the victim of unfair administrative action, or that your labor practices, you have been subjected to an unfair labor practice, you should not ordinarily go back directly to the Constitution and base it on Section 23, for example, but to base it on the legislation which is intended to regulate those constitutional rights. And if the litigant considers that the national legislation doesn't do so satisfactorily, or does so in a way which is inconsistent with the Constitution, the proper course is to attack the constitutional validity of the subsidiary legislation.
When you dealt with the matter in the High Court in which you declared legislation constitutionally invalid, I guess that you would have dealt with a Section 36 analysis as well?
The proportionality?
Yes.
Yes.
Yes. Okay, all right. I'm going to now allow commissioners to put questions to you, and largely when they put questions to you, they will be seeking to satisfy themselves whether the information you will give them enables them to see how your appointment would meet the selection criteria that this commission has previously adopted and uses. I want to read all the criteria, but they include the question whether or not a candidate has integrity. They include the question whether or not you have the necessary energy and motivation, and whether you are a competent person, and that is technically competent, and whether you have capacity to give expression to the values of the Constitution. It will also, the criteria also include asking the question what message your appointment would give to the community at large. I will now allow commissioners who wish to put questions to you to do so. I'm looking around. Commissioner Dodovu.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon. How are you?
Very well. I reckon that you have presided over high-profile public cases which attract very, very much interest to the population of South Africa, like the elections, like football and all of that. How do you describe your judicial temperament?
I'm the sort of judge who engages with counsel in argument. I don't sit silently and then come up with a decision at the end. I think I'm generally regarded as courteous and polite, but I can be quite vigorous in engaging counsel, and precisely how one undertakes that exercise will depend on the experience of the counsel, because one doesn't want to browbeat a junior practitioner, but if you have a senior experienced practitioner, they enjoy a debate, and I knew from my own time as an advocate, if I went to the appellate division or the SCA and spoke for 15 minutes and didn't hear anything, I was like a lost ship at sea. I'd rather debate issues.
Okay, the second and last question. You declared certain laws, including the correctional service law, unlawful, and that judgment was upheld, for example, by the Concord, where they made a declaration of invalidity in terms of Section 172 of the Constitution. And once that happens, normally they refer the matter back to Parliament for consideration, and that they prescribe that Parliament must take 18 months or 2 years to finalize the legislation. In your view, do you think that is sufficient? I'm speaking as a member of Parliament, and once that happens, we run around, spend sleepless nights, especially when it pertains to Section 74 bills or Section 76 bills which require the concurrence of the provinces. Do you think that 24 months is sufficient in that respect?
I'm not entirely familiar with every process which Parliament has to follow, and that it's not only their processes, but what other calls there are on parliamentary time and what other legislative business has to be dealt with. I suppose at the time that the court is seized of the question whether it should suspend, and if so, for how long, I think it would be for the responsible minister or ministers who are cited for the state when legislation under their aegis is being declared invalid to put up the evidence as to what a likely timeline for dealing with it is. Otherwise, the court may be left in the dark. But I can understand that there might be instances where 24 months might not be enough. In the case of the search and seizure provisions in the Customs and Excise Act, which was the one which I declared invalid and which was upheld by the Constitutional Court, that followed a number of other cases where that was one of those interesting cases where Parliament could look at some of its other legislation where it had got it right and use that perhaps as a model. But they just hadn't caught up in the case of the customs legislation.
In the interest of time, it's okay. Thank you very much, CJ.
Thank you very much. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge Rogers.
Good afternoon.
I'm this side, on your right.
Oh, sorry, yes.
Judge Rogers, in your publication, High Fees and Dubious Practices, you seem to acknowledge that high fees are an impediment to access to justice, especially for the poor. Could you just summarize and take us through your thoughts as captured in this publication?
I was particularly concerned with the fees of advocates. That was something of which I had personal knowledge. And I didn't understand how many people could afford the very high fees. Now, just from my personal perspective, I thought however good an advocate is to be, of course I'm a bit out of that game now, but at that time to be paid 20,000 or 24,000 Rand a day seemed a great deal of money, however good you were. So I thought the basic level of fees was too high. I also thought that some of the practices which had crept into the way advocates charged tended to exaggerate that, because you've probably heard of this thing called collapse fees. You reserved for say for a week in a month's time, the case is going to run, and then it gets settled. And council have negotiated themselves a collapse fee where they get paid for the full week or for 2 or 3 days, even though the case doesn't run. I personally was opposed to that. I can understand that if a person really takes themselves out of circulation for a long time, you might have to have some collapse arrangement. But I never found in my practice that if a case settled, I didn't have something else to do on that day. So I thought collapse fees were a bad thing. And then I also thought the tendency, it wasn't so much in the Cape, but I think it was and might still be followed in Johannesburg, of junior counsel tending to charge 2/3 of the senior advocate's fee tended to drive up fees. So even if the junior's normal rate might have been 5,000 Rand a day, if 2/3 came to 9,000, he or she would end up charging that. But to be honest, when it comes to access to justice, I suspect that even if advocates' fees were more moderate, even if you cut them in half, the indigent people can't afford to pay that. And access to justice then depends on legal practitioners firstly being willing to do a reasonable amount of work pro bono, and then it obviously also depends on adequate legal aid, a legal aid system.
Thanks. My last question, Judge Rogers. What is the prestige which comes with having your articles cited as yours seem to be cited many times?
Yes, I'm not sure that I haven't followed it. I'm not sure my articles are cited that often. I know quite a few of my judgments are cited subsequently as precedent. I don't know, I suppose it's human to be pleased that other people have found what you have written persuasive or useful, but I haven't particularly tracked how my legal writing outside of judgments has been received. I do know one or two Labour Court judges, for example, referred to my article about high fees. I think I was criticised rather than praised for what I said about silk. So it hasn't always been on one side.
Has your views changed about silk now?
They haven't, but I've given it up as a lost cause.
Thank you, Judge Rogers. Thank you, CJ.
Thank you very much. Commissioner Muiman.
Thank you, Chief Justice. Good afternoon, Mr. Rogers, Judge Rogers.
Good afternoon, Mr. Muiman.
Just one question from my side. In certain corners of the NGO, there has been a reflection on the critique of our constitutional democracy and a silent yearning for a return to parliamentary democracy, which characterized our system of governance prior to 1994. Do you think that that could be a cause for concern for the return to, if one is to parallel what was said by Malan, D.F. Malan in 1952? Allow me just to paraphrase what he said. It was in response to a call to set aside the law that the National Party passed to remove a colored from the common voters roll. Malan said as follows: if the court should declare this act of parliament invalid, it stands to reason that it would be a serious matter for parliament and for the country. It would mean the undermining of parliament's sovereignty. It would mean that the judicial authorities would assume powers belonging exclusively to a legislature. What is your view with regard to that? Thank you.
I think the Constitution as the ultimate source for the power to declare a law invalid, it mustn't itself be viewed as just any law. It is a very special foundational law sitting above all of us in all three branches of government. And I think that one is not, if courts properly recognize the limits on their powers without intruding into policy-laden choices about legislation or about executive decisions, then the power in those cases where plainly the Constitution has been infringed is essential if we are to have a constitutional democracy. I suppose whether as a matter of personal choice politically one prefers to live in a constitutional democracy or a parliamentary democracy depends on who you ask. It is possible that people who are in the majority will say, I like a parliamentary sovereignty. But I think in a country with a history like ours, where one doesn't have an homogeneous population, where one has enormous tensions which exist because of a long and ghastly history, I think to hand power back supremely to a parliament uncontrolled by a constitution would be dangerous, and we know what was the result of parliamentary sovereignty in an apartheid regime, or in fact until 1994.
Thank you. The last one from my side. One of the cases that you referred to is the Central Energy Fund a matter that involved 10 million oil barrels. What was the rationale behind setting aside the sale? I'm raising it in the context, within the context of the crisis that is beginning to emerge around oil, given the battle between Ukraine and Russia. Thank you.
I don't want to say too much about it because I know the case was argued in the SCA and judgment is pending, but that was a case where I'm not sure how much you have read about or if you've read the judgment, but it was a case where there was a significant delay on the part of the Central Energy Fund and the Strategic Fuel Fund in bringing their self-review, which is what they did. They sought to apply to set aside the disposal of the oil barrels, so they had to overcome a significant delay. But on the other hand, there was a principle which the Constitutional Court had formulated to the effect that even in the case of a significant and unexplained delay, if the violation of the law is so clear, one must intervene to set aside. And the big question there was, well, what about the financial consequences? I think it turns out nobody could have guessed back in whenever that was, it's slightly more than a year ago that I gave that judgment. At that stage, I think it probably turns out better for the CEF that it was set aside, because with oil prices at $115 or $120 a barrel, even if they have to pay a lot of money to the people who had the oil and then had to give it back, I think they're still a lot better off than having to replace all the oil at $120 a barrel.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you, Justice Betzer.
Thank you, Chief Justice. Good
afternoon,
afternoon,
Judge
Justice
Betsy.
Rogers.
Yes.
I will not seek to question your attributes as a good judge, such as experience, scholarship, dignity, forensic skills, and the capacity for articulation, diligence, integrity, objectivity, and energy. But I have two propositions that I want to put to you and then invite you to respond to them. As you would know, the Constitution deals in Chapter 8 with courts and administration of justice. You touched upon that earlier. Section 167, which establishes the Constitutional Court, confers the jurisdiction on the Constitutional Court, and then there's Section 167(4), which confers exclusive jurisdiction on the Constitutional Court. And if you come then to Section 168, establishing the Supreme Court of Appeal, the Supreme Court of Appeal can entertain any and every case which falls outside of the exclusion stipulated in the Constitution, which then means that it has, a wide scope of cases that it does. And I was made to understand that this is what was closest to your heart. Hence, you made yourself available for a vacant position in that court. How do you wish to respond to that general proposition?
As the Chief Justice disclosed at the beginning, I was invited to put my name, or asked to think carefully about putting my name forward, and as he says, without any suggestion that it came with any expectation that I would get the nod, as it were. I thought about that, and I also spoke with Justice Meyer before reverting to the Chief Justice, or the ACJ as he was then, about his invitation. And I came to the view that not only was it an honor to be invited, but that I should try it out to see how I experience life at the Concourt, if only for 2 terms. I found there that, firstly, I didn't feel out of my depth in the matters that were truly constitutional or public law. I saw that there were, in fact, important contributions which a generalist lawyer could make, and which I think I have made during my acting stint there. As I said, it's a very hard-working court, but of course everything it does, or just about everything it does, is important. As against that, the SCA certainly has a wider jurisdiction, and, for example, it enables you to grapple with facts, and I've never been a judge who shies away from dealing with the facts of cases and trying to confine it to law. I enjoy mastering the facts of cases, and the SCA allows you to do that. There's less scope for it in the Constitutional Court. But as against that, the SCA is not the final word on the matters of greatest importance to the country. Normally it will then go further. And as you will know, interspersed between the interesting matters which the SCA hears are a number of fairly mundane or humdrum cases. And I think that is largely a consequence at the moment of the fact that whereas the Constitutional Court has almost exclusive control over what cases it hears, and therefore makes sure that it only hears important cases, the SCA, about half of the cases that it hears are cases where leave was granted by the High Court. And often, as you will know from experience, leave is given where perhaps it shouldn't have been given at all, or where it should have been given to a full court. So I can see ups and downs. From a purely personal point of view, I can see aspects of Constitutional Court work which I enjoy, and aspects of SCA work that I should enjoy. And having been encouraged by the CJ, and I should also say several other people urged me to think carefully about it, I take the view that if what I have to offer is thought to be useful and valuable to the Constitutional Court, I should not hold back just because there might be aspects of SCA life that I would prefer. It is not purely a personal matter. All I can say is that I believe I could find work in either of those courts invigorating, but intellectually, the Constitutional Court has the advantage of being decisive in shaping the law in a way which the SCA only does where its judgments are not taken on further appeal.
Thank you. And you did mention earlier on that you acted at the SCA for 7 terms and 2 terms at the Constitutional Court. And I'm looking at the letter of nomination by Professor Hugh Coder, the unnumbered penultimate paragraph, which says his service as an acting justice of appeal, that is at the SCA as well as on the Constitutional Court of late, will have allowed him to assess his suitability for the role and his colleagues to experience the value which he will bring to the latter court. And my reading and understanding of that sentence is that you have now decided to ditch the SCA and nail your brightest colors to the Constitutional Court mast.
No, I think the answer I gave to your previous proposition is the correct one. Of course, that choice would have confronted me if, in this round of interviews, vacancies had been advertised both in the SCA and the Constitutional Court. That is not the case. I have been encouraged to consider making myself available for the Constitutional Court. It is quite conceivable if my experience thus far of the Constitutional Court being a more grueling workload were to remain the case, that I might have a slightly more restful time if I were to rather not have put my name forward now and perhaps applied next time when an SCA vacancy became available. But I don't think that's what it is about. I think the question is, a candidate comes here, offers or tries to explain what he has to offer, and then it's for the Commission, or in this case, ultimately the President, to decide whether one can add value to that court. And it's a duty I'm willing to perform in either court.
Thank you, Justice Rogers. Let us leave it at that. Thank you, Chief Justice. I have no further questions to Justice Rogers.
Thank you, Justice Spetzer. Let me say 2 things which might be consolation to you arising out of your question to Justice Rogers. The first one is that when I encouraged him to consider making himself available, he didn't immediately say, yes, I will make myself available. He wanted to reflect. He did indicate that he had been thinking about the SCA. And ultimately, he said, well, he might make himself available for both. That is assuming that there was a vacancy. So I think the SCA was not far from his heart. But the other point I want to make is that he's not the only judge that I encouraged to make himself or herself available. There is another judge that I approached and asked to make themselves available, and I was turned down. And that judge is in the SCA. Thank you very much. Commissioner Lucas.
Thank you very much, CJ. Good afternoon, Judge Roger.
Good afternoon, Ms. Lucas.
I was looking at your profile a little bit, and I'm going to ask you the same question that I asked one of the candidates earlier, and that is whether you believe that there is a term like judicial activism that exists. Is there any maneuver for a judge to apply the activism in his approach to any case that is coming in front of him?
I suppose it depends precisely what one means. But if by activism one means, as it were, some agenda one has in advance of an issue presenting itself to you before the issue actually presents itself to you. In other words, you have a view of an end result you'd like to achieve, and you use the cases that come before you to achieve that result, I would not approve of that. The oath of office is that you will, a judge will apply the Constitution and the law without fear or favor. And I think I actually marked up the passage in the judicial oath, because it seems to me that it's the only criterion which a judge needs to bear in mind when any case comes in front of him or her, and that is that I swear that as a judge I will be faithful to the Republic of South Africa, will uphold and protect the Constitution and the human rights entrenched in it, and will administer justice to all persons alike without fear, favor, or prejudice, in accordance with the Constitution and the law. And of course, there are a lot of constitutional court judgments which build on that and tell you how you interpret legislation, how you go about a proportionality analysis. It seems to me that if one uses that judicial oath as your guide, one shouldn't need to categorize oneself either as activist or pacifist.
No, it's fine, CJ, because if I ask my other questions, it might take some time.
Okay, no, that's fine. Thank you. Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge Rogers.
Good afternoon.
My first question is going to be a follow-up to a question asked by Commissioner Dodovo earlier on, and I was very pleased that you spoke about fees, because I wish to submit that to a large extent, access to justice in our country is influenced largely by affordability. And if it was not for legal aid, then many people would find themselves in prison for sometimes crimes that they may not have committed. Now, having said that, you know, we as political office bearers in our parties find ourselves also bearing the brunt of high fees. Because in some cases, you know, I'm the Treasurer General of my party. You know, I've had to pay up to 50,000 rand for Silk not even appearing on the day because the matter was adjourned. And when you question it, they say, well, the day was booked off. And your response was, you can find many other things to do on that day. So I'm appealing to us, Chief Justice. Which body? We've got the bar here, we've got representatives of the attorney's profession. Which body can look at this? For South Africans to benefit from justice, access to justice in our country. Because it's a terrible thing when you have to pay that kind of money and nothing happens on the day. So I wonder how you would respond. What advice can you give to us as a JSC and to South Africans on what should be done about this matter? Thank you.
With your permission, Chair. With your permission, as you respond to that question, you might have regard to Section 35 of the Legal Practice Council, in terms of which rules will have to be made to determine and control the issue of fees, which has not been done as yet.
Yes, I suppose before 2013, I would have had to be more concerned about what my colleagues thought of me. But there is the pro bono route for the truly indigent, but what you're talking about, and I can understand it, when one is dealing with government departments or SOEs or political parties, I suppose there is a sense, well, they've got a sufficiently broad funding base that they can pay. And the answer may very well lie in proper regulation. But it would have to, I don't know if research has begun on potential regulation pursuant to Section 35. As you will know, in other environments, price regulation doesn't always work, or it can sometimes have perverse results. But I think merely wringing one's hands and encouraging people to be more reasonable may not achieve the result. So it may take some form of regulation.
Thank you. Chief Justice, through you, I don't know if the Minister would think that this is a matter for the Competition Commission to look at. And I'll leave it at that on the matter of fees. Having said that, one of the criteria I think that commissioners need to look at, and I say this with respect to all my colleagues that are here, one of the criteria that we have to look at is judicial temperament. And I can recall in 2019 when SCA President Justice Meyer had questioned you, Justice Rogers, on your appointment before the SCA, where certain criticisms were leveled against you, of you being arrogant, quote unquote arrogant, of you being high-handed, quote unquote, difficult to work with. And you did say in this interview as well that you set high standards for yourself, which is absolutely 100%. But I think your response at that time in 2019 is that this is something that you would work on. I just want to ask you, have you worked on this kind of aspect, or do you think those allegations were unfounded at that time? Or, you know, were there allegations that you needed to deal with, and have you dealt with it over the period of time from 2019 to now? Thank you.
Yes, I think Justice Meyer was perhaps passing on a little bit of feedback from unnamed persons, which was a bit difficult to deal with. One doesn't know to what extent that on a particular occasion was fueled by, if one ended up dissenting or disagreeing with a person on a case that you had heard. My own experience with colleagues in the SCA did not accord with that criticism, but what I found distressing was that there would have been any people who would have perceived it that way, because I don't see myself as arrogant. I think even before then, but since then, I attempt to interact with all colleagues in a way which doesn't convey anything of that kind. And obviously, I'm not going to go into names, but there are many colleagues on the SCA who commissioners could talk to, who I think would refute that notion, and not necessarily the strong-minded people or the most forceful personalities, but the sorts of people that perhaps might be more susceptible to arrogance, and that is just the opposite of the feedback I have got from them.
Thank you for that. Chief Justice, the next question.
Chief Justice,
sorry.
Follow up.
Who is?
Minister Lamola.
Oh, okay. Right. Okay, Minister. Follow up.
I'm not sure if Councillor Commissioner Singh is done. I wanted to follow up on the access to fees.
Oh, okay. Maybe shall I just put you on the list here?
Yeah, no, that's also fine.
Okay.
I just have one question more, Chief Justice. Okay. And I don't know if I could ask this question, because this matter that, we all know about publicly could be before the small JSC. And that is the investigation and the conduct of some judges vis-a-vis Judge Mushtaq Parker. I don't know if it's still before the small JSC or not, or could Judge Rogers be asked a question in that regard?
Well, I don't know anything about it. Maybe if you are in doubt, if you can maybe leave it out. It just depends. I don't know anything about the matter you are raising, so I'm not able to guide you.
Okay, what I read somewhere, Chief Justice, was there was an issue of judicial misconduct leveled against certain judges because they didn't want to share a bench with Judge Mushtaq Parker. Now, has that matter, yes, has that matter been resolved or not resolved, or is it still under investigation? So I wouldn't want to ask Judge Rogers directly if the matter is still being looked at by the...
I'm not up to date about it, so maybe you don't ask.
Well, I can put the...
Oh, unless Judge Rogers knows.
I'm happy to put Mr. Singh's mind at rest. The only complaint that was lodged against a group of 10 High Court judges was, as I understand it, by Mr. Makwakwa, and that was dismissed. Well, I can't remember how long ago, but a long time ago. It was before my last interview. It was certainly more than a year ago. There is a pending complaint by those 10 judges against Judge Parker, and that is the subject of a judicial conduct tribunal into Judge Parker's conduct. But it's not into the conduct of myself or any.
No, thank you very much, Chief Justice. Thank you, Judge.
Thank you. I said I couldn't remember what that matter is about, but when Judge Rogers responded, I thought I might know about it. I hope I was not involved. But there are so many of these matters, sometimes you forget that you were involved in one or other of them. But thank you. I'm going to take Commissioner Nochesi now. After that, I will go to the commissioners who are attending virtually.
So you have forgotten me, CJ? CJ, you
Sorry?
have forgotten me.
No, you are 2 lines down.
Okay, thanks.
Yeah. It's you, then it's Commissioner Baloyi, then it's Commissioner Baloyi, then it's you.
Thank you, CJ. The Chief Justice greeted you on my behalf as well. Don't think I don't want to greet you. I think I have only 2 questions, very short. One, in your interpretation of Section 174(2), which talk to the need for the judiciary to reflect broadly the racial and gender composition of South Africa, and so forth. Would you agree with me that in that broad statement, we must build into it geographical spread, not simply to limit it on the question of race, gender? It must include the geographical spread in that court, that is in particular in any court, but in this case in the Constitutional Court.
I see the injunction in Section 174 as directed to the judiciary as a whole. Mm-hmm. It is not in terms an injunction that each court must be a microcosm itself containing that particular balance. Mm. I think if one honours broad racial representativity, that may give rise to the geographic spread. I haven't previously thought about the notion that independent of racial and gender issues, there should be a geographic representativity, although I suppose I could say from Cape Town that perhaps it's Cape Town's chance. But,
All right.
But can I say something, because it did occur to me, obviously I knew it would be of interest and concern to the Commission, as it always is, that injunction in Section 174(2). And my own view is that that's a policy matter that the Commission decides, but my own view is that the Constitutional Court is a small court. It's very important, but it's only 11 people. It's the apex court. And I almost think that judicial excellence, coupled with a commitment to constitutional values, should be the most important criteria, so that, it struck me looking at, obviously I know who the 5 remaining candidates are, and ultimately it will be if 5 names go forward, it's the President's decision, not the Judicial Service Commission. But it didn't seem to me that whatever configuration of choices were made, assuming 2 people were appointed, whether they were 2 black people or 2 white people, 2 women or 2 men, if the guiding principle was who can make the best contribution at that court in the interests of the country, to say, well, we will not appoint that person because we would prefer, say, a 6-5 split gender-wise or a slightly different split racially. And I accept that that might result in no white people being appointed if that's the conclusion to which one comes. I just think a court of 11 justices is too small, and it is, in this case, too important to allow anything along the lines of a quota to determine who goes onto it.
The last question. If you are in the SCA, matter served before you, say an application for leave to appeal, you dismiss that leave to appeal at the SCA. The following week, you are appointed to act at the CC. Same matter comes to the CC once you are there. Would you preside in that matter?
No, it's happened already, and any judge who was part of an SCA panel immediately withdraws from a consideration of that case.
Thank you.
Before I move on, I just want to make sure that I did not misunderstand you when you said something about the Constitutional Court being too small. Would you care to just repeat the proposition?
Yes,
in the context of the section of the Constitution that Commissioner Nochesi raised with you?
Yes, I wasn't suggesting that there should be more than 11 justices. What I was indicating as a personal view, but recognizing that this is a policy decision rather for others to make, not for me, that in a court where there are only 11 people, the ability to get a broad representativity is compromised because you only have 11 positions to work with. And you are working in a court with a court which is the apex court, where I don't think people would generally disagree that you would want your best judges in that type of court. And all I was suggesting was that if, in the current circumstances, the lodestar of the best judges for the court were used, I do not think it would be retrograde from a constitutional point of view whether that resulted in 2 black candidates, 2 white candidates, 2 women, 2 men. One can do the maths. The court there won't be an equal representativity. There will be some and a significant representativity, but given the current composition of the court, I do not consider that the precise makeup of the 2 people that are now appointed, if 2 are appointed, makes a material difference.
Excuse me. Let me ask this question to make sure I know what you don't mean and what you do mean. Is what you are saying that because this is the apex court of the country, it should not matter if all the judges were men and there were no women, and it should not matter if all the judges were black, there were no white judges, and it should not matter if all the judges were white and there were no black judges? And it should not matter if all the judges were women and there were no men.
No, I don't want to suggest that. It's against a backdrop where currently there are, I'm trying to think, are there 8 permanent members of the court currently, all of them black and I think 3 of them women. And if Justice Meyer, as the President has foreshadowed, were appointed as the Deputy Chief Justice, one would then have 9 black people and 4 women. In that context, I'm saying how you appoint 2 further members to that court isn't going to make, if one used who can make the best contribution rather than striving to achieve, as it were, a quota, then I personally would think that judicial excellence and contribution to the court would be more important. I don't for a minute suggest that in this country we could have a court of 11 white justices. And also in all things being equal, as it were, between candidates, I can readily see that achieving the representativity would be would come to the fore more strongly.
So are you saying that as long as the judges appointed were excellent, the rest should not matter much? Or are you saying the excellence is important because this is the apex court, but all steps should be taken to make sure that there is a representativity in terms of race and gender? I just want to make sure that
yes,
we don't finish this interview without me being sure what you were saying.
Yes, because I don't sit and have never sat on the side that you sit on, the Commissioner's side, having to work out what policy one adopts. I am just expressing a personal opinion, and the practical reality is that we sit with a court currently composed as it is. What I was indicating is that to strive, say, for a 50-50 split between men and women, or a precise racial representativity, that's already not the case based on, personally, if you ask me, if you or ultimately the President considered that the 2 persons who could make the best contribution to the court were black persons, whether they were women or men, I wouldn't say that that was wrong. And by the same token, if the reverse were true, I think given the current composition of the court, the mandate in section 174(2) is not materially affected by whether the person's, any configuration amongst the current candidates you've got. That's just a personal opinion.
So you confine yourself to the current situation and in regard to the 2 vacancies?
Yes, if you were starting from scratch, I don't suggest you would, if this was the very first court to be appointed, that you would say, well, it's not of concern that one doesn't have any women or one doesn't have any white people or any black people on the court. I think.
Would a constitutional court that consists of men only be acceptable to you?
No.
And would a constitutional court that consisted of one race be acceptable to you?
Probably not.
Okay, I'm going to go to the commissioners who are attending virtually before I come back. When I come back, the next one will be Commissioner Baloyi, Commissioners who are attending virtually, is there anyone who wishes to put a question to the candidate?
Chief Justice, it's Glynis Breitenbach.
Yes.
Thank you, Chief Justice. I have no questions. Thank you.
Thank you very much, Commissioner Breitenbach. Any other commissioner who wishes to either indicate one way or another attending virtually?
Chief Justice, is Julius here? I don't have any question.
Thank you very much, Commissioner Malema.
Chief Justice, no questions on my side.
Thank you very much, Commissioner Barnard.
Chief Justice, no question from my side. Have been covered.
Thank you very much, Commissioner Shabango Ndawe. Commissioner Baloyi.
Thank you, CJ. Good afternoon, Justice Rogers.
Good afternoon.
Yes, you've referred to the most recent case that you wrote of the Constitutional Court, that is the Barnard SARS matter. And that matter related to or raised the issue of the rescindability of your so-called tax judgment. Now, and please correct me if I'm right, my recollection is, or in fact maybe you do say so in the judgment in paragraph 1, that the first judgment that was delivered in this matter was withdrawn by the Constitutional Court, and then you issued a new judgment. Is that
yes,
is
that's
that
correct?
Yes. Now, it's often said by judges that judges account to the public through their judgments. So if you want to know what the thinking of a judge was, why certain conclusions were reached, you look to the judgment. You're not going to get an explanation outside of the judgment. Now, in paragraph 1, the question of the judgment being withdrawn, the first judgment and then being replaced by a subsequent judgment, the best explanation that there is in this judgment is in paragraph 1. It says, you say that, well, firstly, and that's an important factor, I think, you say it was decided without an oral hearing, so there was no public hearing where we could go and see the transcript and see what happened in court. And then you say shortly after delivery, the judgment was rescinded by the court of its own accord when it emerged that the Revenue Service had filed written submissions of which the court was unaware. And then you say the judgment which follows takes account all of the written submissions. Now, for a reading public, the first curious question is, what does it mean the Constitution, this panel of judges was not aware of these submissions, right? And there's no explanation in the judgment. But, and as I've already said, that there is no transcript or public record to see what accounts for this. And then what then raises concern, if you like, for lack of a better word, is those that were fortunate enough to read the first judgment before it was withdrawn become aware that, in fact, the conclusion, and you can correct me if I'm wrong, the conclusion in this judgment is exactly the same as you had reached in the first judgment. And it raises an interesting conversation of what does it mean? Does it mean, do they even consider these written submissions after they became aware of them? So there are issues. The issues are that there is no explanation why the panel didn't become aware of these submissions. So there's no account for that. 2, how do you assure, and you don't in this judgment, assure the public that whatever was submitted, whatever we found later on, which resulted in the withdrawal of the first judgment, was taken into account? It doesn't change our conclusion that we reached in the first judgment for these reasons. They're simply lacking an explanation of that. That comes across as a lack of accounting to the public for this decision of the judgment, at least to this fault that the first judgment didn't take into account any submissions. What do you want to say to that?
If you are saying that there should have been a fuller explanation of the administrative oversight which resulted in the members of the court not being aware of the submissions by one of the respondents, I suppose that's a matter of opinion. I would have thought it self-evident, though, that if a judgment is delivered and it immediately becomes apparent because one of the parties remonstrates, they said, but you've now said in this judgment that we didn't file submissions, and we did, and you discover that, in fact, they did file submissions, the judgment can't stand. That seems to me self-evident, and Rule 42 envisages a rescission under those circumstances. The administrative oversight, I suppose a fuller explanation could have been given. The 9 or 10 members of the court who signed on the judgment thought that explanation sufficient, but if you wish to know, it was an oversight in the general office, the administrative office, in that my clerks had twice checked before the judgment went out with the general office whether the first respondent had filed submissions, and were told that they had not. And those were the circumstances in which the judgment came to be delivered. But the important point was that, for whatever reason, the judgment had been given in ignorance of one party's submissions and couldn't stand for that reason. The second point is that if one compared the first and the second, the withdrawn judgment with the judgment which then followed, you will see that all the additional points which were raised in the heads of argument, of which the court was originally unaware, were dealt with. So there's significant new material in the final judgment which specifically addresses the written submissions that were overlooked and deals with them and meets them head on.
The point, Justice Rogers, that I'm making is the panel of judges that sat here, they know and understand what happened here. The parties that were before you, they understand, or that made submissions, they understand what happened. But for a reading public that sees this paragraph, it seems to me that it is the lack of an explanation puts you, basically puts in the firing line of criticisms but the court doesn't account for what happened here. I think, to speak loosely, it seems to be put under the carpet or swept under the carpet what happened. That's the only point I'm making. The second question, my second question, relates to your article that you referred to, which is the ethics of a hopeless...
Well, maybe, Commissioner Baloyi, before you move to your next point, I must just come in to confirm what Judge Rogers has indicated about what happened in that matter. It was brought to my attention, and the Secretary General of the Office of the Chief Justice has been asked to investigate, but the indications are that somebody in the Registrar's Office gave wrong information to Justice Rogers' clerks when they said there were no submissions filed by the particular party. And then the judgment was written on the basis that there were no such submissions, but that was actually wrong. But it was only discovered after. So I just thought I must just mention that that is the position. Thank you.
Thank you, Chief Justice. I think it does settle some concerns about accountability. Justice Rogers, the second issue is your article about the ethics of a hopeless case. Now, and as you correctly say, that article is referred to in the Labour Court case of Mashishi by Judge Van Niekerk. And fortunately for the applicant in that matter, he wasn't represented. Rather, he was represented, but the matter was not opposed. When in fact, in the tenor of the article of the judgment, it's clear that Judge Van Niekerk considers that such cases of hopeless cases being brought to court and therefore burdening the court role would, in appropriate cases, warrant cost orders or ordering that counsel or the representatives do not recover any fees. In this case, it wasn't applicable because there was no opposition to the application. Now, the concern that it raises, possible concern, is where do you strike the balance between discouraging what you refer to as hopeless cases and not discouraging parties who believe or individuals who believe that they have a triable case, misguided as they may be, from asserting their Section 34 right of access to the courts. And we're very much aware that new cases or new arguments come up when, in areas that have never been tested before. And there would be a popular sentiment that there is no case, it's a hopeless case, and yet ultimately it turns out even at the Constitutional Court that, well, there is a case after all that could be made on that, however unlikely it looked like. Now, firstly, it seems that the discouragement, especially to the extent that costs may be used to discourage people approaching court, would have an unequal effect. You may not be represented because your counsel or your attorney doesn't want to be marketed with personal costs. So you're better off going to court alone on your own because you won't meet the same punishment. That seems to be the possible consequence of the concern that you raise with hopeless cases. And yet, if you're not represented, you can approach the court and you're not going to be kicked out. You will be heard, you'll be dismissed in the normal course. Where and how do you strike that balance?
Yes, that is a very difficult question. I suppose one has to start with the proposition, does one accept or does one not accept that eventually a case may be so hopeless that it shouldn't be advanced? Because justice doesn't come at no cost. It may be that the litigants don't pay for the judges and they don't pay for the infrastructure of the court, but justice always comes at a cost to the public purse. And every case that is heard before a judicial officer either causes another case not to be heard or to be delayed in hearing. And it seems to me, therefore, that one must reach a point where one says it is simply wrong that the court should be open to even the hopeless case at a significant cost to the public purse and potential prejudice to the administration of justice for meritorious cases which should be heard. As to where to draw the line, and this isn't a new idea, as the article demonstrates. It does have some significant acceptance in other systems which follow or which have a similar adversarial legal profession to the one that we have. I think the article repeatedly emphasizes that what is not to be discouraged is a weak case. What counsel should not be precluded from doing is arguing a case which, although it is weak and although counsel thinks it will probably lose, can nevertheless be formulated coherently. But just to take an extreme example, assuming there is a constitutional court judgment which shows that the conclusion you're trying to reach is wrong, you just can't get there. And you can't get there without persuading the constitutional court to reverse its decision. And you're now in the High Court and you have no arguments as to why the Constitutional Court should reverse its decision. To take a case, and it may not even ultimately be argued, it may just be strung out to buy time until a certain point. But such a case is hopeless. If you cannot formulate a coherent argument where each link rests on some evidence that is available, on some legal principle that is arguably applicable, you are abusing the court system. And we just don't have the time and the money to allow the court system to be abused in that way. The dividing line between, I think, what you regard as, say, a case which is challenging conventional thinking. That's also the article. I quote a passage from of what another judge said. You can always put forward heterodox arguments and try to push the envelope. You can argue weak cases. And because you don't want to discourage people from doing their duty to clients by arguing even weak cases to the best of their ability, any cases which are penalized as hopeless must be very clear cases of hopelessness. But I just think that there is and must be such a line to be drawn somewhere. And that was the point of the article. And I set out various circumstances towards the end, which I thought demonstrated why such a point of view had a legal foundation in our own law, including in constitutional values.
Well, Judge Rogers, I do agree that there are the obvious hopeless cases. Really, the debate is always, where do you draw the line?
Yeah, no, I accept that, and if it stimulates a debate amongst people as to how it should be dealt with, that would be good. This was really just the upshot of as you saw, it came up in an advocacy training course, and it caused me to start thinking about it. Why did people think advocates could just go and waste court's time with hopeless cases? Didn't seem to me to be right.
Thank you. Thank you, CJ.
Thank you, Commissioner Baloyi. I now have only 4, and I think the 4 would be the last ones. Commissioner Klaba.
Thank you very much, CJ. Good afternoon, Justice.
Good afternoon. I'm sorry. Yes.
In fact, CJ, I've been covered by the previous commissioner.
Yes.
But I will not retire to back to my seat without raising this point.
Okay.
And amongst the extramural activities, you list music. And you say you are a member of the Vocal Assembly in Cape Town, and that you play piano, violin, and guitar. Would you teach the justices of the Constitutional Court to play piano and violin if this house they just ask you to? Thank you, CJ.
Thank you, Commissioner Klaba. Thank you. Commissioner Schlemmer.
Thank you, CJ. I think adding on to that, I might think it would be easier to make them sing rather than play instruments.
I have made judges sing. We did one at one of our Cape Christmas parties.
That's wonderful. Judge Rogers, I would like to know from you, with your experience now at the Constitutional Court, are there specific things that you would like to see changed in the way in which the court is running? We've heard over the last couple of months of delays in judgments. We have spoken at some of the sittings with some of the candidates concerning the number of judges on the bench, perhaps combining the SCA and the Constitutional Court. What are your views on this? And if you have any different views, please also tell us about them.
Yes, I haven't thought about the idea of combining the SCA and the Constitutional Court. I'm sure you've heard from the candidates who were interviewed for the Chief Justice position. One of the difficulties is that even applications for leave to appeal have to be decided by the full complement of justices in the Constitutional Court. That's one thing that delays matters. Another, that is very time consuming. Another is potentially, although I know colleagues don't necessarily agree with me on this, is that if it emerges fairly shortly after the hearing, there's normally something, a post-hearing notice circulated within a week. If it's apparent that there's a difference of opinion, rather than letting the nominated scribe complete their first draft and circulate it, to let people from both camps start writing so that second or third judgments don't have to wait until the first judgment has been produced. But particularly the applications for leave to appeal. Within about 6 weeks of being at the Constitutional Court, I got one of these windows on on my email server there to say that I needed to empty my delete box in order to carry on receiving emails. I had about 2,500 deleted emails in my delete box. And one can't be away from one's email for more than an hour or two, and they start building up because people have got opinions on things and you've got to process it. So I think cutting down the number of judges and maybe having leave to appeal matters dealt with by 3 justices. I do have ideas about the SCA, but that I think it falls outside the scope of your question.
With your permission.
Sorry, I should have mentioned one point, though, about promptness. One way is obviously to reduce the workload by not requiring all judges to participate in every application for leave to appeal. But I don't think one must overlook that ultimately the speed with which work is produced depends to some extent on judges themselves. And I think it is legitimate when people apply for positions to consider, does this person have a track record of producing work quickly?
Just one last question, if I may. Are all the Constitutional Court judges typing their own judgment, or does it have to go to a typist? I'm just curious about that.
My impression, I actually don't know, but I do mine with voice recognition and dictation, and I think there are a number of judges who do that. There are others that are very quick typists and type their own. I'm not aware of any that, as it were, send off dictation or handwritten notes to a secretary.
Thank you, CJ.
Well, I can tell you that I depend on my secretary for the typing of judgments. Minister?
Yeah, thank you, CJ. It's a follow-up on the access to justice question by Commissioner Singh. I'm not sure if you are aware of the report on Project 142 by the South African Law Reform Commission that was released on the 29th of March. So I'll assume you may not be aware, or you might be, but it speaks on the issues, what the report aims to do to address some of the major problems bedeviling the South African civil justice system, such that it takes too long to resolve legal disputes. The system excludes those who cannot afford to litigate in the courts. The average time it takes to resolve a legal dispute ranges between 3 to 6 years, and the legal fees have escalated to a point where the majority of people are excluded from the system of dispute resolution. The high cost of litigation in both civil and criminal matters is one of the main barriers to access to justice. And the questions that must be asked are, what are the factors that give rise to unaffordable legal services? What interventions can be devised to address these challenges in South Africa? So this report deals with these questions. I just want to get your view on some of these challenges and what is your view in terms of dealing with these issues of access to justice?
You're right, I wasn't aware that working paper or report had been issued, and I will track it down and have a look at it. The main emphasis appears to fall on fees and the cost of litigating. I suppose to some extent the cost of litigating is itself a consequence of the complexity of legal procedure. One might say, should one have a more user-friendly form of procedure that perhaps lay people could employ without needing lawyers, or which doesn't have all the complexity and delays built into it. But of course that form of procedure has been designed by and large to achieve fairness to both sides. When you start tinkering with it and trying to cut it down, you might then find that there are cases of unfairness that arise because the procedure isn't as comprehensive as it should be. I still think it is not realistic to imagine in the current legal environment or any highly professional legal environment that fees will come down to a level where the indigent person, or even the person of modest means, will be able to afford lawyers. The answer must lie in a significant dedication by lawyers to doing pro bono work and representing indigent clients without charging fees or on a contingency basis. I've been out of the bar for 8 or 9 years, so I don't know what the current state of play is of pro bono work. I know both the Legal Practice Council and does try to encourage it, and I think there are professional requirements for pro bono work, but presumably they're falling well short of what the country needs.
Yeah, no, thank you. With your indulgence, CJ, I have the second follow-up on the question of Section 1742, because I think you took him for some time on this question, but I feel like I'm still confused. I'm not sure whether I'm confused because I disagree with him or I just don't understand the response. So I just want to try once with one question. If I'm still confused, maybe other commissioners will help. I'm struggling to understand why it does not matter when we have got these 2 vacancies who you appoint to add into this issue of the racial and gender composition. While I get your point on that it's a judicial, it must reflect the entire judiciary and so forth, but I was struggling to understand why it does not matter, because these 2, if it is filled, it adds to that composition of the judiciary.
Yes, well, I was looking at the current composition of the court, and I was assuming, but I know one can't take it for granted, that the President makes the appointment of Deputy Chief Justice, which he has foreshadowed. My simple point was this, and I accept that you may not agree with it, but one then has a potential of, say, following any appointments which now get made, of a gender split, say, of 7-4, male, female, or a gender split of 6-5. What I was suggesting is that as between those 2 possibilities, if the importance of getting as close to a 50-50 split on gender should not, in an apex court, be so critical that one would not appoint a person who could offer the greatest contribution to the work of the court. In other words, I don't think the public looking at this court would say, oh, well, it's got 7 men and only 4 women, and therefore it's not a representative court. But I accept that this is just a personal opinion, that if all else were equal between 2 equally appropriate candidates, the one would result in a 6-5 split and the other a 7-4 split, I can readily understand that it would be in favor of the 6-5 split. Similarly, it didn't seem to me that from the point of view of the representativity and legitimacy of the court in the public eye, that it would make very much difference whether it consisted of 9 black persons and 2 white people, or 10 black persons and 1 white person. When the court did until very recently have 2 white persons, and I don't think the presence of Justices Cameron and Froneman on the court was thought to impair its legitimacy. So all I was cautioning against, or expressing a personal opinion, that when you've only got 11 positions to work with, one should not be so tied to trying to achieve absolute representativity that you potentially deprive the court of persons who could add more to its work. That's all I'm saying. I don't say that the court should not in a general sense be representative.
No, thank you, CJ.
Thank you, Minister. Commissioner Pillay.
Thank you, Chief Justice. Good afternoon, Justice Rogers.
Good afternoon.
Justice Rogers, one of the criteria which this body has to consider is whether the candidate is experienced in regards to the values and needs of the community. It's part of the published criteria. In your view, Justice Rogers, are you experienced in the needs of the community?
Only to the extent that intelligently following events, current affairs, reading newspapers, watching television, driving through urban spaces. In that sense, of course, it seems to me that when the needs of the community feature in an actual decision, that is the subject of evidence before the court. And it's not necessarily something which every member of the court must pluck out of their own experience, because one can never be certain that the community needs which feature in a particular case are those of which one has any particular experience or insight. It primarily lies in the evidence in the case, and then I think with respect, human compassion. I've enjoyed a relatively privileged background, but if I read about a community where people have to, at night, if they wish to relieve themselves, walk 30, 40, 50 meters to a pit latrine in dangerous circumstances, I can put myself in that position, I think, and have compassion. I can contrast it to my own position and try to understand what is involved for those people. But I haven't, for example, lived in a community which could be regarded as indigent.
But do you always require evidence, Justice Rogers? Are there instances where you could, for example, take judicial notice of what would be a likely outcome? For example, and I see you've kind of appreciated that these questions arise in the context of the Mediclinic decision and the Constitutional Court's judgment in Mediclinic, which was fairly scathing of your majority decision of the Competition Appeal Court. And specifically, I think if you look at paragraph 61 of the Constitutional Court's judgment, Chief Justice Mogoeng says the following: Additionally, the court treated and reduced the predicted and undisputed tariff hike to the level of insignificance. Lest we forget, to the overwhelming majority of South Africans, regard being had to our acute economic inequalities, even a 1% fuel or bread price hike probably constitutes a threat to their presumably shallow pockets and survival. And to the vulnerable group of uninsured patients, it is even more so, with the predicted percentage hike for healthcare services. It was therefore most unfortunate that in the plight of the 100 or 200 uninsured patients that received treatment from the Potchefstroom or Klerksdorp private multidisciplinary hospitals per year was not accorded and handled by the majority with the necessary sensitivity and concern that their vulnerability cries out for and deserves.
Yes, well, a judge in a lower court always has to accept on the chin the criticism that comes. One can't re-argue the case. I think as the minority judges in Mediclinic pointed out, and I think later the Chief Justice did, or the former Chief Justice, actually quoted the passage in my judgment in the Competition Appeal Court where I specifically said even the detriment to a small number of people would be an important consideration if they were a vulnerable group of people. That was specifically recognized. The important point was that the majority in the Competition Appeal Court in that case came to the view that prices would probably go up, not down. Or the prices would probably go down if the merger was approved. So the jury is out on whether prohibiting that merger is ultimately better or worse for the indigent community or the vulnerable community. The reason why the majority in the appeal court didn't find that the ultimate determinant was that on the facts we found that there would be no such detriment and that they would probably be better off, not worse off, if the merger went ahead. And it was in that regard that the majority in the Constitutional Court said, well, we didn't have a sufficient basis to interfere with the tribunal's fact-finding. It's a point on which the Constitutional Court split, but the majority judgment is what it is.
And reading Justice Mogoeng's judgment, I think it went one step further. And it said in certain scenarios, you don't need hard evidence in order to appreciate the likely outcome of a potential price hike, a tariff hike.
Yes, there's no doubt. We accepted, everybody in the Competition Appeal Court accepted that if there was going to be a price hike and it would prejudice even a small group of uninsured patients, it was an important matter. But we found it wasn't going to happen. It was a predictive exercise. The Constitutional Court or the majority took a different view on what would happen with prices. I think everybody agreed that what happened with prices was important. If it prejudiced that small number that you spoke of, I certainly recognize it, and I don't need to have lived in an uninsured medical environment to know that it matters to the uninsured patient whether you can or can't afford medical treatment. That's a matter of common sense.
Thank you, Justice Rogers. Thank you, Chief Justice.
Thank you. We have come to the end of your interview, Justice Rogers. The one thing which I didn't mention at the beginning is that you are also a member of the Competition Appeal Court?
That's correct.
Yes, and how long have you been a member of that court?
I did give the date of appointment. I just don't recall off the top of my head.
About 5 years, about 4 years, 3 years?
About, I'd say 4 or 5 years, yes.
Yeah, okay, all right. And you acted in the labor court as well at some stage?
Just once. That was before I was a permanent judge.
Yes. Okay,
of the
all
High
right.
Court, yes.
Are there any 2 or 3 points that you want to emphasize to the commissioners before I release you that they should give special attention to when they consider your candidature?
No, I think I've said everything. I just
You've
want to
said
apologize for not
yes.
having asked how you were at the beginning. I didn't know that it would be appropriate.
Okay, all right. Thank you very much, Justice Rogers, and once again, thank you for making yourself available. You are now excused.
Thank you.
Thank you. Commissioners, I think we should take the tea break for 15 minutes and then come back. I know yesterday I said 15 minutes, it ended up being more than that. Let's try to make it 15 minutes. Thank you. So that means it's about 13 minutes past. Let's resume at 4:30. Okay.
Recording stopped. Res.
Let's, oh, there are so many empty chairs that side. Is everybody there that side? Okay, you may bring in the candidate. Good afternoon, Justice Unteralter.
Good afternoon.
How are you this afternoon?
I'm very well. How are you, Chief Justice?
No, at least you are asking me how I am. I am fine, thank you.
Good.
Thank you very much for making yourself available for consideration for one of the positions on the Constitutional Court. I know that at least this is the third time you are making yourself available for a position in the Concord. Thank you very much for making yourself available. A number of us here in the Commission took part in your interview in October. We have before us the transcript of that interview, so we are quite familiar with a lot of information about you. And of course, we have got the questionnaire and your CV. Speaking for myself, I do not propose to ask you a lot of questions precisely because I did benefit from the interview that we gave you in October. It may well be that there will be other commissioners who will take the same position as me, but there are commissioners who were not there in October and who might wish to ask you quite some questions to get to know you better. But even those who were present in the October interview might wish to ask you a little more questions. So I will ask you some questions aimed at just refreshing our memories on some basic information about you, and after that I will allow commissioners who wish to put questions to you to do so. In terms of your qualifications, you possess, you hold 4 degrees. The first one being BA, which you got from Cambridge in 1980, is that right?
That's correct, Chief Justice.
And you got your LLB degree from the University of Wits in 1984, is that right?
Yes, that is correct.
And then you got your BCL from Oxford in 1985, is that right?
Yes.
And you got your MA from Cambridge in 1987.
Yes.
I do recall that from the October interview, that by the time you made yourself available for appointment to the bench, or by the time you got appointed to the bench, you had been in practice for something like 27 or 28 years, is that right?
Yes, I think it's 27 years.
Yes, yes. And in your practice, you appeared in many courts, including, of course, the High Court, the Competition Appeal Court, the Supreme Court of Appeal, and the Constitutional Court. Is that right?
Yes, that's correct.
And with special reference to the Constitutional Court, there is a long list of reported cases in which you appeared over the years. Is that correct?
Yes, I have had the privilege of appearing in that court for a very long time, almost since the inception of the court.
Yes, yes. And you have written also numerous articles that have been published, and you have also, I think if I recall correctly, made some contributions, some books as well.
Yes, that's correct. I did pursue a set of academic positions at the same time I was at the bar, and so sought to publish as best I could, and some of those efforts are reflected in my CV.
Yes. I do not propose to go through a lot of the information because it is before us. In your CV, in your questionnaire, in the transcript, we are aware of it. But I know that you are currently acting in the Constitutional Court, is that right?
Yes, that's correct.
And is that from mid-January this year?
Yes, I started in the middle of January, and I'm going to act. I've acted for the first term, and I've been asked to act for the second term this year as well.
Yes. How have you found that experience?
It's been a very, very enriching experience. Having appeared before that court for so many years, of course, to see it all from the other side is a very different matter. But it's been an enormously enriching experience. It's a very collegial court where I've been welcomed. The cases are enormously interesting and challenging. It's a hard-working court. There's been a great deal for me to learn about the court and the way it works, but it's been a very, very good experience for which I'm very grateful.
Yes. You have now been a judge for what, 4 years or 4.5 years?
Yes, for just over 4 years.
Sorry?
Just over 4 years. 4
Just
years
over
and
4 years, yeah.
4 months, I think.
Yes. Okay. Have you handed down any judgments that you have written in the Constitutional Court or not yet?
No, not yet. Those are
Yes.
still in the process of being
It will
dealt
happen
with.
soon.
It will happen soon, yes.
Yes, okay. I will now allow commissioners who may wish to ask you questions I will allow them to do so. And I just want to mention that in doing so, to a very large extent, they will be seeking to see how your appointment would satisfy the selection criteria that were approved by this body in 2010, which continue to apply. And without reading all of them, I just mentioned that some of them are whether you are a person of integrity and whether you are a person with the necessary energy and motivation, and whether you are a competent person, technically competent, or whether you have capacity to give expression to the values of the Constitution, and whether you are experienced in regard to values and needs of the community, and what message your appointment would give to the community at large if you were to be appointed. Of course, there is the question of whether you are appropriately qualified and whether you are a fit and proper person. Very largely, commissioners will ask you questions seeking to see how your appointment would satisfy these criteria.
Yes.
Thank you. Commissioner Nyambi.
Thank you, CJ. Afternoon, Judge.
Good afternoon.
I'm on your right.
I'm sorry, I didn't see where you were.
I'm very close to where you are. The first question is about the previous interview, as CJ has indicated that you interviewed twice last year.
Yes.
Probably you might have gone through the transcript, and anything that you might want to reflect about out of what was said in the previous interview coming here today that you think it's more than significant, that can assist you to stand out, that you might have not have ample time to deal with it then, or you have reflected about it and you have changed your views about it, about what you said to us in your previous time you were here twice last year?
No, there's nothing in particular, but I'd be very happy to take any questions that arise from it.
Okay, linked to that, as you came twice last year, sitting here today, what is it that is totally different to the judge that we interviewed last year twice, so that we must seriously consider as this commission this time around?
Yes. Well, obviously, I have had the privilege of acting for a term in the Constitutional Court. And since that's the court that I aspire to sit in on a permanent basis, I think that's been a very, very helpful experience, both in understanding how the court works and engaging in the important work that it does. So I would say that that is a relevant factor that is additive to the things that I've already placed before the Commission for the purposes of considering my position. You will also see that I have sent through to the Commission a number of the judgments that I have written in the Supreme Court of Appeal. And I think that's a not inconsiderable body of work, much of it reflected in the law reports, and I'd be happy to take questions on that, but I think it reflects both my interest and the way in which I go about deciding cases. So I'd say those are the two things you might want to reflect upon.
My last question is about Section 167, subsection 2 of the Constitution.
Yes.
The quorum of the Constitutional Court.
Yes.
If you can share with us your view about it.
Is there some specific question about the quorum?
The issue of having 8.
Yes. I think there are different views as to precisely what the quorum should be. My own view is that if the Constitutional Court, as it is intended to, hears cases of the greatest importance, which resolve issues of law that then become a durable part of our constitutional and legal framework, I do think that a quorum of 8 is, generally speaking, the appropriate quorum, because one does want the benefit of all the minds that can be brought to bear on the very important questions that the court considers. And so, although I know there are other proposals about structural change, and I'd be happy to address those if it's of interest, for the moment, in the structure of the court as it stands, I do believe that that quorum is the correct quorum.
What about a situation where you have got a split of 4-4?
Yes. Well, that can give rise to the somewhat unfortunate result that then the decision that prevailed in the Court of Appeal from which the appeal lay would then prevail by default. So it can be an unfortunate consequence. Generally speaking, it's obviously better that more of the judges should sit, but there are also exigencies around other duties that judges have and other commitments that don't always make it possible. So you may well be right, perhaps an uneven number is the better number, and so perhaps 9 would be better, but one has to also be practical about, is it always possible to assemble that quorum? And we have seen in the past that it has not always been possible. So I'd completely take your point. It's much better that a decisive outcome is achieved rather than an equality that simply gives rise to a default rule. But one has to also yield to some practicalities.
Thank you, Judge Ndaulta. Thank you, CJ.
Thank you. Before I go to Commissioner Notjesi, Justice Ontrolta, when you were here in October, you had occasion to mention some of members of the bar that you had been able to assist or give support to. Is there anything arising from what you said then that you might wish to revisit?
Yes, indeed, and thank you for the opportunity, Chief Justice. A query was placed with me yesterday as to my reference reflected in the transcript at page, I think, 62, where I referenced Councillor Beloy. I've, since as my communication, which I hope has reached you, indicated.
It only reached me now.
Oh, I'm sorry.
Yeah.
I did send it first thing this morning, but I did indicate that I had checked that reference, and it was my error. I had made a mistake because in the matter of MTO forestry and the Competition Commission, I had thought that I had led Councillor Beloy, whereas in fact she acted for a respondent, and we were effectively on the same side, but I was not leading her. I have, if it would be of any assistance to the Commission, since drawn up a list of those junior counsel, some of them have since become senior counsel, and some judges, who I did work with, who were black practitioners and women, and I'd be very happy to make that available, because that is a list that has been checked. So if it's of use to the Commission, I could make that list available.
Yes, maybe they might be able to make copies for
Certainly.
everybody if that facility is available at the Secretariat. Yeah, okay, all right. They will probably take it after.
Certainly.
Okay, all right. Commissioner Nochesi?
Thank you, CJ. Good afternoon.
Good afternoon.
Firstly, I note the Law Society of South Africa speak well about your judgment and publication, but my attention is particularly drawn to what Nadel is saying. I will read for you. I mean, paragraph 53 of the comment. Advocate Mugaitobi's nomination essentially entails three considerations. The first is that the candidate's acting stints have played a role in developing the country's jurisprudence. The second is that his judgments demonstrate his strong judicial skills. The third is that the candidate's judgment also demonstrate a commitment to the underlying values of the Constitution.
Yes.
That's a huge statement from these two organizations, to which I can find no fault, and obviously even on the last occasion. There's been a question I've asked from all the previous candidates. The question is, if you are sitting at the SCA as a judge, leave to appeal served before you, and shortly thereafter, you are appointed to the Constitutional Court. That leave to appeal comes to the Constitutional Court. Are you entitled to sit?
If it's an appeal from the SCA, the answer would, I think, be not, unless there's some distinctive feature of the case. But no, I think the answer would standardly be no.
Yeah, I'm asking you this question, Judge, because in the course of my preparation for this interview, I came across two orders. The one issued by yourself and Judge Chomi in the SCA on 8 August.
Yeah.
In the matter of Ken Joan Lindek, Eskom Holdings, SO, and Mogale City. In that matter, you dismiss the special leave to appeal. Shortly thereafter, this year, you sit in the SCA in the full court comprising of Justices Kolapen, Matlanga, Majid, Matopo, Hlanhla, and others. You sit in that bench for the same matter, and you dismiss the leave to appeal by those parties. That's a serious concern to me, I have.
Yes,
I'm worried that maybe you may not have the orders. I can give it to you. But I came across this as I'm preparing for this particular matter.
I must say that
Before you
so sorry.
respond, Justice Unterholzer, if you are able to respond, even though this was not given to you in advance, it's fine. But if you are not able, because you would have needed time,
Yes.
then we might have to deal with it differently. I don't know, maybe let me first ask, are you able to deal with it?
I would have to look at the two cases and see, I'm afraid. And I'd happily come back and answer as best I can. I recall very distantly the one, but let me have a look and I'll happily respond.
Maybe let me say this.
Chief Justice?
Oh, is it Commissioner Malema?
Yes. No, sorry to come like this. This matter was brought to my attention and I gave it to
Ms. Van Niekerk.
Mr. Ello yesterday because it came late. And
Yes.
I had hoped that this matter would have been given to the judge and to your good selves.
Yes. No, I want to address that. Ms. Van Niekerk mentioned to me that there was, I think, this complaint, or, yeah, there was a complaint from somebody. And the question was, she sought guidance as to how it should be dealt with, because as I understood the position, it's a complaint that came late, or comment that came late with regard to the candidate. And I said to her, because it's a complaint that came late, in terms of the decisions we took yesterday, it would not fall under the exception. So it should not be asked to sent to the candidate. You will recall that the general rule we agreed upon is that if it comes late, it should not be accepted, except if it falls into an exception. And the reason why I said it doesn't fall into the exception is this, that generally speaking, I don't think that a judge would intentionally sit in a matter where a decision in which he took part or she took part would intentionally sit, because they would know that they should not sit. But what could happen is that maybe there is oversight and so on. And I said, well, also the complainant, because he is late or she is late, they can lodge a complaint with the Judicial Conduct Committee, and their complaint about Justice Unterholzer having allegedly sat in a matter in which he should not have sat can then be dealt with by that body.
Sorry, Chief Justice, this one is not a complaint. I'm not part of that complaint.
Oh, okay.
I'm asking a question, and I explained that it arises as part of my preparation, and I do not know how, and I cannot even reconcile, because the court order is a public document.
Yeah.
I don't need a complaint to ask this question.
Okay,
Because
so you are saying...
what I'm saying is, I have 2 court orders here. This is what I pick up in the context of preparing, as I do for each and every candidate, this one and other candidates, because these are documents, and I'm asking.
Yeah, no, I understand you.
But I don't know about the complaint. No one has given me
Yes,
the complaint.
no, that's fine. But Commissioner Malema said it is a complaint.
Oh,
No,
Or
Chief
did I
Justice.
misunderstand you, Commissioner Malema?
No. But also your response is what gives me discomfort.
Yes.
And if this is how we're going to proceed, then we're going to have a big problem. We have asked a question. Commissioner Nonchesi has asked a question. The candidate has said, well, let me look into this matter and then I'll come back. But the Chief Justice has already given an answer. that I don't think a judge can sit intentionally in the matter. You have already answered the question for him. And I don't understand what is this, because you gave it to him. He said he needs to familiarize himself with the facts, and then you go beyond that to answer for him.
Well,
you don't think a judge can sit deliberately on a matter? Already the matter is being answered.
Well, Commissioner Melema, I thought I owed you a disclosure of what happened when I was approached, so that you all know. And I shared with you what my thinking was. That is what I was doing, nothing more than that. Justice Unterolter, you would like to check the facts
Yes,
about this?
if I may, I would like to check. I know there have been a number of matters in which I was involved in the SCA where I've recused myself when those matters came up for applications for leave to appeal. I'll look at this instance and come back to you if I've done so in error. Of course, I will indicate my error and make appropriate apologies.
Yeah. In fact, Judge,
Yes.
in fact, Judge, like,
One
just
second.
let,
Yes,
let me,
Commissioner
let me
Rogers.
explain this, Judge. The question from me
Yes.
is by no means an intention to convey some other meaning or to catch you up. It's just a clarity on this matter,
No,
which I would accept, including the question, the clarity such as to say, well, I did not see whatever it is. So I don't want this to create controversy.
No.
If, for me, your answer is, look, because I have these court orders, if you say I will check, if, well, I see, then I recall, and then that's it, we pass on. And I can assure you, take my word, it is not about catching you up, because all what I want to establish at the end of the day is how do you, for instance, between the SCA and the Concord, when you act there, how do you manage such issues?
Well, as I've indicated to you, I'm completely alive to the question. There are a number of cases where the record will reflect that I have recused myself precisely because I was involved in decision-making at the SCA level, and I will obviously look at what you have got there, and if I have fallen into error and made a mistake, I will acknowledge it.
Yes.
Okay, if you can let us have your response after checking at some stage tomorrow, that would be highly appreciated.
Of course.
Okay, all right.
So what is happening to me? I don't ask now. It's end of my question.
Sorry.
Because I was asking questions, I was stopped. I'm trying to clarify things, so it must end here.
Sorry, Commissioner Nokesi. Well, Justice Unterolter has said he needs to check, and then he will revert and let us know.
Because I have the order, so that I stop here, I don't ask questions, I leave, and then everybody asks. If it's read at the end or it's not read, it's fine. But I had some questions that I was to ask.
Yes, no. You remember you have been asking one question with other witnesses. I thought that was the only one. But you can ask, continue.
It's simply because...
Chief Justice, maybe before he goes to the next question, it's Lamula.
I'm sorry?
Yeah, I heard you saying if you could respond tomorrow. My challenge is that according to this, we're going to have deliberations. So how are we going to handle that?
Well, I don't think he's able to check before today. So I thought that we might have to postpone our deliberations.
Okay.
Yeah.
Chief Justice, as I understand this from the judge, and I understand, if we can leave to him, he can simply say, today I want to get other document. Or he can say, I'm in a position, because this is a court order, it shows who appeared in that court, who appeared, what is the matter.
Yes, okay. Justice Unterolter, do you want to respond to that?
I don't want to hold up your proceedings at all. I simply need to get access to my computer, and when I do so, I'll check and see how this arises, and I will come back to you and as soon as I possibly can.
Yeah, okay. Commissioner Jets, is that fine?
I'm happy.
Thank
So
you.
I will stop my questions at this moment.
Okay,
because,
all right.
Because we cannot take it further.
Chief Justice,
Yes.
my difficulty with that is that the candidate would have finished his interview and then he says he will come back to us at a whatever convenient time. Does that mean he will have to come back? Because depending on the type of answer he's going to give, that answer may necessitate a follow-up, wanting to follow up on this question. So
Yes.
how are we going to deal with that? Because depending on how people answer questions, that question may necessitate a follow-up. So how are we going to deal with that?
I think we should then say, ask him to come back tomorrow to give the answer in this forum, so that if his answer generates further questions, he can answer them. Would that be fine with you,
CJ?
Justice Unteralter?
Certainly, I'm entirely at your
CJ?
disposal.
Yes, who?
Is Dodovu, Commissioner Dodovu?
Oh,
I want to
Commissioner
speak
Dodo.
on the same matter.
Yes.
I personally feel uncomfortable that we need to put this matter in abeyance because of a single question. My express view is that a candidate was asked a question. He is not certain about what transpired in that particular case. I think it's enough in the context of how we're moving forward, because here we are going to set a precedence that we have to call a candidate to come and clarify a particular matter here, something that has not happened in the past. My view is that when we consider the issue or the matter at hand and the candidate itself, we'll do that in the context of the information that is available at our disposal, and therefore make a view, express a view on how we must move forward. I think, in my view, that this that we have is sufficient, and we need to move forward along those lines. Thanks.
Thank you. To some extent, it depends whether Commissioner Nochesi, what he thinks about that, because he is the one who had the question, and there has not been a definite answer because the candidate must check. Do you want to say anything about that view, Mr. Nochesi?
Chair,
I want to.
Chair, it's such that I do not know how to approach now. I knew exactly earlier on, because I think I was in agreement with the candidate on two things. One, that he cannot sit there deliberately when yourself you indicated.
Please raise your voice a bit.
I was in agreement with the candidate. In fact, he answered when he says, look, I could not sit on these matters when I was in that court and come and sit on appeal. All what I think you wanted to check is this, so that he's able to say, oh, well, this happened, I made a mistake. I mean, this is what it is, because we know the principle that he cannot sit. If that is what happened, because it's just a question of court orders. But now, your view is that you need more time on this. To me, there's nothing, it's not in trial about this matter. I'm not putting him on trial. I just wanted to clarify this, not only for this candidate, but for all of us, my education, other commissioners, and everybody listening outside there. So,
well, if you say it's not a big issue for you to warrant that he should come back tomorrow or furnish other information so that we finalize everything today in regard to the Concord. If you say that, I would have no problem going ahead.
no, to me, it's not a big issue.
Yes, okay. All right. Is there anyone who feels that...
I'm here on virtual.
Oh, Commissioner Malema?
Well, that is my question as well. If non-jazz is retreating from it, I'm sponsoring it because I don't know how the question of Advocate Baloy arose, whether it was raised 7 days before or it was brought to the attention yesterday and it was also processed and we're able to get an answer today. This matter was also raised and there was a space in between. It is special for me because it has got everything else to do with the ability to make judgment for the judge. And when the argument arises that no, you can't say that because he has answered the way he has answered, we are going to use this in deliberations. And I can't use the things that we have not raised or that he did not respond to on this platform. So whatever we're going to say in the deliberations based on this should be coming from him and not what we suspect he said or we assume he said this. So that's why we should get a definite answer. Because for me, there are two issues. Is Advocate Baloy's issue, is this issue, and then it has got everything else now to do with the judgment of the candidate. That how do you go around making such mistakes? How do you come here and say you mentored Baloy or you led Baloy in a case and not being sure? And then you come and say, no, I made a mistake. Then on this matter, he comes and say, okay, I made a mistake. There are two matters where a candidate for a senior position has made an error of judgment. And I will be using that to argue in the deliberations. And someone can't just come here and say, no, leave it. You can't get an answer from him. Just use what you got. They're going to litigate and say, he never said what you are saying he said. Because I know for sure on this candidate, all the time there are NGOs that are readily available to attack us. And that's why we must be thorough and we must be clear and we must get definite answers. Unless they say they are not prepared to entertain it, then we can use that. But if he says I can entertain it, let me have an exposure to my laptop, it's going to help all of us that this is his answer.
Yes.
Thank you.
Thank you, Commissioner Malema. Commissioners, this is the view I take of this matter at this stage. I'm not saying it's final, but let me say to you, we are here tomorrow. We are here for the rest of the week. I don't think there is anything problematic if we were to defer our deliberations. The candidate goes and checks what he needs to check. He comes in here tomorrow, and at some stage when it's convenient to us, we let him come in. It might be 10 minutes. He gives an answer. If there are no further questions, that's it. If there are follow-up questions, he deals with them. Then we know that we are done. Because it's not, I don't think it's right if there are members of the commission who feel strongly that an answer on this question should be obtained. I think that's what I think we should do. Can everybody live with that?
Before we do that.
Oh, before, let me, Commissioner Singh.
Yeah, thank you, Chief Justice. I don't know whether Justice Untitled has his laptop with him. But if he does have, I think it'll be very helpful to all of us. Perhaps if we adjourn for half an hour or so, and through you as the chair, the documents which Commissioner Notiesi has on hand be provided to him just to jog his memory, because we don't expect him to come with all the answers here. And then we adjourn for half an hour, and then we continue and finish our interview. And we can deal with deliberations perhaps tonight or tomorrow. So I don't know if that's a possible way out on this.
Maybe what we should do is let's exhaust other questions, and then at the end we can then decide whether we go that route or another route with regard to this particular issue. So in other words, what I'm suggesting is that let's park this issue, let's continue with the interview, And once we are done with all other questions, and the only one left is this one, we can decide at that stage whether we go the route of asking him to come back tomorrow or whether we go with the suggestion made by Commissioner Singh. Commissioner Kaba?
Yes, CJ, thank you very much. I want to agree with your proposition that says, let's park this issue and then continue with the interviews. And then the issue that the advocate needs to be aware of is that we need his response to this particular question before our deliberations. So we either postpone our deliberations, we're going to have the deliberations immediately after the sitting. We either postpone them to tomorrow morning, in which case we allow him time to come back. The issue, how is he going to come back? I think we can even take it by, he can come online on the time that you determine. We make a follow-up on this and then conclude and then go into deliberations. Thanks.
Yeah. Okay, all right. Are we agreed? Let's continue with the interviews for now, with the interview. And then before, when we are done, then we'll talk about this issue, how we move forward with it.
Chief Justice. Can I just raise an issue?
Okay. Commissioner Pillay.
Thank you, Chief Justice. I would like to agree with Commissioner Malema. There are actually two issues which are unresolved. I wouldn't want to label the one the Beloy issue, but certainly the number of black women that the candidate has led while he was at the bar, I think that's still an issue that's unresolved. So if we are pending issues to be discussed tomorrow, I think it's important to emphasize that there's two issues thus far that remain unresolved.
Well, as we speak, I don't know of any reason why any other issue can't be dealt with today. I know why this one that we are talking about might have to wait until later. What I'm saying, if we continue with the interviews and there is a question that somebody wishes to ask with regard to the issue you are raising, that can be asked.
Except, Chair, on the black women juniors, we're waiting for the candidate to produce a list.
Oh, okay.
And that's why further questions will have to follow once we receive that list.
No, that's fine. Can we continue with the interview, Commissioner Nochesi?
To do just for myself to complete, I want to hand over this so that on my side, so that you can see what I'm talking about.
That's fine, thank you. Okay, let's continue with the interview for now. Commissioner Moimang, had I given you a chance or not?
Not Chief Justice.
Okay, may I give you the chance now?
Thank you, Chief Justice. Good afternoon.
Good afternoon.
Justice Interhalter. My question relates to whether there is a case in suggesting that there is lawfare in South Africa following the role that the court plays in promoting the values of our Constitution. Secondly, does the Constitution stand in the way of radical socio-economic transformation in terms of transforming the capital relations in South Africa, ownership, management, and control of key economic sectors? Thank you.
Well, let me answer both your questions. Perhaps let me begin with the second question first. Our Constitution marks out two parameters fundamentally, which is that there are a bundle of fundamental rights which define a number of liberties that people have, as well as obligations that rest upon government to progressively realize the socio-economic rights. On the other hand, there are a scheme of separation of powers under the Constitution which give, as one would expect, considerable latitude and indeed obligations to the executive and parliament to shape the policies that, in the view of the government of the day, are relevant for the country and they are elected to determine. And I don't think that our Constitution dictates the kinds of economic policies that are to be pursued by one government or another. They permit of a very great range of economic possibilities, and by and large, those who might be committed to significant changes to economic relationships in this country will find that there is ample scope within the Constitution for that, bounded only, as I've indicated, by the fact that this is a constitutional democracy, and in a constitutional democracy there are certain fundamental rights which exist and which are to be honoured, notwithstanding what the government of the day offers. So that would be, in general terms, my answer to the second question that you pose. As far as the question of lawfare is concerned, there's been a great deal of discussion as to whether the courts have become places in which political battles take place. And I don't think that the courts have ever been immune from the fact that political actors will often seek to translate their political positions into legal arguments. What matters most fundamentally is that courts don't find themselves drawn into the rights and wrongs of particular political positions. And so it seems to me that when people speak about the fact that courts are overstepping, that can arise in one of three circumstances. The one is that an unsuccessful litigant does not like the way a court has decided. That's an inevitable feature of all litigation. Somebody wins, somebody loses. There are some who criticize the structure of the Constitution as it exists and would have it other than it is. Well, we know that that's a matter for constitutional change. And then there's the third question, which is, have the courts in any way overstepped the boundaries of what courts are there to do in upholding the Constitution? It would be that third category that one would want to look at very closely. But in my judgment, though many issues of great legal importance sometimes are the result of political battles that litigants would fight, the courts don't translate that into political partiality. They must and always should determine the matter on the basis of the law and the constitutional order as we have it reflected in the Constitution.
Thank you, Justice Interhalter. Thank you, Chief Justice.
Thank you, Commissioner. Justice Betzer.
Thank you, Chief Justice. I've got two. Good afternoon,
Good
Justice
afternoon, Justice
Unterholder.
Betzer.
I've got two questions for you. One is more of an observation, and I'll leave it to you whether you might seek to dispute it. I see from the bundle of documents here that you were nominated by Advocate Maleka, Advocates Maleka, Ngugai Toby, and Sisilana.
That is correct.
And having read those letters of nomination and the motivation for the nomination, I just want to make this observation. Your wealth of experience and extensive knowledge of the law was demonstrated during your several acting stints at the SCA, during debates with counsel in court, and deliberations that the members of the panel would have after the hearing. Do you wish perhaps to comment on that?
Well, I've certainly had, as I've indicated earlier, the privilege of acting in the SCA and now in the Constitutional Court. And there's a great deal to learn about how appellate justice works. But it has been one of the enormously enriching features of that experience that one engages in these courts with very talented counsel who come to submit before the court, and getting the best out of their submissions is part of what hearings are all about. Although the questioning is often rigorous, it's intended to be in order to get the very best advantage of what counsel can contribute. And then there is the wealth of experience and knowledge that colleagues bring to bear in thinking about cases and offering their views about it. And it is out of that judicial chemistry, if I can put it that way, that we get our thinking refined and the best of our judgments ultimately come to be made. So I've tried to make my own contributions to that process, and of course also greatly benefited from how others engage in what is the fundamental work of the appellate courts.
Thank you. My second question has got its genesis in the question that Commissioner Nokesi wanted to pose to you. And you are at liberty to indicate if you feel that we must park that question until tomorrow, after you have had the opportunity to investigate the matters relating to what Commissioner Nokesi wanted to raise with you. I don't know whether you are aware from your acting stints at the SCA, which is a common occurrence there, where you would have two judges of the SCA considering a petition, deciding to grant leave to appeal, and one or two of those judges would make up, together with three other judges, the panel that hears that appeal in due course. Similarly, from my experience in the Constitutional Court, where justices of the Constitutional Court would consider applications for leave to appeal, would dismiss one straight away on the basis either that there are no prospects of success of the intended appeal, or that it does not engage the jurisdiction of the court. In the one it happens, they would decide to issue directions, file the record, and they set time frames for filing of the record, filing of heads by the applicant, and filing of the respondent's heads, and an indication of when the matter would be heard. And all 11 justices who are party to that direction, or whatever the number that constituted the quorum, would then hear the application for leave to appeal in due course.
Yes. That is entirely as I understand the procedure to be. As I understand the difficulty that's being put is that I would not have been competent to be part of any quorum that would have determined the application for leave to appeal before the Constitutional Court, and that's the matter that I will look into. I don't think it makes a consequential difference to the outcome, because there would, I assume, have been more than a quorum available to take the decision. Whether my assent, if there was an assent, is counted out of the calculation or not. So, but I will obviously look at the position, and but your understanding of the procedures, as I have come to know of them, is accurate with respect.
Thank you, Justice Unterholter. Thank you, Chief Justice.
Thank you. Commissioner Makwanisha.
Thank you very much, Chief Justice. I think I must be protected from my discipline.
From who?
From my own discipline. Because I do raise hands to make interventions because I just don't just talk.
Yeah.
I think I need to be protected from that discipline.
I apologize, Commissioner Makwanishe.
No, thank you very much, Chief Justice. Good afternoon, Justice Untitled. When you were responding to the question from the Chief Justice, I think I'm going to collapse two questions into one. When you were responding to the question from the Chief Justice, you said that you are still writing the judgments. You have not yet delivered the judgments in the Concord where you are acting now. Now, will it be fair that you just come for a few months, you have not even delivered one judgment, and then we expect you to be appointed to that court? Can you really say that you know that court? I think it's linked to also the question on the fact that in terms of one of the criteria that the Chief Justice has articulated is that we must also consider the message that we are sending to society in general. Now, what message will we be sending? That you just come for 4 years, you jump to the highest court in the land, and there are other judges generally who have been there for quite a long time. And it's linked to the issue that I've just raised also with the Constitutional Court. You are appointed in January, if I'm not wrong. You are appointed in January. You are still in the process of writing judgments for that court. Then we are appointed. Can you assist us so that we have a compelling argument to recommend your name?
Yes, well, let me be clear. The judgment that I've been asked to write, I have actually written, but it's under consideration from my colleagues, so I can't do more than await their views on it, which are in the process of being determined. Of course, it happens that this interview comes at the end of the first term, and as you all know, the Constitutional Court follows a particular process by which judgments are produced. But I think that you will find that the work that I've done over the term that I've just been engaged upon has been quite considerable, and the results of that will become apparent when the judgments are yielded. So although you can't know everything as to what I've done over this period, that is something that will become apparent. And I think I can give you the assurance that I have very fully participated in the work of the court and will fully participate and continue to do so in the term that is coming. So I don't think that the proposition is somehow that I've just started and there's nothing by way of a record that is relevant to my suitability for consideration. The other point is this, which is that generally speaking, if one is privileged enough to act in that court, there is a limited time over which that takes place. So I'm not certain entirely what is the expectation of the Commission. How many times must one act in the Constitutional Court before one can be considered as a candidate for that court? It does seem that not only is acting not a requirement, but if it happens, a period of 2 terms would probably suffice as a reasonable training ground for the purposes of permanent appointment, and that has been a norm established over the years. As to the question as to the period of time that I have been a judge, I've made these indications to the Commission before, but let me very briefly summarize where I am on all of that. In a lengthy professional career, where I took time out from the bar to engage in the work I did at CALS and at the Mandela Institute and so on. There is only so much one can do in a professional life. And I took that time because there were a number of things that I wanted to do and achieve in the course of my professional life. In addition to the time that I took to serve at Cowles and in the Mandela Institute. I also spent time, as I've indicated before, at the WTO, where I served on the appellate body and chaired that body for 2 years, with a cumulative experience of some 8 years of judicial service in that capacity. Now, we can talk about how useful and relevant that is, but that explains why I, as it were, came to the South African judiciary relatively late in my professional career. And the ultimate question, I think, for the Commission, and certainly the one that I would suggest to you, is that the question is that cumulative experience of practice and judicial performance in the WTO and the other things that I've done in my career of value to a position in the Constitutional Court. And I would like to suggest to you that it is.
Thank you, Chief Justice. Thank you, Judge Altenhutter.
Thank you, Commissioner. At this stage, I'm going to go to the commissioners who are attending virtually to see if there is somebody who wishes to put some question to the candidate.
Julius.
Commissioner Malema.
Thank you, CJ. Judge, is it an acceptable thing that, maybe let me put it differently, that we have observed a huge temptation to capture the judiciary, especially from the executive and politicians who want to use their judiciary to fight their political battles. And all of us without fail have gone all out to protect the judiciary against politicians who want to capture it. Will it be an acceptable thing that some NGOs here must capture judiciary to serve their own interests because they are not political parties? Is it acceptable that if it's not political parties, it's okay that these NGOs must capture the judiciary?
Commissioner, I think the position is very clear, which is that it's critical that the judiciary should be independent and beholden to no one but their oath of office and to the Constitution, and they should be captured neither by politicians nor by NGOs, but simply do their duty as independent judges.
Now, my second question, Judge, is, does experience count for anything for you? Like, do you think it's necessary for people to get an experience before they assume certain responsibilities permanently? And let me take it further that, do you still hold the same views you were holding before you acted in the Constitutional Court, or you think that your acting actually helps somehow to put you in a better and a different position?
I think experience is always helpful. I think we have had examples of very, very good judges who have had little or no experience and discharged their judicial functions with great distinction. But it is always helpful to have experience, and I'm particularly grateful that I have had 2 years on the Supreme Court of Appeal and have now had the opportunity to act in the Constitutional Court. I don't think, in other words, that you can never have an appointment without the requisite experience, but I think that it is helpful, and it has been helpful.
And will you agree with me, Judge, that acting and acquiring an experience is so helpful that it will even empower you to a point where you don't make minor mistakes, especially at that level of the Constitutional Court, because that is the highest court where you cannot afford to make minor mistakes. And part of the things that will make you not to make minor mistakes, it is acquiring an experience.
Well, Councillor, I'd say this, that I'm afraid human error is part of everyone's experience, and no matter how long one pursues a particular career or a particular line of engagement, you can always make a mistake. We're all fallible, we're all human, I am, and we can make mistakes, and we have to acknowledge that, and it's true of everybody. And if I've made a mistake, it's not because I believe I lack experience, it's because everyone can do so from time to time.
Judge, I agree with you, we are all going to make mistakes, but that is not my question. My question is, acquiring experience, especially when you go to the Constitutional Court, helps you not to make minor mistakes. Underline minor mistakes.
Yes.
There are certain things are ABCs of the Constitutional Court. And if such minor mistakes are committed at the Constitutional Court, you'll destroy the image of that court. And once you destroy the image of that court, you destroy the confidence of our people on that court. And once our people no longer have confidence into that court, it will lead into the state of anarchy. So I'm saying, do you accept that experience will help you not to commit minor mistakes? Not mistakes, minor mistakes.
I don't accept your proposition. I don't think that the kind of experience one gains, important as it is, ever prevents a minor mistake from being made. These things happen from time to time, and if they do, they're regrettable, but I also don't accept that because what you've said is a minor mistake, if it has been made, somehow that leads ordinary people to suddenly lack confidence in the Constitutional Court or the judiciary at large. People recognize, as they do in every walk of life, that people make errors, and as long as those errors are corrected and acknowledged, then there is no threat whatsoever to the institutional integrity of the courts or any other part of our constitutional structure.
You know, it is minor mistakes that ordinary people will appreciate. Those legal jargons and whatever arguments you make there, we may not be able to pick them up. But once you start engaging in minor mistakes, then that court is going to be flooded with rescission applications, and it will be forced to change its own decisions. And once it starts changing its own decisions, it suffers image crisis and confidence crisis, and that leads to our people losing confidence in that court. Will you agree with me?
Councillor Malema, I can't agree with you. Rescission is a very particular kind of procedure, and it has been resorted to more often of late. But there are very few instances in which courts make errors, but if they do, they can be corrected, and they should be corrected, and I don't believe that it leads to this wholesale lack of confidence that you suggest.
My last question is, does seniority count for anything for you? I don't know anything about law, and I'm not a lawyer, but every time I go out with lawyers CJ, and then we go to a dinner or something, they say the senior counsel must pay because he's the most senior person there. and that they always accord respect to that senior because of that seniority. Then there will be judges. I heard JP saying earlier on, he thought he was the most senior in the room and all of that. So you've got this tradition amongst judges and by extension, lawyers, and by extension, judges who respect seniority. And it's not only in the legal fraternity or in the judiciary, it's also in the church, where you can't join judge. Today you get baptized. The following day you ask the question, where are the pastors sitting? After being baptized, you give yourself some time to familiarize yourself with the processes there and allow the seniors to take you through and teach you. So my question is, does it really, seniority, does it matter to you? Because I'll tell you why I'm asking you this question, Judge. I respect you very highly, and those who are in my legal battles respect you very highly. Some of them nominated you. But I've got a problem that and you can see that we consider you very highly. We appointed you and you are being given opportunities to act and all manner of things. But you are in this hurry to a point where you even want to pass the people you found in the judiciary and go and lead them at the Constitutional Court. Why can't you give yourself time? You are now acting. Earlier on when we interviewed you and told you about acting, you had a different view. Now you are acting. Can't you give it some time to continue acting and accumulate the necessary experience? Then this argument of seniority and minor mistakes and experience will fall off and you assume that position properly without anyone having questions. Seniority, does it matter really to you?
Yes, Councillor, I don't think we value seniority just for the fact of seniority. We value seniority because it sometimes represents cumulative knowledge and experience that can be usefully brought to bear. And that's sometimes valuable, and we take account of it for the reason of its substance, not simply because it is a rank that has been attained through the passage of time. I think in my case, it's a question of how the Commission and yourself assesses the fact that I have had a very lengthy career at the bar, in which I have done a great deal of constitutional work over a very long period of time. I have had experience across many areas of law, and I have acted in a judicial capacity in the WTO for some 8 years. And it's now a question of whether there has been enough further experience within the South African judiciary that would suggest that I can make a contribution. I believe that I can, and I'm happy to further explain what that contribution would be. But if it is the case that you or the Commission at large takes the view that it is only sitting judges who have sat for 10 or more years, well, then you will announce that policy and people will know where they stand. And speaking for my position, I will then become too old to ever assume a position on the Constitutional Court, and I will not be able to make that contribution. But that's a judgment ultimately for the Commission to make. It's not one that I can. I believe I have cumulative experience of some value to a contribution I can make at the Constitutional Court, and if I'm given the opportunity, I should love to do so. But if that isn't the requisite combination of experience that counts for the purposes of appointment, well, then I will accept that, and that is how things will be.
Thank you, CJ.
Thank you, Commissioner Malema. I don't have anyone on my list anymore now, but I see Commissioner Singh, and after that, Minister. Oh, I'm sorry, I'm sorry, Commissioner Singh, I'm sorry. I think I forgot that I was still with the commissioners who are attending virtually. Was that Commissioner Breitenbach?
Yes, thank you, Chief Justice, if I may.
Yes, you go ahead.
Thank you, sir. Good afternoon, Judge Interalta.
Good afternoon.
My question is a simple one. What, in your view, are the factors to consider in deciding whether or not you are sufficiently conflicted in any given matter to justify your recusal as a judge? Thank you.
Well, a conflict of interest arises in a number of different circumstances, but it would usually be one where there is some private involvement that one has, which is at stake in the litigation, and hence there would be an apprehension that one could not bring an independent mind to bear. So standardly, it is conflicts of interest that give rise to recusals, and that's the one category that would ordinarily require a judge to step away from a case if they had interests in the litigation or its outcome that were peculiar to their private concerns, and hence they would be operating in a conflict of interest and duty. And I think that's fairly well understood as a basis upon which a judge would recuse themselves.
Thank you.
Thank you, Commissioner Breitenbach. Any other commissioner attending virtually who has a question for the candidate?
Nothing from me, Chief Justice.
Thank you, Commissioner Barnett. Commissioner Shabangu Mdawe, have you got any
Nothing
questions?
from me.
Nothing from you.
Nothing from me, yes.
Thank you, Commissioner Singh.
Thank you very much, Chief Justice. Good afternoon, Judge.
Good afternoon.
Firstly, I just want to confirm, Chief Justice, that if you take us out for dinner, or in our case, Parliament, the Speaker, then the Speaker has to pay, because that's seniority as far as I'm concerned. So I think they must expect a big bill from all of us when they take us out to dinner. I think one of the significant appearances that you made, Judge Untitled, when you were not a judge, and I'm speaking from a parochial point of view in the Constitutional Court, when you secured us, when I say us, members of Parliament, the right to introduce private members' bills.
Yes.
And that was in 2012, where that right was not a given right at that time. And late Honorable Mario Ambrosini took that matter, and SC Untitled represented us MPs, and I think that was a significant ruling by the Court, and it really helps us now as members of Parliament to move forward. That's as an aside, but just to say thank you again for that. During our last interview, the Commission spent a lot of time on your participation or appointment in a leadership role or otherwise in the South African Jewish Board of Deputies.
Yes.
And I know you explained at length your position, but there were a number of articles in the papers, in various publications thereafter by different people, which is not you writing, about this matter. Now, I know you did explain the matter to us. Is there anything that you would want to add for those commissioners that were not here, or may not have followed it, or members of the public who don't have the transcript that we are privileged to have before us? Thank you.
Yes, I'm not sure that I have terribly much to add. The position, as I've described it, is that the Jewish Board of Deputies is a body that has long predated the State of Israel and is there to look after the interests of the Jewish community, and in particular deal with cases of anti-Semitism, which is a species of racism that is particularly concerning to the Jewish community. I joined on the basis that I could possibly, in a time of COVID, be of some service, and that was my understanding. It was to serve that community of which I'm part. I've indicated on a number of occasions that the views that the community, that is the Jewish community, has as to the State of Israel and so on are highly varied, and that is no part, as I've ever understood the constitutional basis of the Jewish Board of Deputies, to be anything more than its service to the Jewish community. I certainly acknowledge that in the light of the fact that the Jewish Board of Deputies is a litigant, and sometimes a litigant in the appellate courts when dealing with questions of anti-Semitism, that it would not be appropriate for me to continue to serve in such a body which is also a litigant. And it was for that reason that I stepped away from the board, and it seemed right that I should do so in the light of the issues that were raised with me. And as I've indicated, where one is in error and there is correction to be made, well, then one must make the correction and not simply dig down and simply refuse to acknowledge and refuse to correct. And that's essentially what I've done.
Thank you very much, Judge Untitled. Thank you, Chief Justice.
Thank you, Commissioner Singh. Minister?
Thank you, CJ. Judge, my question relates to the partial judgment versus the Minister of Justice and Correctional Services. One of the issues that the judgment was attempting to cure was a dual system of consideration of parole. But I'm asking myself that you took a decision there, which was confirmed by the Court on the fact that the parole must be considered on the basis of the date of the commission of the offense instead of the date of sentence. But there's a judgment, Van Wyk judgment. I'm sure you will also have considered it when you're considering the partial. So when dealing with the Van Wyk matters, they are dealt with also differently. You can consider them before 2004. There is a kind of regime. So I sometimes feel like it did not really cure this issue of a dual system that the Concord was trying to cure, but also that I sometimes sit with the parole that I feel like this is a gruesome kind of an offense, but a person has to be considered for parole even before they reach maybe 25 years, which was the intention of the Correctional Services Act.
Yes.
Yeah. Do you have any comment on that you think could be helpful for us?
Well, the dilemma that arose in that case, and which I attempted to resolve as part of a full bench, which then went on to the Constitutional Court, was how does one understand constitutional rights in relation to parole when the legislature has changed the scheme under which parole can be considered, particularly the time period relevant to when those who have been convicted of the most serious offenses can be considered for parole. And as we know, there was a law change that occurred, and the question was, well, is the regime of parole some part of the burden of sentencing and punishment that a person has to suffer or be relieved of? And ultimately, I found, and in the judgment with my colleagues, and so did the Constitutional Court, that there is a relationship between the consequences of one's criminal acts, including any parole that might flow from a criminal sentence, and that and the relevant time to determine that burden of punishment is at the time of the commission of the offense rather than at the time of sentence. Now, there are always anomalies when one engages in a change of law, and certainly there were decisions prior to Pachla which had looked at this in a very different way and had said that in effect parole is a feature of executive discretion and simply doesn't engage this burden of punishment. I took a different view, so did the Constitutional Court, but there is certainly a view, and perhaps it's one that, Minister, you may be more sympathetic to, which suggests that parole is something that happens after sentencing and is a discretionary feature of executive decision-making and shouldn't be implicated in the notion of punishment itself. That's not the route ultimately that the Constitutional Court took, and it wasn't the view that ultimately I held. But it's certainly a view that I fully understand the weight of.
Thank you, CJ.
Thank you. We have taken 1.5 hours already with this candidate, but I don't have any further hands. The Secretariat has told me that they have been in contact with the Constitutional Court and have obtained the application papers relevant to the matter that Mr. Nochesi raised. It is possible that if the candidate was given those papers, maybe that might give him all the information he needs, and he might be able to assist. I'm not sure.
Yes.
Do you think that might help?
I'm obviously very happy to look
have a look. Yes.
at what papers have been procured. What I had wanted to check on my own email, but with the assistance of the Constitutional Court, I might be able to do it here.
Yes.
Is firstly to check what applications served before the Constitutional Court, and check in that application how it came from the SCA, and then to check in the scheme of the emails that were exchanged that my concurrence in the Constitutional Court is accurately reflected on the documents that have been handed to me. But I can look at whatever materials are available and see if I can ascertain the position or not.
Is your answer that looking at the application papers that have been secured may or may not help, because you might need to look at your computers and for other things?
I think what I would be wanting to do is to check in the scheme of the emails by which one indicates a concurrence.
Okay.
That I did participate as the documentation seems to indicate. I would just like an opportunity to check that.
Yeah.
And I'd have to get access to my computer or a computer to do so.
And you don't have your computer here?
I don't, but I'm certainly, I can certainly see what I can do to get remote access to it, which may be possible if there's someone who can assist me with the computer. I can certainly look and see.
Yes.
So, Chief Justice, if I can deal with the matter today, I would obviously want to do so to assist you and resolve the question one way or the other.
I'm sorry, did you say if you can deal with the matter today?
Well, if it really just depends upon getting access to a computer and being able to remotely access my emails at the Constitutional Court. And it may be that some of the documentation is available. So I'm perfectly happy, if it would be of assistance, to try and see what is available.
Yes.
If I can try and resolve the matter today, I would obviously do so.
Okay, all right. Thank you. They will give you the papers for what it's worth, but from what you say, they might not provide the answer, because you need to see the emails that were exchanged. You want to see whatever email where you would have indicated you would have signified your concurrence with the order.
Yes.
So I think, commissioners, let's now talk about the way forward with regard to the issue that was raised by Commissioner Nochesi. But I think Commissioner Schlemmer wants to say something.
Yes, CJ. It seems like the Secretariat has a computer available that Justice Unterhalter may use to get access to the material.
Yes.
And if I may, then I would like to suggest that we adjourn for an hour maybe, and then come back to give him time to have a look at it.
Yes. Justice Unterhalter, how much time do you think you might need?
If I can get access to a computer which allows me to get into my Constitutional Court emails, I don't think I'd need terribly long, but I could indicate early whether that's possible or not, so as to not detain you for any longer than is necessary.
Yes. Okay, well, maybe we should adjourn for maybe let's say 30 minutes. And if, maybe after that 30 minutes, you will tell us whether you have succeeded or not.
Certainly.
Okay.
Before we adjourn, and I think we can excuse Judge Untitled.
Well, let's first see. We agreed that we'll adjourn for 30 minutes. Okay, all right. So let me release you temporarily, Justice Untitled.
Yes, I'll leave the copy of the list of counsel with whom I've worked.
The Secretariat must take it from you.
Yes.
Yeah. We are therefore going to come back. It's now 5 minutes past 6. We'll come back at 25 to 7.
Yes. But before we can
but you want
adjourn,
to say something, yeah.
Firstly, I think...
After the candidate has left.
Yes, yes.
Okay,
Shall I?
we are
Am I
releasing you.
excused for now?
Yeah.
CJ Lamula. I see
yes.
the JP wants the candidate to leave. I'm not sure what issue he wants to raise. I see there's still a media. Is it a kind of a close?
No, the media can remain.
Okay. Thank you,
because
Minister.
What I want to raise may as well perhaps resolve the problem. I don't know. But I think what we have seen is the Roman 3 alive. We have actually applied Roman 3, which we spoke about yesterday. That is what has happened. But I think DP Petse raised a very important issue. And I think you can advise us, CJ, if you are sitting in an application for leave to appeal, I take it in the Constitutional Court, once you have dealt with it, all of you assist with the matter. And I think the next issue is going to be, would there have been anything wrong if, say, for example, he was sitting at the SCA, leave to appeal coming from the High Court was granted, would he have been excluded? Because remember, it is not his judgment that is being appealed against. It's the judgment of another court. And as far as I'm concerned, where I am, I find it very difficult to see it as some sort of something that is completely forbidden. With us, it's a different story. Because we assist with the main matter.
No, I think that... Yes, Commissioner Malema?
I think we have not arrived at a point of deliberation.
Yes.
And this matter you said, the candidate is still going to look into it.
Yeah, let's come back.
We're going to have a proper discussion.
Yeah, let's come
Once
back.
back.
Yes. No, let's come back at 25-2 as we have already agreed. Okay.
Yes, Chair.
Thank you.
Because that issue still needs to be discussed
Yeah.
further, even with the candidate.
Yeah.
Yes.
Thank you. We'll come back at 25-2. We'll just wait for the candidate to be brought in. Are you able to report back?
Yes, indeed. Thank you very much for the opportunity. I've managed to get hold of the application that served before the Constitutional Court and the memorandum that was provided by Justice Madlanga. So let me tell you what I've been able to ascertain. The document that has been provided to me indicates that a petition served before the Supreme Court of Appeal, and I, together with Justice Mukumi, sat on that petition.
I'm sorry, Justice Unterholter. Thank you, Minister. The commissioners attending virtually, are you there? Are you back?
We're here.
Yes, we are here.
Oh, okay, thank you. Thank you. You may proceed, Justice
Yes, thank
Unterholter.
you. So I have seen the document which evidences the fact that together with Justice Mukumi, I sat on a petition in the Mogale City matter, and we dismissed the application for special leave. There was then an application brought to the Constitutional Court by the disappointed applicant, and in accordance with the procedures that are followed in the Constitutional Court, a memorandum was produced by Justice Madlanga in which he traversed the merits of the application, and the application to the Constitutional Court was itself attached. My concurrence is correctly reflected in the order that I've been given, and which I recall joining in respect of the dismissal of the application for leave to appeal. So it is certainly the case that I was not in a position to determine the application for leave to appeal before the Constitutional Court, having refused the petition in the Supreme Court of Appeal. I can only say that it was an error. I did not recall that I had sat on the petition. Commissioners will know that many of these petitions come and one sits on them in their many numbers. I would indicate that the application to the Constitutional Court did not in the body of the application actually reference me or my name, nor Justice Mukumi. And the order itself is an attachment right at the end of the application, which I certainly didn't take note of when I considered the application before the Constitutional Court. So I didn't see that I had sat, and I should point out, though I make no, it is also the case that none of my colleagues on the Constitutional Court noted this fact, nor their clerks who assist them in the preparation of their work. So it is an error that I made. It is the case as a matter of law that one can sit upon a refusal of an application for leave to appeal if the matter nevertheless goes to a hearing on the merits, but I accept that having sat on the petition at the Supreme Court of Appeal, I was functus officio for the purposes of sitting on an application before the Constitutional Court. It makes no difference to the outcome in the Constitutional Court because there was a quorum of judges even if my vote of concurrence is removed. So nothing turns on the outcome, but I certainly acknowledge that I didn't recognize that I had sat previously and that I should consequently have recused myself. I would indicate that I am completely alive to this problem, and in numbers of cases in the Constitutional Court, I have recused myself in respect of applications for leave to appeal, one of them being the HAL case against the MEC for the Orange Free State, where I sat not on a petition, but on the full court that heard that matter in the SCA, as also in the Coral Sands versus Capitec application that was directed to the Constitutional Court, and more recently in respect of the Group 5 and Competition Commission cases. So I should point out that I am entirely alive to this problem, that having sat in a number of courts, one has to be alive to the fact that you may have sat previously. This is just a petition that I did not recognize I'd already sat on, and I made the mistake, and for that I apologize.
Thank you, Justice Unterholter. Commissioner Nochesi.
No, I understand you, Justice. I just want to bring to your attention that the reason why I asked you this question is because the matter itself emanates from the Gauteng division, that is your division. And then it comes to the SCA, it comes to you. The CC, it comes. It's like, in my language, like wherever you go, I follow you. So that was a serious concern I have.
Yes. No.
And with your answer that you have given, I've got it. But now, this is the last point. What does then, because if I send an application, full application with all attachment, even if it is a letter that is not clear, as somebody who's going to decide, you need to see what is in that unclear paper. That's why judges would write back a note and say, can you clarify, can you send us a legible note, because that one. So now in this one, admittedly, you didn't read the order itself. I accept because the name appears. Where does it leave us? What does it say? In general, what can you say? I understand the apology about sitting because there are many matters. But now, admittedly, a document in an application that must be decided is not read.
Well, to be fair, I don't think that that's entirely correct. I mean, the application was fully read. It dealt with the question as to whether an interim application was susceptible of appeal. That was something that clearly, when I read the application and the SCA, we considered there were no prospects for leave to appeal. The memorandum that would accompany the application, which I've read and refreshed my memory of, made exactly the same point. So the issue is a relatively crisp one as to when an appellate court will entertain an interim order, and there are only very unusual and special circumstances where such an order is entertained by an appellate court. And so the principle is very clear. And I think there was, it's true that the very last page of the application, where the actual order of the SCA is to be found, but where my name is not reflected in the body of the affidavit, is one that I didn't have regard to. But I would point out that nobody in the Constitutional Court did either. Not a single justice and not a single clerk who looked at this application. So while, of course, I take responsibility for my failure to notice this, it appears to have been an error that was made by everybody, and it is regrettable, but there is, I think, little to be said about it beyond the fact that it was an unfortunate error. These things do happen occasionally, and one will endeavor not to repeat an error of this kind.
That concludes my questions.
Thank you,
And
Commissioner.
I think I'm also relieved about my concern. Wherever you go, I follow.
Yeah. No, thank you. I think for the, I think I can share this, arising out of this incident, I think we may have to consider in the Constitutional Court making it a requirement that in an application for leave to appeal, the applicant should prominently list all the judges who have had something to do with that matter. And then internally within the Constitutional Court, we could also say the judge who prepares the memorandum that is circulated to all the justices about that application, who tells them what the application is about and so on, should also somewhere first page maybe mention all the judges in the other courts who have had something to do with the matter, so that it's prominent. Because if in the application they don't mention the name of a particular judge, and in the memorandum the judge is not mentioned, but you only see the name of the judge if you go to an annexure, it's possible that these problems could arise. But if we make it a requirement that all the judges who have had something to do from the High Court up, who have had something to do with that matter, their names must be mentioned prominently. That might help to make sure that in future we don't have a situation where somebody takes part in a matter not knowing that it's a matter in which they may have been involved.
I think that would be very helpful, if I may say, CJ.
Yes. Thank you. Commissioner Malema?
Yeah, firstly, I just want to raise a concern with how you chair, because a matter is put on the table, we're still engaging in it, and then you come in as if you are giving a conclusion or a summary of what we had debated, because I would ordinarily expect that you give us an opportunity to engage with the matter, and then from there, you make, especially if there is a candidate before us, so that we don't sound like now we are going against what you are saying. So I wanted to make a follow-up on this matter, that now I would expect, and it's not only for the judge before us, it means that on this matter, all the 11 judges did not see that you sat on this matter, because I'm not a lawyer. I would expect that when an appeal is made, the higher court will want to familiarize itself with who had the matters, what are the issues, and all of that. That's why even in the judgment there, your names are there. So all the 11 judges in the application for leave to appeal, none of them picks up that actually one of the judges who's going to hear this matter has actually had this matter. So more than the judge who appears before us, the whole Constitutional Court sat on this matter. The staff that sat on this matter could not pick up that one of the judges is actually the one who had the matter before. So I've got a very big problem, Chief Justice, with that response. But that is not my question. Now, I've apologized to us. But before you apologize to us and to the nation, you make some sort of remarks which suggest you want to justify that action. Because you say your participation will not have swayed that judgment differently. And that is not our argument. Our argument is, it doesn't matter whether the majority will still have ruled the way they did, but it doesn't help to improve and enhance the image of the judiciary if a person who had this matter before still goes and sits on a higher structure to hear the appeal that he dismissed before. We're not talking swaying here. And once you're talking about it, it doesn't matter, even if I didn't participate, the decision was not going to be different.
That is not the point. The point is the morality of it. It doesn't enhance the image of the judiciary, because remember, it's not about how the judgment goes. Whoever says the judge who dismissed me before went to sit and listen to the same thing and then dismissed me again in the higher court, then the whole of society says, how does this thing work where people can listen to the appeals against themselves? So it's not about which, was it going to be in their favor or not if I had not participated. That is not what we're talking about. And it's about the principle of recusing yourself. It has nothing to do whether, even if I recuse myself, they will still lose. No, it is in the best interest of justice to be seen to be done. Must not only be done. Thank you, CJ.
Thank you, Commissioner Malema. Do you want to say something, Justice Unterholter?
Not really. I don't think it's got anything to do with morality whatsoever. It's got to do with an error which I think most fair people would acknowledge can be made, and as long as it's corrected, there is no harm done.
Thank you. I saw a hand that was up among the commissioners who are attending virtually. I don't know whether there is somebody who wanted to ask something.
My hand, CJ.
Oh, okay. Okay, thank you. Oh, Commissioner Klaba?
So, CJ, so it means now we are assured that if he meets the same matter in heaven, he would not repeat the same mistake.
I'm sorry, just repeat your question.
No, I'm saying it means that we are now assured that even if he meets the same matter up there in heaven, this mistake will not happen again.
Well, I certainly intend seeing what can be done to minimize the chances that it could happen again. Yes. Commissioner Lucas?
Thank you, CJ. I just put it on the record that I don't agree with the statement that Judge Unterhalter made to say no harm done, because we don't know what is the harm that has been done to the applicant. And I agree with Commissioner Malema, justice must be seen to be done. So I can't agree with the statement that said no harm done.
Okay, all right.
Yeah, can I come in on matter? Just a small matter.
Thank you, Chief Justice. I'd raised my hand many times, and it is in relation.
I'm sorry, I didn't see it.
No, don't worry, Chief Justice. It relates to that issue that Commissioner Lucas just raised, because in response to Deputy President Petze's explanation on how these matters are dealt with generally, I seem to recall Justice Unterholter. Good evening, Justice Unterholter.
Good evening.
Justice Unterholter indicated that it's of no consequence, if that's the language I think he used. And now in response, he's said it again, that it causes no harm. My understanding, and I just wanted to ask Justice Unterholter, is that if you are on a panel and one of the members of the panel is conflicted or is disqualified from hearing a matter, does it not contaminate the panel, or does it not have an issue for the applicant? So I just wanted us to be clear. I wasn't sure and wanted you, if you could clarify that for me.
Well,
thank you.
Sorry. I think it's a question that really turns in the following way, which is that these applications for leave to appeal are decided by way of an application on paper where each of the justices indicates their position. There isn't a hearing of the matter. It's not like it's not done as a formal court case where people appear and there's an interaction as to how the matter is conducted. So it doesn't see, when I say that I can't really see where the consequence is, it's because, as I understand it, the position is that each judge that considered the papers indicated their position, and there are 8 justices, apart from myself, who indicated that the application should be dismissed. So I didn't influence any of them to come to the view that they did. They came to their own view. And that's why it's rather different from a court case, which is heard where there are interactions that take place, and you might say that there might be some difficulty that arises. But this is a rather different kind of case, and that's why I'm not minimizing the error. I'm simply saying that each of the justices has given their concurrence in the result, and I'm not certain, therefore, that it makes a difference. But if there is a different view that is taken, that somehow the fact that I gave my concurrence to this outcome makes some difference to the applicant, well, the applicant will now be in a position to raise whatever issue they wish with the Constitutional Court. But I'm not even, I mean, they must do so as they wish. I'm not, as currently advised, I can't precisely see how it makes a difference, but there may be a legal argument that they have to make. And if they wish to do so, they will do so.
Thank you, Commissioner Sepe.
Okay.
Is that Commissioner Malema?
Yes.
Okay, I'll come to you. Let me first go to Commissioner Matolo Zlepu.
Thank you, Chief Justice, and good evening, Judge.
Good evening.
I just seem to recall in your last interview where I think it was a follow-up from my question of how many black female that you trained.
Yes.
And your response was that it's a long list
Yes.
of them, and one of them is Advocate Baloyi.
Yes.
But we have been given a long list here.
Yes.
But to me, there are about 2 of them who are very junior, which I'm not sure whether you trained them before you went to the bench. And the list actually includes male, it's not the long list, that's the impression that you gave me. I wanted to find out, do you still remember really the people that you really empowered?
Yes, I do. As I have the numbers here, there are 24 women on this list, and there are 25 men. And the fact that certain people were very junior doesn't mean that they were not given opportunities. I mean, the key point about the list, and the reason that I've given it to you, is that what matters most for people in the profession and at the bar is that they are given opportunities to come and work in types of cases that they would otherwise simply not get. And traditionally and historically, women practitioners and black practitioners have often been precluded from important lines of work and have just not been given the opportunities that they deserve. And I have certainly sought to work with numbers of people to both give them opportunities to participate in the kinds of work that I did at the bar, and I, in turn, learned a great deal from them as to the things that they could contribute to the cases that we did together. So I don't think that this is a trivial list, and I don't think that my contribution was minimal.
Thank you, Chief Justice.
Thank you. We are at 3 or 4 minutes to 7. I'm just mentioning that because yesterday I think we were trying to say we should try and not go beyond a certain time, which I thought was 6 o'clock. But I know that we are here because of what happened. I just want everyone to know where we are with time. I'm going to go to Commissioner Dodovu, and after that, Commissioner Malema, and then Commissioner Makwanesh. Commissioner Dodovu.
Thank you, CJ. I just want to go straight to the question. I understand that the candidate says this was an error It's a mistake, and it's a genuine mistake. But I want to ask him a direct question. With this judgment of the Concord, don't you think that your presence has blemished it, that it has contaminated this judgment? As straight and simple as that.
Well, my legal answer is that I don't think it has, for the reasons that I've already given. But if the applicant takes a different view, it will make its application to the Constitutional Court.
No, leave the application aside, the applicant aside. The applicant has brought the matter before the Concord. The Concord has issued a judgment where you were involved in the way that it has been explained here. Now, my question is, and let me say my respective view is, this judgment of the Concord, the highest court in the land, has been blemished by the fact that you participated in this particular proceedings. That's all that I'm saying, and I want to hear your response on that.
Yeah, my response is that I don't think it has been. I think that the application was carefully considered by all the judges, other than including myself, but let's deal with the other judges. Each one of the justices gave careful consideration to the matter and arrived at a unanimous conclusion as to how the matter should be dealt with. And so the fact that I should not have added my concurrence to the position taken by the other judges, I don't think in any way means that this is a problematic decision. It is a proper decision rendered after proper consideration by all the judges on the court who should have sat, and the applicant therefore got the hearing and result that the applicant deserved.
Okay, thank you, CJ. During the deliberations, I will definitely deal with this particular matter. If I may analogize, it's like Chiefs playing against Barcelona, and Barcelona has got 10 players, and you say, in any way, Chiefs was going to lose. That's not how it works in my view.
Commissioner
Thanks.
Abdodovu. Commissioner Malema?
No, CJ, I wanted to correct small mistake that the judge committed. He said it's another mistake which is committing right in front of us here. He says he recused himself on a matter involving Department of Education, MEC of Department of Education from Orange Free State. There's no such a province called Orange Free State. These names are changed for a reason. And if a judge just sits there and call a name of a province wrongly like that, it's an exception that it's an issue that we take serious exception from it, some of us, because we value these names. That's why we replace these colonial names. Thank you, CJ.
Thank you. Commissioner Makwanishe?
No, I'm covered.
You are covered. Okay, all right. Commissioner Pillay?
Thank you, Chief Justice. Good evening, Justice Untitled.
Good evening.
Justice Untitled, I did a rough calculation of the matters that you list in your application, and it roughly amounts to about 350 judgments listed in your application. Now, I'd like you to juxtapose that for a second with the list that you've provided us, which sets out the number of Black and Women Council that you've led. And if one had to distill from that list the Black women specifically that you've led, it totals to no more than 7 women.
I have 8, but you may well be right.
Well, let's give you the benefit of the doubt and say it's 8 women. And I really want to hear you on this, Justice Untitled. Are you saying that you're looking at the amount of work that you've managed to get under your belt in the time that you were at the bar, your opportunity for passing on skills to Black women practitioners, the power that you wield in doing so? So, given your reputation, given your demand in the market, you are in one of those very rare situations where you could dictate who you wanted on your matters. I mean, your reputation speaks for itself. And in that context, And with that kind of power that you wield, you literally put up a list of 7 or 8 black women. Most of them, and for those of us that know the names, the one thing that jumps out at you is that most of the women listed, the black women listed, were very junior at the time that you left the bar. So certainly it hints to me that at least 1 or 2 or maybe 3 of them were pupils at the time that you involved them in your work. But it is a cause for concern that there are no senior black women that you've worked with, firstly, despite, and this is the real nub of the issue I want to raise with you, despite the power that you wield.
Yes. I can take the point that you make, which is that looking at this list, the black women on the list are more junior. I'm not sure that I accept the criticism, though, that somehow is a problem. Seems to me that it's much, much more important to give opportunities to those who are starting out and are junior to participate in cases. More senior black women, important as their professional rise is, have more opportunities just by dint of their seniority and the fact that they are established. So I'm not certain at all that the criticism is a fair one, in that one would have thought that some credit would be given for the fact that bringing more junior black women into cases of some importance would actually give people opportunities that they could benefit from, and I think did benefit from. I accept that everybody could be better than they have been, but I'm not certain that you've generated lists of people that from other practitioners of very long standing who've appeared here that rival this list. And I think, frankly, that I took it upon myself at the bar to involve myself with black practitioners and women to a not inconsiderable degree. And I was privileged and happy to do so. And I think if you speak to some of the people on this list, you would learn that they did derive some benefit from their involvement in these cases.
Justice Untitled, I have absolutely no doubt that they did derive benefit. But can I just follow up on your answer? So what you've just said now is where you have worked with black women, it was on the basis of you extending an opportunity to those women.
I think that was certainly the result.
Can I then, the logical consequence of that is that you haven't worked with a black woman junior where you depend and you trust that junior to work with you on a matter. In other words, you rely on the skill and the contribution that the black woman junior brings.
I don't accept that proposition at all. The manner in which I worked, and had I had the pleasure to do so with you, is in an extraordinarily non-hierarchical way, in which I participate and was happy to participate very fully and enjoy the benefit of the skills that practitioners at different levels had to offer. So this wasn't a question of some grace and favor that I was conferring on very junior black practitioners. I enjoyed working with them and enjoyed the skills and benefit of the thoughts that they had to offer and the involvements that they had in the cases that we did together.
Justice Untitled, I represent Advocates for Transformation, so you will appreciate why this is a burning issue for us. I've already put to you what my concerns are about your list and how the names jump out at you and the inferences which those of us who are familiar with the names will draw. Is there anything else you want to add in terms of your selection of black women specifically to work with?
No, all that I have to say is that this was part of what I did in my practice, and I believe that I derived benefits from those that I worked with, and I believe they did too.
Thank you, Chief Justice.
Thank you, Commissioner Pillay. Okay. Commissioner Kane?
Thank you, Chief Justice. Just to follow up on that, Judge, you are aware of the advocacy training program that the bar runs, and I would like you just to describe your role in that regard whilst at the bar and whilst on the bench.
Yes. It was an important part of what I endeavoured to contribute to the life of the bar, both when I was at the bar and thereafter. There are training.
Please just bring the mic closer to you.
I'm sorry.
Yes.
The training is a very, very important part of what the bar offers to both pupils who come to qualify as advocates as well as practitioners who have some standing within the profession. I've always thought training to be a matter of fundamental importance and a way in which practitioners who have some experience can endeavour to assist those who are coming to the bar and those who are at the bar. And so I have, over a very long period of time, worked with pupils in their training, practitioners in their training, and the annual training that takes place at Wallenberg is something of particular importance to me, and it's an intensive period of engagement with junior members of the bar to work with them to augment their skills. And I think that is a fundamental part of what the bar and practitioners can do, and judges can do, to contribute to the excellence of the profession and secure its future, particularly for those who are in respects disadvantaged. And it's often through those contacts and through the training that it provides that they are placed in a position to better their profession and better their performance in the profession. And to the extent that I could do so through work that I did so, and to the extent that training is another channel by which this can be achieved, I worked extensively in that way.
Chief Justice, may I have one more question?
Okay.
Judge, many people listening to you won't understand what Wallenberg is or means. Could you just give some description of your involvement in that particular program?
Yes. So the Wallenberg program is an intensive period of 3 or 4, sometimes 5 days, where practitioners of a certain number of years of experience come down to Stellenbosch, where trainers, some of them members of the bar, some of them drawn from all over the world, and judges work in a very, very intensive way over this period of time with practitioners to hone their skills. And there are particular methods that are done. It's a combination of lectures that are given, talks that are offered, and intensive practical training in respect of concrete problems where practitioners are required to work up problems as they would in real life court situations, and under those simulated conditions, we hone their skills and seek to make sure that they emerge as better practitioners. And one of the gratifying features of that process, which is then replicated in slightly different forms throughout the year, is just to see what enormous benefit practitioners derive from it and how their skills improve, and they are able to deploy them very effectively within the courts that they then go into as practitioners after the training. So it's been a source of both commitment on my part and also a source of considerable happiness that such progress can be made through these concrete efforts.
Thank you, Judge. Thank you, Chief Justice.
Thank you. Commissioner Schlemmer, and then it will be Commissioner Baloyi.
Thank you, Chief Justice. Justice Unterhalter, would you just mind to tell the Commission and the public also the role that you have played at the universities where you were involved in with moot courts, lecturing, etc.?
Yes. Thank you, Commissioner Schlemmer. I have throughout my time at the bar had an extensive involvement with academic institutions, your own institution, WITS, and thereafter with the University of Cape Town. And it's always been a particular pleasure to be involved in the academic world and be involved in the teaching that that has afforded me, both at undergraduate level, but more regularly at master's level. And I have, in that capacity, taught courses and had the pleasure of seeing whole generations of students proceed through the university. The academic world and the academy is a very, very important institution in this country where we not only train people, but they come to form fundamental understandings about law and the significance of law and the contributions they can make. Part of that is through teaching. Part of it is through research and supervising doctoral students, which I've done. And part of it is through, as you've indicated, moot courts, which are done by way of the training that students receive and the exposure that they've done. That's been part of my life for many, many decades, and it's a particular source of pleasure that I have had over the years through that academic contribution.
Thank you. And you have not always been paid for that work, have you?
That is correct.
Thank you, CJ.
Thank you. Commissioner Baloyi.
Thank you, Chair. Good evening, Justice Ntaholta. It's really just mine is just to clarify something arising from what Commissioner Pillay said to you. And specifically, she said that, looking at the list of the black females, yes. Some of us know who they are, and so we know they're junior. I just want to put it to you so that you could confirm. You've been appointed on the bench full-time 2018.
That's correct.
Okay, so you've been there for 3 years, pretty much 3 years, 4 years.
Well, but more than 4 years. 4 years and a term.
Okay. Now, looking at this list, the average age of these black females that you've worked with is about 5 years. I don't know if you know that, but if you start at the bottom, the fourth person would have been in her 5th year, she's left. And then there's Zikalala there, who's in year 5. And there's Ain Simang Ayanda, she's year 6. And then C. Tabata, as you go up that list, she's year 5. And then Muvangua is year 8. So sticking with the year 5s, that generally what it means is that they would have been in their 2nd year of practice by the time you left the bar. Roughly.
I can't.
I know you don't know them so much in terms of how many years they've been there. I'm just putting this to you.
I fully accept that these were people who were starting out their careers as juniors. I completely accept that. Okay. I can't confirm exactly how many years call they would now have. I mean, my recollection is that some of them have rather more years, but you would know that better than I. Yes. Because a number of these people were in my group and they had been there for some time before I went to the bench. But you may have the figures yes. more accurately than I.
Sorry, I'm just making a simple point that if we work on the basis that the number of years that I'm giving are correct,
yes.
you would have worked with them at the tail end of your career at the bar. So in the last 2 years of your career at the bar, because we've established that you are now about year 4 on the bench. Yes. That's all I'm trying to establish with you.
I can go back. I mean, this list has been, it may not even be complete, but I've generated it from the law reports where they appear as my juniors in reported cases. Obviously, there are a great many cases beyond this, and if it was a matter of importance to you, I could, at this rather advanced stage, try and go back and look to see exactly when I was briefed with various people and at what stage. But I accept that these were junior people, and they may well have been towards the end of my period at the bar. But I could go through and look. I mean, for example, some of the cases that they were involved in were certainly considerably before the last couple of years at the bar. And I, because I've derived it from the reported cases, I can give you the cases, the reported cases, and you can satisfy yourself as to when those cases were decided and when they're reflected in the law report.
Yes. No, I'm not asking you to. I was just checking the numbers. If you work off the numbers, their ages as I've given them, am I correct to reflect that if someone is year 5 today, you would have worked with them towards the end of your career at the bar?
That would be true as a matter of arithmetic and logic.
Yes. Thank you, Chief. Thank you, Chief Justice.
Thank you. I think there are no further hands. So at this stage, I want to thank you, Justice Unterholter, for once again availing yourself. I think I had already given you a chance to say something, I think, earlier on, or not?
I don't think so, but...
yeah, if there are 2 or 3 points that you would like the commissioners that you would like to emphasize to the commissioners to take into account as they consider your candidature, I just give you about 3 minutes to emphasize those points.
Yes, thank you for the opportunity. I think I would only make 2 or 3 points. The first of them is that over the period of my career, I have engaged with law in a variety of ways. Mine was never just the narrow path of professional endeavor at the bar. I have, as I've sought to indicate through answering numbers of questions, sought to engage law through the prism of academia, through practice at the bar, through engagements with NGOs, both as a matter of pro bono work, but also through involvements in their work directly, such as CALS. I've also seen work in a whole variety of dimensions, which was done through pro bono work that I committed myself to. And they're not just those that are reported in the law reports, although those I have listed in my CV. I was involved in endeavors to reformulate the National Water Act with then Minister Asmal. I was involved with some of the very early work in respect of what became class actions in respect of the asbestosis claims against GenCor. So I have sought in a whole variety of ways to engage law, both from the perspective of the way in which civil society uses law to pursue the many, many ways in which law can benefit people generally in the country. I've seen it institutionally through acting for various ministers, and so I understand how law is engaged by the executive and the interests that the executive has. I've been involved in institutions and their work such as the Competition Commission and ICASA and the regulatory roles that they've played and how those are reflected in law. And I have, of course, as I've indicated, had a lengthy period of time of involvement in constitutional law, and the Constitutional Court is a place where I would very much wish to serve and very much wish to offer some of the experience that I've had. So that's the first thing I wanted to say. The second thing I just wanted to mention, and this is around innovation within the court system, I was one of the people very much involved in the resuscitation of the commercial court in Gauteng. It's very important, at least as far as I'm concerned, that the court system institutionally develops, that it is responsive to the needs of the country in its different dimensions. One of the things that has happened in this country is that a great deal of commercial litigation has effectively become privatized through private arbitration. There are many virtues that attach to that, but it's equally important that the courts remain places where important commercial decisions, cases come, and where precedents are set, which will be valuable to a country that is seeking to attract investment and where commercial law, amongst many other areas of the law, count significantly. And I think, therefore, that I would endeavor, were I to ultimately be appointed, to keep that sense that The institutions of law are fundamental to the Constitution and the constitutional values that we all savor and consider so fundamental. And I would want to make my contribution to the Constitutional Court, which stands at the apex of a system that ensures that our constitutional values have life and dynamism, and that it is part of a court system that is responsive to the needs of a changing society where there's much to be done, many challenges to meet, and in which the law and its institutions
you have
can
1
play
minute
a
left.
fundamental role.
You have 1 minute left.
I've said my piece. Thank you, Chief Justice.
Yes, thank you very much. Once again, thank you for availing yourself, but you are now excused.
Thank you so much.
Thank you. Shall we go into deliberations immediately, or? Yeah, after the media has left. Yes, the media will leave.